on the rule of law, and I'm very much welcome you. It is a very small circle of people, which is, of course, already not so positive when talking about the rule of law, because it's, we all consider, and you are here because probably also you consider it an important topic, of course. This is unfortunately the situation in Italian universities after the end of May, where we have now the exam period and students think of other things. PhD students usually are abroad, and many other excuses. Colleagues are very busy on conferences elsewhere and so on. But we thought that this was a period where such a conference was first necessary and also possible to organize. And we have opened this we have opened an online channel, so it is possible. The conference is in streaming. This is also important for you in order to understand what you say is, of course, also at least potentially aired to the outside world. However, what we want to do is actually to discuss and to exchange. And this also because, and this is in particular for the speakers, I wrote it to you already, but we want to publish what we discuss here in not tomorrow, not this year, but next year. So this is for tranquilizing you, but also for giving you some incentives in the sense that we today we are a bit tight with the schedule. We have a lot of presentations, but tomorrow we have only one panel, and there's the second half of the morning, which is dedicated also to reflection, to discussion, and we can sink this in. And I think also in English you say the night will bring good advice or something like that. Is this true, David? No, you are not so convinced. Okay, la notte porta consiglio, and in German there's something similar. So sleep on it or something. But the idea is that actually this is a conference where we will hear many interesting and important things, get some ideas, also connect things, and then have also the time or take the time for discussing, as we want to understand the whole picture for preparing also this publication, which will be with a review of Central and Eastern European law, because we thought that this was also for the target in terms of readers, an interesting way of sharing the results from this conference, in particular to the countries we will talk about. The topic of the conference is, of course, the rule of law, resilience and conditionality inside and outside the EU. So the first question is, of course, the rule of law. What is the rule of law? And here the whole definitory question starts, which I won't resolve now and will not even start to discuss. But part of our discussions will, of course, be dedicated to this. It's important that the rule of law, and this we have already talked about individually before, is under threat. We can say, if you look around these days in many countries, maybe too many countries, I would dare to say, democratic backsliding has become a familiar term, unfortunately. Rule of law backsliding, as far as I know, not yet. In Europe, you talk about the rule of law crisis. I would say that both expressions are rather polite euphemisms for deliberate attempts by politicians to weaken the independence of the third branch of power, very often considered to be the least dangerous branch of government, in order to bring it under political control, together, I would dare to say, with many other things, or maybe even everything else. But best before to bring it under control immediately, in order to not have obstacles, no? And this is also, in a way, the question and the function. We have published with Luisa Antonioli and Carlo Ruzza have published a book at the School of International Studies 1 year ago by Springer, Rule of Law in the EU, where it is very much about populism and the rule of law, so the interactions in Europe. Our focus here is, of course, more on the question on the legal issues, and then on the question of enlargements on one hand and what's happening inside the EU and the interactions. The second part of the title, resilience and conditionality, can and how can rule of law be strengthened and made resilient? And this brings us back, of course, to the definition puzzle. So what is exactly the rule of law? Because it's an abstract principle, and of course we all have an idea, but how can this abstract concept and the principle be broken down into something concrete and into concrete elements, which then as a second step might even be better protected? And this is also something. So how can rule of law in a multi-level governance system like the EU based on legal integration be guaranteed? And the other question, which is very much also related to the constitutional core, the question of whether we can still count on a common basis of fundamental constitutional values and the respect of the rule of law as a general principle of primary EU law, because it's a general principle of primary EU law. And then again, from the other side, which are the acts which qualify as violations of the rule of law? Do they need to be systemic attack on the rule of law? And how can these acts, then these violations be sanctioned? And we try to do this in these two half days, looking at the specific geographical scope. As I said, the EU member states, the Western Balkans, and the so-called trio area. And each panel is organized. In the first panel, we have an addition, looking also beyond that to the neighborhood policy. Of course, the enlargement process is a huge challenge because we have these two different geographical areas with different experiences on one hand, but on the other hand, we also have an acceleration due to geopolitical considerations and necessities of this enlargement process, which might even have bring us the question that we might go too fast and forget about sustainability of these enlargements. This will certainly also a point we need to discuss. And then there's the so-called Copenhagen dilemma. Once you are in, what happens? As we all know from the rule of law crisis with regard to Hungary and Poland. So do the same strict benchmarks apply? And we will see whether these are actually strict benchmarks or not. This is another question once you are in. But it's of course also true, if you look back 20, 30 years, there was no real rule of law methodology. This has been developed for the first big enlargements, 2004, 2007, and then refined. Now, rule of law is part of the so-called fundamentals. We will also explore this certainly. So what is of our interest in particular for this special issue of the review, and now also these 2.5 days, is these interrelations and a kind of maybe cross-fertilization between these two processes, the rule of law inside the EU and then the enlargement. So I think the overarching guiding questions are clear. Of course, the focus will be on judicial independence and accountability now in the first panel directly after the keynote speech, and then institutionally, as you have seen, the other two panels on constitutional courts first and on judicial councils, and we will now start with a keynote speech by Professor Hanna Suchocka, which I will briefly introduce. Just let me say before, thank you. Now she's gone, but also in particular to, where is she, Halina? Where's Halina? There's Halina, and also to Simone as co-organizers, because I have taken the floor, but we, the three of us have organized this conference, also to the administrative staff. And also I have to say, I'm happy to bring the, I'm very sorry.
Just to audition for my drug. I said that this, I have a problem.
Yeah, I don't know whether we can.
This windstorm.
Yeah.
For me, I enter here.
Obermann, somebody. I think it's not possible because Simone, you can. Yeah. And if you go to a different, if you go here in the middle, maybe we'll give you a microphone. But this is a bit better. No, exactly. You are directly under. Yeah. If you. If you try to sit here in the middle, we take the chair there.
Sorry, but you have seen that I was quite good.
Yeah.
So stroke air condition.
Yeah, 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 and stream her, and yeah, okay, yeah, we could try. Eh? Abbiamo un'altra aula? Abbiamo un'altra aula? No, 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 please, in the meantime, please go to the first, that you are not here directly under the... See,
I was quite good. Everybody knows when I entered here, yes. But because of some sort of air conditioning, because it's too strong.
It doesn't come here. Remind that we have a funding from this Germonnet module, which is important to say for the rules of the Germonnet module, but we are also very thankful that we have this funding, plus some funding from the faculty. And basically this was it. I'm just waiting whether we see some signals. Again, looking at the situation outside this room, and we have individually already referred to this a bit with regard to the rule of law, I think the best we can probably do in this period is to hope for a new enlightenment. Indeed, in the 18th century, in the Kingdom of Prussia, even without democracy, there was a well-known saying, which probably many of you know, pronounced by a miller vis-à-vis the Prussian king. Your Majesty, there is a judge in Berlin, right?
That we can start, because in that case.
No, I wanted to. No, yes, I wanted to know whether we can find another room. Then we move, and then we don't have to interrupt. This was the purpose of the.
Take the time.
Simone, com'è? Andiamo in aula. Would you go and check, please, whether we're in the next room? It's just here on the other side.
It's here?
Yeah. If you would just see, please, whether this is better, then we will, because we want to listen, of course. It was about the judge in Berlin, which you probably have heard about. And there was a great confidence that this judge, even though there was no democracy, even though this was a monarchy, would sort things out in the way we could say this is the counter-majoritarian function, as we would frame it probably today, of the judiciary. And there was, at that time, at least this is the saying, of course it's a legend, it's an anecdote, there was trust. And I think this will also be something which we will focus on, trust in an independent judiciary, or even more widely framed in an independent control of executive government activities. And of course, this does not cover everything regarding the rule of law concept, but I think this goes to the very core. And this was what I wanted to say. Now we will see how we can sort out. I apologize. It's actually colder here than where you are. Maybe you envy me for that, but of course you have seen that our colleague is not very well, and we absolutely need to respect this also, because we want to listen to what she has to say. So if you can be patient for a second, and maybe 3 seconds, then we will try to sort this out. You have come and that you speak to us. So Professor Hanna Suchocka is probably already well known. She's a Polish politician and lawyer, and most notably for being the first woman to serve as a Prime Minister of Poland in 92-93, and after which she was for many years Minister of Justice in the Republic of Poland. and afterwards an ambassador to the Holy See in Rome. She speaks excellent Italian also. And then afterwards, she became a law professor at the Adam Mickiewicz University of Poznan, where she also shared the constitutional law department. She is a member of the Venice Commission for many, many years, 15 years. She was a full member of the Venice Commission and also the first vice president. And now, since 2016, she's honorary president of the Venice Commission, and we are very, very happy and grateful that she has come here the long way to Trento. Again, my apologies, but we are very, very also curious of what you will tell us because, yeah, we are. No? Yes, we are. We're very, and this is why of course, I'm very pleased to give you the floor, and I'm certain that we will enjoy this keynote speech.
Thank you, Professor. Thank you so much. And first of all, I am very sorry that I make such a lot of, how to say, I don't know how to call it, yes, disorder here. But you know, it is my problem that I have a certain allergy to air condition, which is when it's too strong, yes. And here, when I entered to the saal, I felt suddenly that probably it is exactly a very bad situation for me, for my voice. I don't know why, but since several years I have some problems with my voice, and then when it's too cold is a problem. Sorry, but I try to finish. Maybe I will lose my voice tomorrow, and tomorrow I will not speak. But maybe today it would be possible to finish. So thank you, thank you for the invitation since the beginning. When Dr. Esa Halina asked me if it would be possible to come to Trento, I felt that of course would be pleasure to be here, to come here. I always with pleasure I'm coming to Italy. As you know, I spent several years in Italy, and so it's difficult to say that I'm half Italian, but I like the atmosphere. Even I can say that I liked a certain kind of disorder, but a certain kind, yes, when it's not too cold. So then, and then when it's not warm. So for that reason, it was very nice to come here. And I decided, because as I found that this is a kind of key speech, I decided to say some words on the evolution of the rule of law and the role of the Venice Commission. Because in the first draft, I noticed that somebody else, secretary of the Venice Commission, Simona Granata, was invited to come, but finally she was unable to come now because she's so busy making so many different opinions now and preparing a new draft, a new report on the rule of law, that exactly she was unable to join the conference. And for that reason, I decided and feel myself like being not only professor at the University of Poznan, but also for many years, as you said, a member of the of the Venice Commission. I can say that even probably since the beginning, I was a member of the Venice Commission because I was invited to participate in the work of the Venice Commission even before Poland became a member of the Council of Europe. And I was invited as a co-author of the draft of the new Polish constitutions in 1990. So it was for me exactly a very curious situation when I looked for the reports on Poland, and I found that the first report was a Polish draft of the Polish Constitution, 1990, presented by Hanna Suchocka and Janina Zakrzewska at the Venice Commission. So I thought that I was not sure that my collaboration with the Venice Commission is so long. Now, as you know, this year we will have a big anniversary, 35 years of the Venice Commission in October. It will take place in Venice in October, between 9 and 11 of October. And now what I would like to start to make such a basis for the specific discussions they will be after, yes, during the whole day, this afternoon and tomorrow in the morning. I would like to start with such a quotation from Plato, when he said that where the law is subject to some other authority, it has none of its own, the collapse of state, in my view, he said, is not far off. But if the law is the master of government and the government its slave, then the situation is full of promise and men enjoy all the blessings all the gods shower on a state. These words of the Greek philosopher were the motto of the actions taken by the countries of Central and Eastern Europe just in the beginning of 90s. It was in the beginning of political transformation. We would like exactly to change the situation, that not the law is the hand of politicians, but the politicians are rather in the hands of law. And for that reason, in many countries, in all of the countries, when I read the constitution to make analysis of the constitution, the principle of the rule of law was introduced to the constitution. In Polish case, the principle of the rule of law was introduced to the constitution just in December 1989. It was the first amendment to the constitution done after the June elections in 1989. And the first amendments of the constitution were December 1989. And it was a very situation because I was a rapporteur of the amendments to the constitution then. And we introduced the rule of the state of law, that Poland is a state governed by law. And this formula, which was introduced to the constitutions in 1989, is still, how to say, the same in our new constitution from 1997. Nothing has been changed, the same formulation. So it was exactly so important for us, for all of us. And the reference, as I said, to the rule of law was intended to make a clear distinction, as I said, between the former system, communist system, and the system of rule of law we would like to build. But exactly in the beginning, it was only intention, yes, to build the rule of law. It is not such a how to say, light obligation, yes, to do it. And almost simultaneously with the start of the transformations in 1990, the Council of Europe Commission Democracy through Law was created. And sometimes there is such an impression, and I heard such a question that it was a kind of prophetic to create such a commission. But the commission was not created because of transformation, because the idea proposed by Professor La Pergola was done even before the transformation started, because he, as a very good lawyer, Italians know him very well because he was a personality in the Italian system. He would like to create such an organ which will only make analysis using the legal instrument, yes, not political instrument, but using legal instrument, but to the situation which are in the essence political situation, yes, like building democracy, power, majority, minority, etc., but using only legal instruments. And then it was exactly excellent initiative and excellent instrument which which was very helpful to all countries under transition. As we remember, in the beginning, the Venice Commission was created only for a certain period of time. It was not so sure that it would be established as a permanent organ, yes? But then when transformation started and the new countries tried to build a democratic system, it was obvious that the Venice Commission should become a permanent organ in the system of the Council of Europe. And we can say that the Venice Commission helped the countries under transformation to discover what growing out of the common European legal tradition, but also legal tradition in local tradition in different countries, became a European legal standard. And now what we discuss, it is a problem, it is a question on a European legal standard. What does it mean? What is a European legal standard? Last year, we organized in Gdańsk, it was organized also by myself, because I chaired the special chair on the constitutional law. We organized a conference in Gdańsk with the participation of Venice Commission, what does mean legal standard contemporary, yes, what it is. It was also a book published, I gave yesterday the book to Halina, maybe tomorrow he will show you that the book exists. Many lawyers, important, wrote papers to this book. And rule of law, as we said, was a crucial value then. But over time, however, this thinking, we had an impression, has changed, yes? And then when there's such a period that the new democracies try to look for a different interpretation of a rule of law, yes? What does mean? And notwithstanding the active role of the Venice Commission, concepts have started to emerge about the misunderstanding of the rule of law in individual countries. There is no doubt that if a system of the rule of law based on European values is broken in any member state, this is tantamount to a collapse of the rule of law through the European system. This is not only the internal matter for the particular member state, it is a problem of the whole European system, which can only function if all member states fully respect the principle enshrined in the treaties. And now this is the discussion which is going on this issue. And the clear first symptom of a danger of, we can say, a kind of decline of the rule of law. We can use the different name as Professor used it, the opening speech, the crisis, the Wechsleit, etc., yes. But the things, first symptoms were very clear in 2010, yes, with Hungary. Because the Hungary was also a democratic state, which a very, very strong, how to say, even such a feeling of democracy. I remember very well when I was prime minister, we have a very excellent cooperation with Prime Minister Antal. He was a hero in Hungary, and he also would like to build a strong Hungary, but inside of Europe, yes, not outside of Europe. And then we noticed that we had a year 2010, and then with the amendments to the fundamental law of Hungary, some elements start to change, yes, especially the role of Constitution Court was limited, different meaning of the standard of judicial independence. And in that time, Venice Commission decided, but it was also, how to say, the Council of Europe idea, that it should be prepared a special report on the rule of law to analyze and to present what the rule of law means, what are the different meanings, and what the different names for rule of law, how different names could be interpreted. What does mean the rule of law in English system and in system of when the rule of law is coming from the court cell, when in German system, it's a different meaning in France. And in this report, Venice Commission would like to make such an, how to say, image and exactly good analysis what element are important for the rule of law. And as somebody once said, this is very quotation which I like very much, that rule of law is not just one dish, it's a whole kitchen with the different dishes, yes? And the different elements are, how to say, part of the rule of law. And the first report of the Venice Commission was published in 2011. And you know, it was only 5 years past when the Venice Commission analyzed that probably the report from 2011 is too short, is too general, that we need much more concrete instrument in the hands as a Venice Commission to analyze and to make control, to prepare opinions on different states, on the laws, amendment to the constitution, especially on the judiciary in different countries. And so for that reason, the new report was adopted, and this new report was called Checklist on the Rule of Law. the checklist as an important element, because then there are specific points which should be taken into account when the analysis of the law and amendment to the law in different countries is done. And the report was intended to be an instrument to assist, as I said, in the control of the rule of law in different countries, to avoid this kind of accusation that Venice Commission is using different instruments. There are different instruments using to the Western countries, Western democracies, and different instruments using to so-called new democracies. So the new report with the benchmarks and the special concrete points was such an instrument which is always taken into account when we make the opinion in the Venice Commission. And of course, one of the crucial issues, as I said, was to make analysis, especially three important areas, but there are also many areas, but three are of the great importance. Making law procedure, because it is a first problem, judiciary, and constitutional justice. Yes, it is exactly three areas of great importance. And but of course, also when the Venice Commission prepared the report, we can hear also such voices that the Venice Commission would like to make a certain pressure for the countries. But the Venice Commission always make a distinctions in making opinions between two subjects, namely, what constitutes the foundation, the basis of European democracies, what is a crucial element which absolutely must be respected by all member countries, that's the European standard, and then, which is a very delicate sphere, but it is typical also for the Council of Europe, what is a part of each country's regulatory freedom resulting from its diverse tradition and culture. And this point is very difficult, yes, because we can find in different countries as well positive as well negative tradition. For example, we discussed also with Halina that sometimes in some, here we will discuss also this issue, in some Eastern European countries, the kind of corruption, yes, is taken as a local tradition. But you know, it is a negative local tradition, and this kind of tradition should not be taken into account when we would like to build European standard. But for example, there is a different area, family life, morality, and here is a question how far we can leave this sphere for individual countries to regulate the issue, yes, because they are two completely different situations, and for that reason, in the Council of Europe, we have such an institution like margin of appreciations, which now is also introduced to the preamble of the European Convention of Human Rights. Yes, after so many years, it was elaborated as a result of the judiciary, but now it's a part of the law. So it should be also taken into account that Venice Commission always analyze very detailed the concrete situation in different countries. But despite on the, how to say, the whole situation, last year, 2024, the Venice Commission decided to prepare a new report. A new report is a kind of consequence of the Reykjavik summit in 2023, when the special declaration, as we know, was also adopted on the rule of law and guarantees of the rule of law. And now the Venice Commission is in the process of making new report. Till now, we have draft, 53 pages draft. Exactly, it is a discussion between us, how and what kind of elements should be introduced to the new draft. It is also done a proposal that at the beginning should be such an introduction, or maybe it's the first chapter, which would be called a restitution of the rule of law. Because now we can observe in many countries First, I mentioned here it was Hungary, but then in 2015 it was also Poland and some other countries, when especially the problem of constitutional justice and judiciary is a very weak point, and we have a real crisis of rule of law. So for that reason, the discussion is going in this direction, whether we need such a special chapter in this report on the restitution of rule of law. Because as I said before, we elaborated during the whole year, the many years, standards of the rule of law. But we don't have till now the standards how to restore the rule of law, yes, when it's, when it's destroyed. And what kind of mechanism could we use when we would like to restore and to, I don't know, to be back, to use the same instrument as well used in the process of destroying, or maybe we should find other weapons, I don't know, our instruments. It is not so easy. And now we have the problem in Poland with the situation of the new judges and the new constitutional court. What kind of instrument we can use when we would like to restore the situation? And now, as I said, the problem which will be here discussed, I notice, is a problem how the process of appointment of judges should be regulated. Because it is one judges, first ordinary judges, and then also constitutional judges. The problem of appointment of ordinary judges, and how far and what should be the role of National Council of Judiciary? It will be a special report, yes, on the National Council of Judiciary here today or tomorrow, I will notice. You know, it's in the beginning of our work in Poland on the new law on judiciary. We are not so sure if we had to introduce the National Council of Judiciary. It was just in the beginning. But then finally, in December, just in December 1989, together with the principle of the rule of law, we also introduced to our system National Council of Judiciary. We are probably the first country after Italy and Spain with a tradition for the Council of Judiciary, but we introduced to the Polish system. But the question still arises. It is a European standard to have a National Council of Judiciary or not, because in Germany, it is not so, yes. We had a very difficult discussion with Professor Hoffmann-Riem when he said, one would like to create the National Council of Judiciary as a European standard. We have a good system of appointing of judges, and we don't have National Council of Judiciary. So we have to discuss, it is a European standard or not. I think that in the beginning of transformation, Council of Europe and Venice Commission was not so far in favor of making a pressure to create a National Council of Judiciary. But now the situation has changed, I think. And now the Venice Commission proposed that the National Council of Judiciary should be created also in countries where till now the council did not exist. One of the most difficult problems was, for example, the Venice Commission opinion on the Holland. We made an opinion on the judiciary in Holland, and everybody asked, why you make the opinion? Because now the judiciary in Holland is working well and we have no problems. But Venice Commission argued, but it was after this decision of the Council of Europe Parliamentary Assembly, yes, asked the Venice Commission to make the opinion. Venice Commission said that we had countries, for example, like Poland, that everything was well. But once politicians came to power, and then would like to change everything. So now we have to have a good instrument which are rooted in the law. And then the second question, Professor, you have to say me when I have to finish, because I don't know how long I'm speaking. We lost the time completely. Yes, so I see. Okay, I will be finishing. And then, you know, it is the only one problem which I would like to raise here. But then there's also a problem of constitutional justice. It was also, as we know it, the rule of law, which are now the report on the checklist of the rule of law, in the chapter which is devoted to the constitutional justice, it is such a formulation that Venice Commission recommends the establishment of the Constitutional Court or equivalent body, but it is also written that Constitutional Court control, if applicable, yes, so it is such a condition, if applicable. And I can say that the new draft, we propose to delete the word if applicable. So it means that the constitutional control should be introduced. But now is a question, what kind of constitutional control, yes? Should be the centralized or maybe more deconcentrated constitutional court control. It is a problem which we can call much broader, politics and judiciary, because now the two terms, or maybe two areas, are strictly strongly connected. Because, for example, now, in different situations, especially when we analyze the relationships between European law and internal law, the constitutional courts, the courts, enter very often in the role of politicians, yes, because the Constitutional Court decides that such a law should be binding, valid in the country or not, yes. It is not only the role of the politicians. So for that reason, the situation of judges and how we call the activism, judicial activism, is one of crucial point. But it is also even more complicated, for example, in such a country like Poland now, when the Constitutional Court is completely taking but one political power. And how we can make the constitutional control now. And for that reason, now we decided, and there is such a discussion, political discussion between specialists in constitutional law, that the individual judges can also analyze the law which is in line with the Constitution. In case when in the concrete decision, judge is convinced that the law is not in line with the Constitution, he can, how to say, make decision directly on the Constitution, not on the law. He can omit the provisions of the law. You know, it is now accepted in the system, but this provision of law, of course, remain in the system. It is still part of the system, because it is not the Constitutional Court who decided that the provision should be, how to say, deleted, using the internet term, from the system. So it is one of the crucial issue discussed now. It opens a new way for judicial activists, individual judge. And now it's a question whether all judges are prepared to make such a control, yes. But it is the kind of this deconcentrated control. In Polish case, we have the article in the Constitution which says that judges, within the exercise of their office, shall be independent and subject only to the Constitution and statutes. Putting that only to the Constitution and statutes opens the question, what in the case when judges of the opinion that statutes is not coherent to the Constitution? What should he or she does, yes? And for that reason, before it was such a rule that the judge in such a case should send the question to the Constitutional Court, yes? But now, when we don't believe to the Constitutional Court, which Constitutional Court is not such a fully independent body, but rather political body, the answer is that it opens way to judge to decide directly on the Constitution, omitting, as I said, law. But it is still for the discussion. We don't know how the situation will develop in the future. And as I see here, it's also even the new problem concerning the relationships between, as I said, as I mentioned at the beginning, between domestic law and European law. Here, in this area, it is often no longer, as I said, the legislator, but the judge are the main adjudicators in case of conflict, especially when it's a case of conflict. The European Court in Luxembourg that plays a key role in the interpretation process of current European law, but then, as concerns the internal law, it should be a constitutional court. And the question which we can call here is the question of so-called last word, yes? Who has last word in such a conflict? We discuss now, and I think that we have a very good young specialist in the constitutional law. They are of the opinion that we should not recall here and agree on the last word, but we rather should look for the, how to say, not conflict, looking not for conflict, but looking for the real solution, and should be not last word, but meeting cooperation, how we can find this problem. And as we know, it was also proposals done by Joseph Weiler, who in one of his articles proposed to create a special kind of chamber of council who will be over the both European court and local court to try to solve the conflict existing between both bodies. But it was of course only a proposal and not accepted by other countries. But I only would like to exactly to call some, or maybe to put on the tape some problems which we meet now. And as Halmai in Hungary, he said that the backslide in the rule of law now occurred through the misuse of constitutional instrument, called sometimes abusive constitution tools, such as often constitution amendments in countries when the ruling party has a conditional majority, constitutional majority, yes? And then they make the negative interpretation done by constitutional court introduced to the constitution. And this is a problem of a certain abusive, I don't know, constitutionalists, how we can code it. And as all we know, that Löwenstein wrote that the history of the constitutionalists is nothing other than the political man's search for the limits of absolute authority by its bearers and his endeavor to establish a spiritually, morally, and ethically justified authority in place of the blind subordination of the absolutism of existing supremacy. It is very coherent with what I quoted at the beginning, Plato said. But the question arises, to what extent the words of Levenstein are currently a motive for politicians? Or maybe they are looking only for the extreme majoritarianism, and when they have majority, they are ready to introduce all provisions which will guarantee them the power for forever. There are also a question, yes. And going to the end, because I think that we have a very interesting discussion, very interesting papers. I only, as I said, put some problems on the table. In 2018, in one of his interviews, the former president of the German Constitutional Court said that the democratic rule of law is well known to us, but is it not something obvious? It was a very pessimistic view. And now I would like to put the question, do we share the pessimistic view, or maybe we'll be able to find instruments to overpass this view? And the Venice Commission proposals to make a new report is also one of such steps. And I think that we'll have also possibility in different cells to discuss much more on the new report to make it exactly a very good and efficient instrument in looking to reestablish a rule of law in different countries. Thank you, Professor, so much. And I think
Thank you so much, Professor Suchocka. I think you gave a very broad overview, which is linked to the experience of the Venice Commission and also reminding us of the instruments the Venice Commission has provided, but also the very concrete examples on how to restore the rule of law and the problem of decentralized control when you have a constitutional court which is compromised and captured is, of course, a very important reminder also of the consequences. So without further ado, I would pass the floor to, thank you again. I would pass the floor to the new panel, which I invite. Sì, 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 sì.
Finally ready. This is a fairly cumbersome procedure today, but we're going to get to the end. So I'm Luisa Antonioli, and I teach here at the Faculty of Law at the School of International Studies. I'm a private lawyer as a formation, but we've been working a lot on EU law. And as Jens said, at the School of International Studies, we prepared a conference and then a book on the rule of law and populism. So there's some relation with what we're going to analyze today. Now, the first panel is called The Rule of Law Methodology as a result of the reciprocal influence of the rule of law crisis and rule of law conditionality. So here we have rule of law, which is, of course, the definition, the starting point. But then we have the issue of crisis and the issue of conditionality, which are two elements that are typical of the current moment. Because right now, I mean, when I was thinking about today, the sheer idea of having a whole conference on the rule of law and then you walk out and read the newspaper and turn on the TV and you have a sense that we are somehow speaking about something that is lurking in the sky, but not getting any hold on the ground. So crisis is definitely the word that we are experiencing on a number of issues, and rule of law is definitely there. So this panel is particularly interesting because it is analyzing what the crisis has meant for the EU and also what kind of link there are with bordering areas which are strictly connected to the European Union territory, either because they are prospective states, member states, or because they have a close link. So I think that's a defining point both for the EU and for the external side to it. From the point of view of methodology, I think what is coming out is the variety of instruments that are out there, which are partly due to the fact that there's no such a thing as a one-size-fits-all. So you have to get instruments that are tailored for the reality. And at the same time, we just heard it from the main speech, that we need to have some commonality. particularly inside the European Union, in spite of the fact that we know that the national member states are different, we need to find some common elements that can be assessed as being the minimal threshold. We just heard about Poland, about Hungary, but it's not just about that. It's about a more general item of how much difference can we tolerate or how much uniformity do we need. So without further comments on that, I'm very happy to start with Cristina Fasone. She is Associate Professor of Comparative Public Law at the LUISS University in Rome and is directing the program on politics, philosophy, and economics. Is holder of a Jean Monnet module and is going to speak about the rule of law in the European Union. So you have the floor. Thank you.
Thanks very much. Thanks to the organizer for the kind invitation. And I'm going to focus on specific instruments dealing with the rule of law crisis inside EU, spending conditions in particular, because conditionality is quite broad, is often related to spending, but is not necessarily so. And I will try to see what the EU has done, so the array of instruments that the EU has been using, especially inside EU, so starting from the rule of law backsliding onward, although the EU has used various tools even before. I will be quite, I think, quick in highlighting conditionality as a governance tool. It has been deployed in a variety of different contexts, international organization, especially when providing financial assistance to the country needs. It's also a very frequently used tool in federal countries. I think what makes this context very different is also the enforcement of conditionality, the level of mutual trust between the parties. We tend to see that this is very low when it comes to IMF providing for financial assistance. We may expect to have a higher level of mutual trust in fully fledged federation. Canada is a good example. Maybe the US in the present context is a bit more problematic. But in any event, there are a number of open questions that relates to conditional spending, effectiveness, how we design these spending conditions is meant to be negative, positive conditionality, so rewarding mechanism. Is it going to be implemented ex ante or ex post? Are there horizontal condition or thematic condition? Strict conditionality, which we have also experienced within the EU, or a more lenient approach in the enforcement, and problem of legality and legitimacy. Legality also in relation to problems of competence creep, because conditional spending can be used to trump the formal architecture of competencies between different levels of government. There are also some problems of legitimacy insofar as conditionality may help making the locus of responsibility a bit more blurred, as long as the process is formally negotiated, and problems of accountability and transparency, which we have also witnessed, I think, inside EU. Problem also of discretion, if not arbitrariness, as for the rationale for taking a specific decision. And there are, of course, advantages and disadvantages in using these tools. Advantages are often referred to certain level of uniformity or, if not unity, in terms of public goods or enjoyment of fundamental rights. Conditionality is meant to be a bit more cooperative as a tool compared to top-down traditional mechanism of law enforcement. But there are also drawbacks, as I said before, encroachment of competencies, under strict conditionality, severe limitation of especially social rights, and problem in the chains of accountability. Now, coming to the EU, because I don't have much time, conditionality spending conditions were first used outside, so in the relationship between the EU and the outside world, in a number of international agreements with third countries, so in the EU external action. And the mechanism was gradually imported in the accession process and inside the EU, especially since the 1990s in cohesion policy. When it comes to accession, we see conditionality widely employed in the eastward enlargement. That was not really the case for the previous enlargements. So it's fairly new also in the enlargement strategy. And many scholars have been very critical in the way, especially political conditionality, so the compliance with those of the Copenhagen criteria dealing with democracy, competition, electoral competition, but also rule of law standards have been applied. Whereas many consider it a bit more straightforward when it comes to approximation to the acquis communautaire on the internal market, for example, rules. I think a big turning point in the use of spending conditions in general was the Eurozone crisis, which was unfolding gradually while the rule of law crisis that was mentioned before, so starting from Hungary 2010, was also starting to provide the first symptoms and signals. The Eurozone crisis witnessed the resort to EU, but mostly non-formally EU law measures, dealing also with spending conditions, particularly with the country that asked for financial assistance through specific funds. And we had a seal by also the Court of Justice of the European Union on the use of strict conditionality, which we have now enshrined also into the treaties. That, I think, needed to be digested and created a lot of also tensions and problems in the way the EU itself abide by rule of law standards in the way financial assistance was provided. Now, from that on, I think the EU has tried to learn something from the management of the Eurozone crisis in terms of what should be avoided. And we see that conditionality, not maybe necessarily spending conditions, have made their way through a variety of different instruments in EU law, including the European semester through country-specific recommendations, many of which now refer directly or indirectly to rule of law reforms. So they are not strictly or directly connected to budget, to sustainability, but they are seen as instrumental to it. And so the European Commission pays attention to those elements. We also need to evaluate that the EU budget is fairly small, is limited in its capacity. And the legal basis had to be a bit overstretched, which triggered a lot of discussion as well, in order to expand the possibility to use conditional spending. And this has been quite clear with the Next Generation EU, so with EU response to the pandemic. The IRRF and other instruments were adopted in the aftermath of the pandemic. And I think we have witnessed a sort of normalization of conditionality spending conditions in particular, trying to link the implementation of the EU budget to the traditional functions that budget are meant to perform: allocation, stabilization, and a little bit of redistribution. The European semester, once again, but also the Common Provision Regulation, the new version of 2020, but we had the first signals already in 2013, have tried to somehow link the implementation and execution of the EU budget to the rule of law. Now, many scholars have also talked about the new planning method of government or integration through funding in the EU, which is probably going to stay with us regardless of the limited time frame of the IRRF. There is a lot of prescription for performance-based plans with negative or positive conditionality tools attached to several policy areas, that some of which, also if we read the National Recovery Resilience Plans, are sometimes beyond the formal competencies of the EU. They deal with institutions, they deal with judicial reforms, with independent authorities. So this is to some extent the state of the art. And now I jump to the rule of law, and the rule of law being a target of conditional spending. We have this nice Article 2 with a lot of values, among which there is also the rule of law. And a lot of scholars have elaborated on the nature of these values. Are they principle? Are they values? Are they directly enforceable? Can they be, for example, used as standalone legal basis for infringement? We now have Commissions versus Hungary, the Advocate General, that seems to be positive on that point. And when we see also the definition of the rule of law that is emerging in the EU, we can see that it actually overlaps a little bit with some of the other values, including non-discrimination, equality, freedom, and protection of minorities. So the question is open: how do we cope with all those values, and how we operationalize the rule of law? A lot of focus has been put on the rule of law conditionality regulation, which is Regulation 2020-2092. The initial proposal goes back to 2018. It has been significantly watered down, we know, in order to be accepted, and it's now very closely connected to the protection of due financial interest. I think indeed that there are more powerful tools in terms of conditional spending than this rule of law conditionality regulation. For example, the horizontal enabling condition of the Charter of Fundamental Rights under the Common Provision Regulation, and as long as it stays with us, also the IRRF regulation, for example. I'm saying this because some scholars have pointed out about the importance of the other instruments, but a lot of also institutional discussion has been focused on the rule of law conditionality, which is not necessarily a panacea, I think. Now we have a nice definition of the rule of law enshrined in Article 2 of the rule of law conditionality regulation, which is the consequence of the case law of the Court of Justice. So it was not drafted overnight, of course. It also relies on the common constitutional traditions of the member state. And it's, I think, a starting point already. It refers to legality, to the lawmaking process. So this is the kitchen we have in the European Union. Legal certainty, prohibition of arbitrariness, but also separation of powers. Yet, when it comes to the rule of law conditionality regulation, all these descriptions should be fine-tuned with a limited scope of application, which is referred to the sound financial management of the European Union and the protection of European financial interests, which explains why it has been used just once. There are a number of other instruments within the rule of law toolbox, and I think also the Court of Justice made a plea for an integrated and combined approach of all these instruments, and the rule of law conditionality regulation is just a subsidiary tool, as for it is described by these twin judgments of the Court of Justice. We need to do a comparative evaluation of the effectiveness of these various instruments to see whether the rule of law conditionality regulation is the most suitable tool to be used. And there are different schools of thoughts on the use of spending conditions. We have some scholars that are a bit cautious in their approach, saying that after all, we are trading money for values. So we should bear this in mind when using spending condition in the context of the rule of law protection. Other scholars instead have a more clear-cut approach, at times even a bit aggressive in the way they are asking for a more systematic interpretation of the various tools, because clientelism in various member states could sediment thanks to EU funds as well. Thanks. I think the Court of Justice has advanced a lot our elaboration on the rule of law in the context of the EU, also drawing and linking the rule of law to the enforcement of the EU budget, to a basic level of mutual trust in order to ensure solidarity in the use of the budget. And I think this is something that to some extent upgrade the constitutional tone of our discussion on spending conditions, which otherwise we can hardly connect it to values. And certainly the protection of the rule of law is a basic condition for the enjoyment of all the rights and benefits that stem from the membership of the European Union. We know how it went. Hungary and Poland were not really happy with this regulation. Indeed, this case law stemmed from action for annulment. They were also contesting on the ground of constitutional identity the very meaning of the rule of law, but the decision of the Court of Justice was clear, I think. We waited also for the guidelines of the European Commission to have the regulation finally enforced. And the first only enforcement was against Hungary. Also for the lack of commitment, not only capacity to implement the 17 corrective measures that were negotiated with the Commission, including the setting up of the Integrity Authority that in the end has been set up, but is always complaining for the lack of institutional cooperation and the lack of resources. Now, if we look at Hungary in comparison to Poland, we see that both have been subject to the enforcement of the horizontal enabling conditions under the Common Provision Regulation, and also Cyprus was subject to it. I would say that the punishment for Hungary was much more significant under the Common Provision Regulation than under the Rule of Law Conditionality Regulation. But we also know that the decision was eventually partly lifted, so partly unfreezing of the funds in exchange for the midterm revision of the IMF and the approval of the Ukraine facility for the sake of reaching unanimity. The European Parliament challenged this decision. The case is currently pending, but I don't think it's going much to concrete result. And it's interesting that under the Common Provision Regulation, various violations of the charters were of the articles of the charter were highlighted, ranging from human dignity, academic freedom, right to asylum, and more. Against Poland, instead, we had the enforcement of the charter enabling condition on the right to asylum and effective legal remedies. We had, however, the approval of the National Recovery Resilience Plans that was even before the actual spending was carried out, subject to action for annulment. The situation changed politically with the election in October 2023 and appointment of the new government, and we had indeed the implementation of the National Recovery Plan and installment paid, even without concrete reforms put in place, because we just had a very important action plan put forward by the Minister of Justice, but with no effective legal measure enforced. Can we talk then of double standards if we compare Poland and Hungary, well, probably yes and no, but the political context was very different and the commitment was very different. Yet, I think that the decision of the Commission was very poorly based when we look at the implementing decision. And we know almost nothing about the negotiation, of course. What's next after the 2025 presidential elections then? Because there was a high hope that with the president more closer to the government, a lot of reforms could be carried out, which doesn't seem to be the case. That open question. Concluding, sorry for being too long. I just want to put emphasis on the variety of spending conditions that the EU can deploy in the case of rule of law problems, if it wants. And the implementation has been, however, somehow critical for the lack of transparency, for the for not being easily traceable to the competence of the EU at stake in any specific decision. There has been a lot of allegation about competence creep for the European Union, also in the adoption of the IRF, and in the fact that we are talking of national plans after all. So I think we need to really reflect more on the constitutional implication of spending conditionality, also on the protection of final beneficiaries. Particularly, I'm thinking here of the universities in Hungary, for example. And there is a little bit of problem with the legal certainty and predictability on how the decisions are eventually taken, and on the democratic and parliamentary control of spending condition and conditionality mechanism in general. Thanks for your attention.
Thank you very much. I know it's I'm having a tough position as a chair. Okay, so now we have a first description of the instruments that are available within the European Union, the advantages and limits, and we now zoom out to the Western Balkans. Do you need to? Okay. So let me just introduce briefly Jovana Marovic. She has a PhD from the Faculty of Political Science at the University of Belgrade and is the former Deputy Prime Minister and Minister of European Affairs of Montenegro. And she also served as an advisor on EU affairs at the Ministry of Foreign Affairs of Montenegro. And she was also a fellow at the University of Graz with several research projects. So you now have the floor. Thank you.
Thank you very much, and thank you for inviting me here. It's really a pleasure to share even less optimistic picture of the rule of law when it comes to the Western Balkans. But I have to say, even though I'm back to academy, and these kind of conclusions and kind of recommendations are mainly based on my practical experience being in the government, but also in the think tank community and doing the research on the rule of law conditionality for more than 10 years. I have to say that when it comes to conditionality, the Western Balkan countries there is a bit different conditionality comparing to the countries of the Central and Eastern Europe, because with the Western Balkans, the European Union started the stabilization and association agreements, which are different from the European agreements concluded with the countries of the Central and Eastern Europe. So that there was a conclusion that for the Western Balkans, there is a need first for the stabilization and then for the association. The membership for the Western Balkan countries was promised in Thessaloniki 22 years ago. And since then, only Croatia actually joined the European Union, and Croatia is still refusing to be part of the Western Balkans. So none of the Western Balkan countries actually joined the European Union since Thessaloniki promise. The new conditionality or the new approach started with Montenegro 13 years ago. And the single chapter on the rule of law, which was applied to Croatia, was actually split in two, with chapter 23 dealing with fundamentals and human rights. basic human rights, and the second one went the fourth chapter 24, which is dealing with the justice and security. And then the European Commission introduced the non-papers, a semi-annual obligation from the European Commission to inform and to report to the Council what is the progress when it comes to the rule of law. The rule of law are the chapters which are now first to be opened and the last to be closed. Just to remind you that Croatia opened the chapter 23 dealing with the rule of law at the very end of the negotiation. So it needed just 1 year actually to improve everything which Montenegro is now improving for 13 years. Then with Montenegro, European Commission introduced the interim benchmarks, and the Montenegro is the first country actually to receive the interim benchmark assessment report since opening of negotiations with Montenegro. The European Commission only applied opening benchmarks and the closing benchmarks. Opening benchmarks are usually just kind of recommendations how to adopt certain action plans and how to improve the state of rule of law within these conditions which are defined by the European Commission. And closing benchmarks are usually, let's say, a long-term recommendations which cannot be fulfilled over the night. So that's why the idea of having and opening the chapters 23 and 24 at the very beginning is for the European Commission to have more time for monitoring and not to actually have another Romania and Bulgaria into the European Union. And we are still like repeating all over again the cases of Romania and Bulgaria. But to be quite honest, I have to say that it's better to have countries unprepared in the European Union and not to leave them outside forever. Because I have to say that it's quite obvious that situation in Romania and Bulgaria, it's much better compared to 2007 when they joined the European Union. And you're comparing situation in the Western Balkans, like 15 years ago or 20 years ago, it's almost the same situation because conditionality is not applied very well when it comes to the Western Balkans. Why it is so? Because there is this theory of stabilocracy that the European Union for a long period of time actually put the stability before the conditionality and before the rule of law. And actually I have to say that, there is no stability if there is no rule of law. And you cannot prevent, country from backsliding or for keeping the status quo when it comes to the rule of law if you are not applying conditionality well. And the second thing is that even though the motto of this new methodology, which was revised just a few years ago, fundamentals first, it's not about fundamentals first. I have to say that even the European Union, European Commission are now applying interests first and not fundamentals first. And I will show you how when it comes to the Western Balkans, how it is going in practice. Then in that way, you are turning blind eye on serious corruption scandals and violation of the human rights because you have some interest in some of the countries. And most obvious case of Serbia with the lithium deal which was recently concluded between the European Union as this general framework agreement and also with Germany and Serbia on lithium. And in that way, they are even praising the reforms in Serbia, and people in Serbia are protesting because of the rule of law issues for almost 1 year. So basically, this is how you are not applying conditionality in practice. Then there is undermining or marginalizing the role of the civil society in the Western Balkans. Because, for example, there was opening a benchmark in the case of Montenegro that the government has to improve a cooperation between civil society and government itself. And there were some improvements when it comes to procedures, when it comes to transparency, when it comes to many other issues. But now, when Montenegro received actually closing benchmarks for the rule of law chapters, there is no this condition anymore. And then by putting pressure on authorities in Montenegro to adopt strategies and laws, many procedures are now shortened without consultation with civil society. So it's kind of paradox that when you are moving closer to the European Union, that the role of civil society becomes less important. And European Commission actually is giving green light to it. Trying to use some methodology or some scores or data, what is the state of the rule of law in the Western Balkans. The recent report from the Freedom House, Freedom in the World, the scores for the Western Balkan countries, there is no country which is free. And there are, of course, systematic issues in all the Western Balkan countries. But when you are comparing the countries among themselves, the best score has Montenegro, and Montenegro is surely front runner and the closest to the European Union. But the difference between the score in Montenegro, which is 69, and Bosnia, which is the country with the worst score, is between 69 and 52, and they're basically, we are sharing the same issues and same problems, no matter in which stage of negotiations we are. And these problems are really politicized judiciary and corruption, which is systematic. And then, party employment, the main party, which is controlling basically everything in the country. So I think that, even though, for example, 3 countries are negotiating for membership and Kosovo is without candidate status, all countries are sharing the same problems. Same apply when it comes to the EU country reports, because just using some of the country reports 10 years ago and the latest country reports from the European Commission, there is one sentence in for example, a country report for Montenegro, which is repeating and which is there for 10 years, that corruption is the systematic issue and a serious reason for concern. This kind of wording is really problematic in my opinion, because if you want to improve things, you have to be really, really concrete when it comes to problems. So I think that credibility really requires consistency, that the same rhetoric is coming from the European Commission and the EU member states and also from the Council, because now there is different dynamics in the EU integration process of the Western Balkans, and it started with the end of mandate of the previous European Commission, and now you have kind of pressure on Albania and Montenegro as front runners to open and to close chapters, but the pressure and the focus is still on laws and strategies and not on implementation. So how, for example, our government and our parliamentary majority see the reform and the strengthening independence of the judiciary, they see it just as a replacement of one political influence over the other one. So how to explain it? At the very beginning of negotiations, we changed the constitution in order to have 2/3 majority in the parliament for important appointments in the judiciary, for judges, for prosecutors, and for the Supreme State Prosecutor. And it was really difficult to achieve it because Montenegro is a polarized country, and this same applies in all other Western Balkan countries. It's not easy to have consensus on important appointments and important reforms when it comes to judiciary. But for example, during the last year, we the Supreme State Prosecutor was appointed, and he had almost all the political parties voted for him, And instead of have independence and the integrity over there because all political parties voted for him, he is now silent because he has feeling that he owns this to all political parties in the parliament. And that's, in my opinion, the most problematic thing, because when the changes, even when the changes are happening, you know, it's kind of trade between political parties. You can take this judge or this prosecutor, and we will take another one in order to have you, like, you know, balance in the Judiciary Council. And I think that you know, when the war in Ukraine started, I think that the European Commission and European Union should have had different reaction when it comes to the candidate countries and countries outside of the European Union. And the response when it comes to the Western Balkans, it was the growth plan. The growth plan is still more focused on economy than on the rule of law. And I think that condition for the first time with the revised methodology, which was introduced back in 2020, for the first time, the European Commission has actually tool to apply sanctions and rewards to the Western Balkans. And now with the growth plan, these sanctions and rewards are connected with the money and with funds. But the way the European Commission is applying it is completely wrong, because, as I said, focus is still on economy and not on the rule of law. I think that, for example, you cannot give the most of the money to Serbia, which is not fully harmonized with the common foreign and security policy of the European Union, and to Serbia, which is has the most authoritarian tendencies when it comes to the Western Balkans. So this is the chance for the European Commission to apply conditionality properly, and I think that it should strengthen the rule of law conditionality within the growth plan, because it was shown by in the case of Poland that, you know, the most successful instrument is money. So if you are giving money, you can ask for country to deliver. The other thing is that for the Western Balkans, there is no clear political vision and clear vision when they will be integrated. And I think that, you know, there is lack of motivation in the Western Balkans, and especially with corrupt governments and political elites, to strengthen the rule of law if there is no EU membership inside. Then there should be clear roadmaps for all the countries. It's quite clear that probably just one or none will join by 2030, but it's possible to develop roadmaps of what is achievable by 2030 for all the Western Balkan countries. So in that sense, you know, it's easier to apply sanctions and rewards if you have clear conditions and if you have clear milestones. And it's also easier to explain to the public if the political party in power is delivering or it's not. As I said, when you're praising reforms in Serbia and Serbia is not doing well, you know, it's easier for that party to stay in power because European Commission is also praising the reforms. And then I think that, you know, I forgot to mention that at the very beginning that conditionality is also undermined by the bilateral disputes when it comes to the Western Balkans. And there is clear case of North Macedonia. The country actually changed the name without any kind of reward. You know, so it's not easy now to trust European Commission, European Union if they are not keeping their promises. And it's also not easy to actually have any kind of clue whether we are approaching, whether we are joining or not. And it's also same when it comes to the rule of law, you know. If we don't have this feeling that we are living the rule of law in practice, how you can really have trust in EU conditionality and EU tools and anything else. And then, you know, if the European Union is not just question of standards and not just question of laws and strategies, but also values, you have to put values in the first place and not interests, and that's something which we have to do together. And I think that we are, I'm almost done with my time. Just to conclude with this that the democracy and the rule of law is something which has to be done hand in hand at all levels. It's not just a question of how to strengthen differently the rule of law in the Western Balkans and also in the European Union. You have to develop tools, and you can use the Western Balkans, you know, as a case study. First to apply in the Western Balkans, and then into a European Union, but the tools should be the same. And I think it's easier to integrate country and then to go with gradual integration once when it is in the European Union. Because as I said, it's quite obvious that, you know, it's easier to strengthen the rule of law once when you are part of the club. Maybe because we are still outside, it's easier to say it, but I think that the rule of law is really, when they say fundamentals first, that's how it should be done. Thank you.
Thank you. Thank you very much. So here it's not just the definition of the rule of law, particularly the implementation that is at stake, and so further issues and further problems. So let us move to the third perspective, which is about Ukraine, Moldova, and Georgia. So you need to, yeah. Magari mi sposto io di qua. Vuoi metterti così? Ce la fate? Aspetta che mi tiro. Okay. Right, so while the slides are going to be uploaded, let me present the bio of Professor Caterina Filippini. She's Associate Professor of Comparative Public Law at the University of Milan, where she teaches transnational constitution making and geopolitics and constitutional system. She has published extensively on the political and institutional evolution of former USSR republics, and has participated in projects funded by the UN, the Council of Europe on Russia, Armenia, and Georgia. So you've got the floor. Thank you.
Well, first of all, thank you very much for inviting me. And it's clear that speaking about Ukraine, Moldova, and Georgia in this moment is really difficult because all the geopolitical aspect, resilience, and so on, I'm playing together. But what I try to do, taking into consideration the subject of this conference, is to analyze how the European Union approaches from a comparative perspective to the rule of law in those three countries. Therefore, I had to analyze and to compare how the rule of law was conceived at the beginning, I mean, taking into consideration the partnership and cooperation agreement. Because if we take into consideration those agreements, we can see that even if they were concluded in 1994, even they entered into force a little bit some years later, they already say something about the rule of law in their preamble. So we can say, for example, that in the European Communities Ukraine Partnership and Cooperation Agreement, the parties conceive of the paramount importance of the rule of law and respect for human rights. Also, in the Moldova PCA, it was written always in the preamble that the parties convinced of the paramount importance of the rule of law and respects for human rights, and also recognizing the efforts of the Republic of Moldova to create political and economic system which respect the rule of law. So there was a reference to the rule of law, and the same was written in the Georgia Partnership and Cooperation Agreement. So in the preamble was written that as in the in the PCA concerning Ukraine and Moldova, that the parties are convinced of the paramount importance of the rule of law. But in addition to this, Article 71 was devoted to the cooperation matters relating to democracy and human rights. And in this article, it is written that the parties strengthen the rule of law. So beginning from the since we can say the partnership and cooperation agreement, we can find a reference to the rule of law, but we are at the very beginning also of the transition, or at least of the transformation of the constitutional orders of those countries. Going further, and speaking always of the partnership and cooperation agreements, we have also to take into consideration that democracy and human rights were considered essential elements of the agreements, and therefore we can find a negative conditionality already in those agreements, even if the fact that a violation of essential elements could mean a material breach of the agreements was not written directly in the agreements, but in joint declaration to the agreements. But what we can say is that all those agreements provide for a negative conditionality. In other words, they provide for the so-called human rights clause. But this was not said with respect to the rule of law. This is interesting because the rule of law was mentioned in the preamble, but was not considered an essential element. Additionally, we can also observe that the Partnership and Cooperation Agreement try to link the accomplishment of the political, economic, and legal reform within Ukraine, Moldova, and Georgia with the progress of the ambition of the EU to increment the relation with those countries. For example, Ukraine said that believing, always in the preamble only, believing that there is a necessary connection between full implementation of partnership on one hand and continuation of the actual accomplishment of Ukraine political, economic, and legal reforms on the other hand, and so on, they agree as follow. What is interesting is that the Partnership and Cooperation of Agreement with Ukraine does not use the verb depend. Meanwhile, whereas we can find this expression, this verb, in the Partnership and Cooperation Agreement with Moldova. Here it is written, as in Georgia, as in the Partnership and Cooperation Agreement with Georgia, that the full implementation of this Partnership and Cooperation Agreement will both depend on and contribute to continuation and accomplishment of the political, economic, and legal reforms. Therefore, we can find already in this period some differentiation between Ukraine with respect to the approach of the European communities to Ukraine, Georgia, and Moldova. Something changed with the launch of the NP strategy, with the adoption of the NP strategy paper and the European neighbor policy, because here, for the first time in a soft instrument, not in an instrument of hard law, as it was the case with the partnership agreement, we can find a reference of two common values, even if what is also interesting to take into consideration is that here in the strategy paper of the NP is not written common values of European Union. So this was another question to discuss at the time. But here it is written differently from the Partnership and Cooperation Agreement that the privileged relationship with neighbors will build on mutual commitment to common values, no longer or also to political, economic, and legal reform. But what it is interesting to note is that the European neighbor policy highlighted the relation and the respect and the commitment to common values. And among those common values, we find, first of all, the rule of law, in addition, the new concept of good governance and the respect of human rights, including minority rights. And here is also stated that the level of the US ambition in developing links with each partner through the ENP will take into account the extent to which common values are effectively shared. This means that also the action plans, which were introduced since 2005, had to take into consideration not only what was stated in the Partnership and Cooperation Agreement, but also what was stated in the ENP strategy paper. And therefore, if I compare what was written in the preamble of the Partnership Agreement and what was written in the action plans, I can distinguish a more attention dedicated to the commitments to common values. For example, when I take into consideration the Ukraine EP, here is written that the pace of progress of the relationship will acknowledge fully Ukraine's efforts and concrete achievements in meeting commitments to common values. And what is also relevant to take into consideration that the EU-Ukraine AP does not use still the verb depend. Meanwhile, if I take into consideration the EU-Moldova Action Plan, I see that the verb which is used is depend, and the same is written in the EU-Georgia AP. The level of ambition of the relationship will depend on the degree. The action plans, as we know, went beyond what was written in the Partnership and Cooperation Agreement, and therefore, when they went beyond, they pay even more attention to the rule of law. So I'm not going to read all those provisions, but among the priorities, there are a lot of references to the role of law, and also when we speak about the section dedicated to the political dialogue and reform. Therefore, we can observe a continuing implementation with respect to what was at the beginning written in the Partnership and Cooperation Agreement. Another novelty has been introduced thanks to the Eastern Partnership, because during the Praga Summit, for the first time, even if it was already spoken about before, was approved a document which officially used the term conditionality, because analyzing the previous documents, we cannot find this word, that we can only find formally in the Praga Summit Joint Declaration, especially here, when where it is written that the Eastern Partnership will be governed by the principle of differentiation and conditionality. Therefore, this principle also had an impact on the ENP, because following the declaration of the Praga Summit, also the ENP policy has been revised according to the 2011 revision. The link between conditionality and the rule of law was particularly highlighted by affirming that increased European Union support to its neighbors is conditional. It will depend, the verb used is depend, on progress in building and consolidating democracy and respect for the rule of law. So in the revision of the ENP policy, of the European Neighborhood Policy, finally we can find a clear link between conditionality and rule of law. And taking into consideration this development, also the Association association agreements, I mean instrument of hard law, took into consideration this not only conditionality, but the strict relation between conditionality and rule of law. Therefore, the association agreements which replace the partnership and cooperation agreement not only mention the rule of law in the preamble, in Article 1, Title 1, Title 2, but also in general principle and political dialogue, but really expand the provision devoted to the rule of law. And what is also really relevant to take into consideration at this point is not only the previous different instrument of hard law and soft law, which contributed to highlight the relation between conditionality and the rule of law, but also that meanwhile, as it was previously observed by other interveners, took place already or began the backsliding of the rule of law within the member states of the European Union, above all in Hungary. And this led, we know, to the adoption of a new framework to strengthen the rule of law within the EU. Therefore, analyzing all the documents, it's clear that the crisis of the rule of law within the European Union had an impact on the methodology concerning the rule of law in the external dimension of the European Union. Also because we have always to take into consideration that all those documents of soft law and above all of hard law were adopted without promising membership to Ukraine, Moldova, and Ukraine. Therefore, the association agreement incorporating and express all the development and the legal development that previously occurred in the external relation with respect to the Free State that I mentioned of the Eastern European Partnership, but at the same time also reflect what happened meanwhile within the European Union. And what is also relevant to take into consideration, paying attention to the association agreement of stipulated with Ukraine, that this agreement is the only one which recognizes formally that the rule of law is an essential element of the agreement. So if we compare all the association agreements, we find out that only the association agreement between the European Union and Ukraine states that the rule of law is also an essential element of this agreement. Therefore, we can discuss a lot about which kind of violation can we identify as a violation of the rule of law when we speak about Ukraine. The association agreement with Ukraine finally align also, how to say, the use of the verb, because finally in the association agreement with Ukraine, we find that the verb use is depend. In the preamble, it's clearly stated that the political association and economic integration of Ukraine with the European Union will depend on progress in the implementation of this agreement. So I have not so much time, but I have to go further, taking into consideration that meanwhile, the constitution of Ukraine and Moldova and Georgia were modified, and and all those constitutions in different moments introduced various provisions devoted to the European Union and to the rule of law. At the beginning concerning the rule of law, and in different moments concerning the possibility and the commitment to enter the European Union. From this point of view, we have to take into consideration that the first country which modify and introduce an article concerning the integration into European and Euro-Atlantic structure was Georgia, followed by Ukraine, and finally, after the referendum of October 2024, also Moldova introduced a special article devoted to the integration in the European Union. But we have all to take into consideration, above all, to take into consideration that Moldova, the constitution of Moldova, differently from that one of Georgia and Ukraine, does not mention the integration in the NATO. So this was done after the invasion of Russia in Ukraine, and the decision of Moldova was really influenced by the geopolitical situation. So briefly going further, after the invasion, we perfectly know that Ukraine, Georgia, and Moldova asked to be recognized as candidate countries of the European Union. And here the problem was which kind of response the European Union can give to those countries. And the decision was to recognize in fact the candidate status through the so-called fast track. But on the other hand, we have to underline that the European Union try always to emphasize that this fast track does not mean that the process cannot be based, it should be based on the merit. So here is clear. The Commission also emphasized that the enlargement process is merit-based and depends on the individual objective progress made by each of the partners. This allows any country in the process to progress based on own merits, but also means that it is really relevant that steps towards the EU can be reversed if the underlying conditions are not met anymore. So, for example, this is also a little bit the case of Georgia. Countries choosing to join the EU must fully embrace and promote EU values, including aligning with the EU's common foreign and security policy. However, yes, 1 minute only. Hearing before the other intervener speaking by Western Balkan, the decision was to approach step by step. I mean, in order to avoid the fatigue which characterized the Western Balkans, in effect, it was recognized the candidate status and at the same time to follow step by step some implementation of some values which, while giving the recognizing the candidate status, Ukraine, Moldova, and Georgia didn't yet acquire. This is true. Therefore, I think that approach took into consideration the fatigue with respect to the Western Balkans. They accelerate, even if they applied the merit-based concept. At principle, we will see what will be in the future. And above all, I'm not speaking about all the process, but the main problem that now is to take into consideration is that the so-called revised enlargement methodology, which was applied only to certain countries of the Western Balkans, was completely applied, is applied with respect to Moldova and Ukraine, no longer to Georgia for the moment. And this means that in order to opening the first cluster related to the fundamental values, it is necessary to have the approval of all member states, the unanimity of the member states. And Hungary is opposing, at least the Prime Minister and its party, to the entering of Ukraine in the European Union. And in addition to this, Orban decided to call for a national consultation. So, and this national consultation will end tomorrow. He asked he sent letters to the citizens of Hungary asking if they agree with the entry of Ukraine in the European Union. And therefore, he is waiting for the response in order to decide what to do. And therefore, now this is the big problem that have to face the European Union. And there are a lot of solutions that the European Union are thinking about to activate maybe Article 7 because the security of the European Union is in danger because of the approach of Hungary, or maybe Hungary, as already have done, may not take part to the decision and considered absent, go out from the room. So we will see. We are waiting for tomorrow and for the decision of Hungary and the European Union. Also because this already happening in the Western Balkans with respect to North Macedonia and Albania, because in that case, the European Union decided to go forward with Albania. And so decoupling the process. But this, from the political point of view, will be a very difficult decision to decouple the process between Moldova and Ukraine. Sorry for my, thank you.
Thank you very much. I think this opened up the chapter between the relationship between rule of law as such and geopolitical considerations, which are clearly there and influence the way in which the discussion is made, and once more underlines the fact that coherence and consistency by the European Union is a difficult task and not always completely successful. So we now have the last presentation for this session, which concerns the Eastern Partnership with a particular focus on Armenia. And our presenter is Anna. I think I need to ask you to pronounce it. Okay, I think you get it better from her than from me. She's the head of Department of Law, Political Science and International Relations at Eurasia International University in Armenia. And he is the holder of a Jean Monnet Chair in EU Legal Studies and Legal Europeanization and an interdisciplinary Jean Monnet module. And she works at the crossroads of law and political science and has a PhD in theory of law from Kiev and a master from the University of Trent. So you've got the floor. Maybe we shall, I think we made okay.
Thank you.
Yeah, but you can start.
Thank you very much, first of all, for this opportunity to participate in this very timely conference. I think my presentation will be the most geopolitical because in case of Armenia, this is one of the factors that very significantly affects the process. I would like to focus on the rule of law, conditionality, and the process of formation of the constitutional identity in Armenia. Why I decided to focus on constitutional identity, because I think that when we are speaking about the rule of law, it is important to look not only at the reforms which are implemented, but also to what extent the value of the rule of law is internalized and to what extent it becomes a part of the domestic constitutional culture and everyday legal practice. Because quite many reforms supported by the EU and promoted by the EU are being implemented, at least at the legislative level, but the major problem, which is continuously reported by the observers, by the monitors, is the lack of proper implementation. So what is the reason why the reforms which are introduced institutionally, which are introduced on the legislative level, are not sufficiently reflected in the legal practice? The case of Armenia is quite an interesting one, I think, because on the one hand, Armenia is a part of Eastern Partnership initiative in the same way as Georgia, Moldova, and Ukraine. But on the other hand, Armenia does not have any promise of the membership, and even more, till very recently, it even did not have an intent to apply for the membership. So what is the anatomy of conditionality in this case if there is no clear promise and expectation of the membership in the European Union? How the mechanism of conditionality works and to what extent it is effective. So this is what I would like to focus on in my research based on this presentation. I have here geographical visualization where Armenia actually is. This is the map representing the countries of Eastern Partnership. And what we can see here, so we are currently not looking at the Belarus, which is not part of the initiative anymore, but Ukraine and Moldova share the immediate border with the European Union. And even this geography plays a very significant role in all of the geopolitical processes which we can observe nowadays. While Georgia, Azerbaijan, and Armenia, the countries of South Caucasus, are geographically distant. And this really complicates even the process of integration. So not only the compliance with the values, with the fundamental principles and the acquis of the EU in general, but also the very geography is not very supportive, let's say, in the process of European integration. Even more, Armenia is in a very difficult geopolitical and geographical position, surrounded with Turkey on one side. Here we have the blocked border. There is no diplomatic relation between Armenia and Turkey. Azerbaijan with the actually ongoing conflict over Nagorno-Karabakh and even the aggressive actions of Azerbaijan in relation to the sovereign territory of Armenia itself. Iran with a very difficult geopolitical situation, and Georgia, the only friendly neighbor of Armenia at this moment. And of course, if Georgia becomes a member of the European Union, this will bring the immediate border of the EU very close to Armenia, and of course, certainly may affect the process. Although the perspectives of Georgia currently are really uncertain, considering both the compliance with the reforms and the general attitude of the government of Georgia to the membership in the European Union. So Armenia currently being in this difficult geopolitical situation with the neighbors is also greatly affected by Russia. Unfortunately, this is the factor that is the decisive in the process of Europeanization and in the process of building the relations between Armenia and the European Union. I will switch to the history of the relations with the European Union to mark actually how the factor of Russia affected the development of EU-Armenia relations. So we start this history with the collapse of the Soviet Union and with the appearance of Armenia as an independent state, the conclusion of the Partnership and Cooperation Agreement, and here we have a lot of commonalities with the cases of Georgia, Moldova, and Ukraine that have been just presented by Professor Filippini. We have the participation in the Eastern Partnership project, which underlines the commonality of values in respect to Armenia too. But surprisingly, in respect to Azerbaijan as well, in the same way, in respect to a country which is authoritarian and which violates the human rights, not only in the context of the ongoing conflict, but also domestically in relation to the political opposition, journalists, academicians, and so on. So this is one of the major problems, I think, of the conditionality and the general promotion of the rule of law by the European Union, that what is declared sometimes is very far from the reality on the ground. And this maybe to a certain extent wishful thinking of Eastern Partnership or a promise that these values are common, to greatly extent undermined the perception of the European Union by the population. So this is a clear discrepancy between what is declared, the commonality of values, and then what is going on the ground. In Armenia itself, in 2008, there was an very grave violation of human rights that occurred during the peaceful protests of people who disagreed with the results of the elections, fraudulent elections, and as a result of the governmental reaction to this peaceful protests, dozens of people were killed. And this violation of the government authorities had never been investigated afterwards. And the reaction of the European Union was also not very clear in this situation. And then the next year, in 2009, the European Union launches Eastern Partnership, declaring the commonality of values. So there is a big question then to what extent this complies with the constitutional reality in the partner countries. In 2010, Armenia finalized the negotiations on the association agreement. And this association agreement was very similar to the agreements with Georgia, Moldova, and Ukraine. However, due to the pressure of Russia, and here I come actually to these geopolitical considerations, Armenia was pressed to join Eurasian Economic Union, an integration project led by Russia and initially as an idea modeled on the example of the European Union, even though later with the process of the legislative framing of the Eurasian Economic Union, it became really far from what European Union actually is, including the issue of values, which are absent in the constitutional framework of Eurasian Economic Union, including the principles of supremacy of the supranational law, and many other aspects, including the institutional capacities. So in 2013, Armenia declared the so-called U-turn in its geopolitical orientation, saying that it is going to join the Eurasian Economic Union. European Union reacted with rather a shock perception of what happened and how it happened. The Armenian government insisted on signing both the legal framework with the Eurasian Economic Union and association agreement. However, obviously, because of the deep and comprehensive free trade area, it was not possible, as being in two integration projects, economic integration projects, is not compatible with the principles of international law. This caused a certain pause in the relations. Both partners were silent for a certain period of time, but partially because of the developments in the neighborhood, generally because of the revision of the European Union's approach to the promotion of the rule of law and values of democracy and human rights, in particular the revision of the European neighborhood policy, the new global strategy of the European Union. The parties decided to come back to the negotiations table and see what can be done now, considering the fact that Armenia was pressed to become a member of the Eurasian Economic Union. Russia, in this case, used multiple leverages, including the security leverage, because at that moment, Armenia perceived Russia as an military ally, as a guarantee of the security, which then later appeared to be absolutely not true, including the energy factor, Russia is the monopolic supplier of energy resources to Armenia and also the monopolic owner of the energy infrastructure. And the third factor is the migration, the big Armenian diaspora that lives in Russia, the labor migration, whose rights may be infringed in case of, let's say, misbehavior of Armenia from Russia's perspective. In addition, Armenia still hosts Russia's military base in its territory, which makes the country absolutely dependent, vulnerable, and with very limited sovereignty in practice. So considering all of these limitations, European Union and Armenia negotiated the new alternative agreement, which appeared to be a comprehensive and enhanced partnership agreement. In practice, this is association agreement, minus those provisions that related to deep and comprehensive free trade area, which was not in compliance with the Eurasian Economic Union legislation. So from this moment, Armenia joined, let's say, the club that can be called 3+1, 3 associated countries plus Armenia, with something in between of those countries that do not have any meaningful framework of cooperation with the EU and associated and currently candidate partners of Eastern Partnership project. Finally, in 2018, the very significant local shift occurs, and this is directly related to the formation of constitutional identity from inside, not as a reply to the conditionality or development assistance from the European Union, but as a local demand for change. This process of peaceful transition of power that was initiated against oligarchy and against very severe authoritarian trends, violation of human rights, the lack of rule of law, so of purely domestic constitutional problems, was called Velvet Revolution. And even though, in contrast with the processes in Georgia, Moldova, and Ukraine, Velvet Revolution did not have any geopolitical agenda. It was not about Russia's cooperation or the integration with the EU, but purely about domestic problems. This process of transformation, this process of advancement of domestic constitutional identity was very positive for the cooperation between EU and Armenia. And from these times, we can observe really greater involvement of EU in the reform processes, support of the institutional changes, the improvement of the functioning of the Supreme Judicial Council, the improvement of the legislative frameworks, judicial code and procedural codes, training for judges, capacity building activities, twinning initiatives, helping to exchange the experiences with European partners, and many more. Interestingly, Armenia has the obligations of legal approximation, as well as Georgia, Moldova, and Ukraine. That is, without any even blurred promise of the membership, the EU expects that Armenia will implement certain directives and regulations in the domestic legislation. And this is an extremely interesting process from a legal perspective. Finally, the last U-turn that happened in the process of relations between Armenia and the European Union was related to the recent escalation of the Nagorno-Karabakh process and the so-called gap between expectations from the Armenian people and the reality, the real capacity of the European Union to intervene into this conflict as a facilitating global actor. In principle, the people of Armenia were quite disappointed with the European Union reaction to this conflict, and this was one of the negative factors that affected the trust in the European Union as a normative power, as a global power, because it was perceived as the discrepancy between, again, the values which are promoted by the EU and the reaction of the European Union to the conflict that was in the recent stage initiated by the authoritarian country, not respecting the rule of law and human rights, and the country which tries to implement the same values as the European Union promotes. However, European Union managed to intervene as a humanitarian actor, as a development actor, restoring this trust to a certain extent. And finally, to finish my presentation with some conclusion, Armenia is negotiating, or is expected to start with this month, the negotiations on visa liberalization, which is one of the strictest conditionality tools which may be applied to Armenia at this moment, because the condition and the award are quite clearly cut and very realistic. Armenia continues the sectoral cooperation with the European Union, having concluded, for example, common aviation area agreement with its own conditionality and the approximation requirements. And the most recent development, probably the most interesting one, is the law which was adopted literally several weeks ago on the membership of Armenia in the European Union. And this law is the first case in Armenia when the law was adopted on the initiative of the people. It was a legislative procedure initiated by the people of Armenia, and they submitted also the draft law, which contains only one sentence, saying that Armenia initiates the process of membership. What it means from legal perspective is not clear, because there is no time frame for this, there is no relevant body responsible for this process identified. So this all is to be defined probably in some legal political roadmaps that will be elaborated further. But it is interesting that in addition to this statement, the law says why it was adopted. What is the reason and what are the objectives of initiating the process of membership. And it is worded as developing democratic institutions and well-being of society, strengthening security and resilience, and the rule of law. So the mere initiation of the process, the mere process of going closer to the submission of the application is viewed as a favorable context for further reforms and development of the rule of law. And finally, the very last statement, it is really not possible to promote the rule of law from outside, and I think conditionality is really not the best tool for this, unless there is a recognition and local demand for change, unless there is the understanding that what is to be done for the society itself, and not because the European Union or the US or any other partner requires, the implementation of the rule of law will become quite problematic. Thank you very much.
Thank you very much. So we have a further step into seeing what are the limits of the rule of law implementation and what are the cleavages. And with that, I think I would ask to Esther Appacher to come and give her remarks and discussion. I can give you my position and leave the presenter here so that you can have an interaction. And so let me chat. Thank you.
Thank you, Louisa, for giving me the chair. Thank you. Thank you so much for this very rich presentations. I learned a lot today, I must say. And I went a little bit further with my reflection on the rule of law. We're rather time restricted. So I will limit myself perhaps on some reflections on the rule of law, which is deemed a cornerstone of the European Union. That's why we are discussing it. But I think that the European Union discovered that even a cornerstone, a fundamental value, which is enshrined in each constitution, more or less, of member states, can be endangered, can be not a cornerstone for everybody. And that's why it became, I think, a little bit difficult to pretend from new member states who were willing to join the club that there must be the perfect rule of law when even within some member states of the European Union, the rule of law was backsliding. And I think that was the moment when the European Union discovered that a value cannot be taken for granted. And it needs maintenance, it needs discussion, it needs measures to enhance and to strengthen its effectiveness. And that's why the European Union decided on developing new tools, because Jens asked me to say something about cross-fertilization between internal rule of law and external conditionality for joining the nice club that the European Union wants to be and is. Not always. So I think let's have a quick look at these tools just to remind ourselves what the European Union tries to do. And perhaps before I do this, I would like to remember everybody that the rule of law is very, very complex. Hanna Sukova pointed out that the Venice Commission laid down a definition. We had this definition also projected by, I think, the first intervention. It is not only legality, it is a lot of things: legal certainty, access to justice, which we will talk about afterwards, respect for human rights, non-discrimination, equality before the law. So it is a rich and a complex concept, which has ramifications through the whole society. It's not only applying the laws. It's much more. I think it's how a society is and feel that it is right to be. So what did the European Union try to do, looking inward to establishing or to strengthen the rule of law within the European Union? We know that there is the rule of law mechanism with rule of law reports, which set out recommendations for the member states, positive and negative developments. We have the justice scoreboard, European semester. We have now also within the Recovery and Resilience Fund facility, the context that member states need to strengthen their justice system, or the anti-corruption framework, or even the quality of the legislative process. This is all part of the rule of law, of the, let's say, rediscovery that the rule of law is not something which is there and is always there and is always observed. We also have, and I think this is quite important, a support for civil society, for networks and projects. This is the Citizens, Equality, Rights and Values program, which aims at strengthening the civil society and the diversity within the civil society. As we are in the EU, have infringement procedures. We have the Article 7 Treaty of the European Union. We have also the general budget conditionality, which has been spoken about. So if you do not observe the rule of law, then you will not get the funds. And we also have, because we're parts of the club, the Charter of Fundamental Rights, and we know that each member state is required to place effective mechanisms to ensure that all programs supported by the European funding comply with the Charter of Fundamental Rights. If not, you won't get reimbursed for your expenditure. So let's say that we have monitoring, recommendations, we have funding for initiatives which foster the rule of law, and we have also mechanisms to aim at imposing the respect of the rule of law by withholding funding. It's the economic angle, I would call it. And I think that you all explained very clearly that these are the mechanisms which are used also towards the new and future member countries. Certainly you cannot use all those mechanisms which apply only to the members of the European Union, but it focuses really on getting, let's say, the requisite level of rule of law done or achieved by future members. And I think that the European Union has invented, or especially the European Commission has invented within the legal framework at her disposal, a lot of instruments. Perhaps instruments a little bit on the theoretical side, I don't know, because if I just think about the last two speeches we heard, well, the reality on the ground, it is much more complex and difficult than formal or legal mechanisms can take into account. I'm a theoretical, I'm only speaking from a theoretical point of view because I'm not on the ground, but there's something I really I would like to point out. Geopolitical conditions, cultural conditions, geographic conditions, and new developments. Well, who would have thought 3 years ago that we will again have a war right there? So I think that we can try to think about instruments, legal instruments. I think that more important is also the political and cultural angle to implement all those instruments. And I think it's for the EU. The EU has discovered that rule of law is a long-term commitment within the European Union. And I think it is a long-term commitment for everybody. So I think that the European Union also tries to, by applying these conditionalities, to introduce or to foster the rule of law in the future members. Tries also to prevent new tensions within the European Union. Let's say when you join the European Union, then you need a certain threshold. And we heard it is not quite clear what this threshold is. So that's, I think it's another critical point. We need to define this threshold, even if I'm a little bit skeptic about if it's possible to define the threshold once for all. I think there is some flexibility needed. So it's a sort of preventive action taken by the European Union that who joins the club is more or less on the same level as the European Union is. And therefore lies also a problem, because we have seen and experienced that it is not always the same within the European. And that is a little bit a problem for the credibility of the European Union. And I think this was also clearly pointed out that one of the major points where the European Union has really to work on is the credibility. Because if within the European Union I do not, my rule of law is not observed, then why I'm going to ask it from the other ones? It is not very credible. So having said that, if I may, I would have some questions. Right? Okay. So I wanted, because Cristina Fasone pointed it out, that this is within the European Union, that you think there is a lack of control by the parliament. So this focusing on the executive level poses a problem for you. How could we just enhance this control from the parliament, means from the side of the people, which I think, because this was the last relation we pointed out, that it needs the people to put into effect a rule of law. And then two times I heard, okay, even if we do not fulfill all those conditions and requisites of the rule of law, it is better to be in than out. Yes, but how should we cope with this better to be in than out? Couldn't this be a problem for the European Union then when they are in? That's one thing. And the second thing what is quite clear for me, I could quote an American president, not the actual one. It's the economy stupid. Is the rule of law implemented by pushing hard on the economical angle? Is this an economic integration like the European Union started, spillover effect, etc., or must it be more than only economic integration? I think rule of law is more than economic integration. But how could we just get out of this dilemma? I think it's a sort of a dilemma. And the last question I wanted to ask is, as Armenia, the case of Armenia has showed, there was a development from bottom up, from the people. How is it in the other countries? Is there also some sort of developments bottom up, or is it more top down? So that's I wanted to ask, because really I think this are some questions which need to be answered. So I don't know who wants to start. Okay.
Well, thank you so much. This a lot of food for thought. Also, I will definitely subscribe on the political and cultural angle of the enforcement of the various instruments and even of a common definition of the rule of law inside the EU. And there is, of course, also a problem of credibility of the EU inside, because not just outside, but also inside. There is a very critical group of scholars, for example, on the point of migration and EU migration law and the new term, which seems to mirror some certain migration policies of the member states. So there is a lot that needs to be fixed here. To respond on the important question of the lack of control by the parliament, I think it's not even clear which parliament here, because we would immediately expect it should be the European Parliament to control. But based on the legal basis, the European Parliament participates in certain procedure on the adoption of the budget, but has no power whatsoever on the execution, if not through the discharge procedure, which happens 2 years later. So for the European Parliament, it's very difficult to take control. Sometimes it tries to do so by merging different dossiers and threatening the veto on other dossiers to have more voice on the execution of the EU budget. But I think as things stand, is difficult. And also, the present coalition within the European Parliament tends to be quite lenient towards the Commission. In the past, we saw grand coalition inside the European Parliament, which were more reactive and vocal on the rule of law than at the present time. At the same time, I think the move, so first of all, spending conditionality is always executive driven everywhere, even in federation. What the parliaments typically do is through legislation to set the condition, but then the implementation and the execution is executive driven. I think the move from the European Commission and the Council and maybe the Parliament itself when designing the various instruments is to insist more on having national plans which are going to implement specific European objectives in order to strengthen the national ownership and to let national parliaments have a role also in the implementation of these plans. The practice, however, is not really rewarding for parliaments because they hardly participate in the design of the plans and not even in the execution. But maybe this planning method, especially for countries like Italy that, I mean, is not used to plan well in advance on many policy, requires a little bit of time in order to build more ownership of European policies, also on the rule of law side. I conclude with a sign of hope.
Well, I spent almost 20 years in researching the rule of law, conditionality, and how to improve it. I am not the one who is recommending to integrate the Western Balkans or any candidate country without progress when it comes to the rule of law. But what I'm suggesting is that instead of focusing on doing all formal preconditions in all 33 negotiating chapters, just focus on most important reforms when it comes to the rule of law, having country which has improved its procedures, which is guaranteeing the rule of law and practice. And for all the other chapters, there is time when you are already in the European Union. So to carefully design post-accession mechanisms, and having gradual integration or the multi-speed Europe, which is already in the Treaty on the European Union when you are inside, but with defined procedures and improved rule of law in order, to cope the pressure when you are in the European Union. And then how to explain that the economy does not have spillover effect on the rule of law? It's easy because you can use Visegrad countries, which were, integrated among themselves. And there was no even improvement of economy and GDP because you cannot improve your economy while you are integrated with the countries which are equal with you or less developed than you. You can do it when you're integrating with the countries which are part of the single European market. And what they are now trying to do with the Western Balkans and the growth plan, like, you can gradually integrate the Western Balkans into single European market. You cannot, because the way they are designing the growth plan and the reform agenda, they are working on digitalization and some less important parts of the single European market. And they are insisting on the common regional market for the Western Balkans. As I said, this does not have spillover effect on democracy and the rule of law. So focus on the procedures and the rule of law and the economy once when you are in the European Union. That's how I see it.
Jumping.
Yeah, no, jumping.
Gradually.
Improve the rule of law and then gradually integrate
gradually.
when you fulfill criteria. For example, in the area of public procurement, you are integrating in that areas once, yes, you are fulfilling it. As it's easier that way, and I think that it could be kind of competition between the countries when you are there, like full. And once now what they are doing with Albania and Montenegro, they are just focused on laws and strategies, still on technical preconditions and not on implementations. And that's not how the rule of law is working.
No, I think simply that it would not happen. I mean, without the invasion of Russia, the European Union would not ask. They were not prepared to access. There are a lot of studies about that. It's true that the main goal of the European Union was stability and security after the big enlargement. So I didn't I focus on the legal provision, but it's clear that the fundamental reason was that, and it is reflected above all in the development of the concept of common values and rule of law to apply in the external policy. But the gap or the differences are really big between, from the point of view of the cultural approach, the tradition, and so on. Therefore, if you read also the report about the implementation of the association agreement, they were not at all ready to enter the European Union before. And there is also an approach nowadays that is a political approach. So this is clear. And however, we have to take into consideration that after recognizing the candidate status, the European Union has to apply other criteria than before, when there was an approximation, a political association, and integration in the EU market, or at least a commitment, without promising the entering of the EU. So I'm completely, so I agree completely that it is impossible to impose the rule of law through conditionality, also because I took part of the first thesis project, and therefore I could appreciate everything, or at least a lot. But what I always like to underline that at that time, we were, as to say, instructed that we could not speak about conditionality. So the approach was completely different. When I began to read that the European Union began to speak normally about conditionality, for me it was a little bit a shock, because it was a symptom about a completely changed approach. I mean, maybe there was also before the same approach, but at least formally the attitude was a little bit different. And there are a lot of problems, my colleague said, because if we think that Armenia, for example, and Georgia are the only two states among the countries of the former Soviet Union which introduced parliamentary form of government. So, I mean, and nevertheless, in Georgia, there is a backslide with respect of democracy. Meanwhile, this didn't occur in Armenia. For example, if you read the Freedom of House, the index before the war, and you compare Armenia, which was already in the Eurasian Economic Union, and Ukraine, the index were better from Armenia than from with respect to Ukraine. Therefore, the situation is really, and we have to read it in terms of geopolitics and stability. I mean, the Eastern European politics was launched in order to stabilize. So this is the main fact.
Thank you very much for such thought-provoking comments. I would like just to briefly comment on your note regarding the bottom-up approach in Armenia. I would like to focus on two points. First, that the peaceful transition of power resulted in the changes in the legislature and in the government. And in principle, we can say that the new government, the new legislature were really reform-oriented, and they changed the approach that was very typical for Armenia before 2018, that is facade reforms, both for democracy and rule of law and human rights, that is adopting the legislation in line with the European Union expectations, in line with the EU acquis, but not implementing anything in practice. Just to provide one example, during the negotiations of the association agreement, Armenia had to comply with a very big amount of pre-signing acquis, including, for example, competition legislation of the European Union. And it was acknowledged in the reports that the legislation of Armenia was so much in line with the dynamic acquis, that is, with the most recent changes in the EU legislation. But in practice, Armenia was an oligarchic authoritarian regime with state-supported monopolies, which was very far from any principles of competition legislation in general. So that is why it was really the typical feature, this facade reforms. This approach changed in 2018, but I really do not want to idealize saying that everything became really perfect, because there were many problems. For example, in Armenia, still there is no effective multi-party system. So the capacity is very low because of many factors, because of the Soviet heritage, because of this semi-oligarchic authoritarian history, because of the existential threat coming from outside. So this all affected the political culture, and the multi-party system is not well developed, which is a basis for democracy. The capacity in public administration is also quite low. The civil service is not the prestigious work, and not many competent young professionals really want to serve in public sector. So all this, of course, affected the results of the reforms, both inherited systemic problems and the lack of capacity, the lack of methodological understanding. But in judiciary, the situation was even worse after 2018, because in contrast with the legislature and executive branch of power that were changed, yes, reformed, and the faces changed also after the peaceful protest, judiciary remained the same. And practically, judiciary remained the bastion of the previous regime, with informal networking, with the political links with the previous regime. This resulted in very significant consequences. For example, the high-profile case against the then President Kocharian in relation to the events of 2008 that I mentioned in the presentation, the violations of human rights by the government, the investigation and bringing to the responsibility for these violations was one of the revolutionary promises. But this case collapsed just because of the judiciary and its links with the previous government. It's by itself a very interesting story with the involvement of the Venice Commission and with the constitutional reform processes. But as we do not have time for this, unfortunately, we'll just bring beyond the scene this further details. Thank you.
Thank you. Well, Luisa, you're the chair.
Keep the question of the public because we are running late, so maybe we can combine it with the next section. And what about the break? How long? Okay, half past five, resuming with the next.
Okay. Good afternoon. We can resume for the second session of this afternoon, the first afternoon of the conference, and now we are. My name is, first of all, my name is Simone Penasa. I'm a professor here at the Faculty of Law in Comparative Public Law, and I teach constitutional law and comparative judicial systems. So I'm, of course, very interested in the panels that will follow, because, of course, the judicial system organization is a privileged viewpoint from which assessing the effectiveness of safeguards strictly related with rule of law, such as the idea of judicial independence. Now and also tomorrow morning, we will take a more specific focus perspective, and the title of the session trace the boundaries of the perspective from which we will analyze the constitutional course in these three levels and the three dimensions: political interference on the one hand and resilience on the other, which set the boundaries of this second session. But I think they also reveal the complexity of analyzing constitutional courts inside and outside the EU in the framework of rule of law and enlargement. Precisely because in the perspective of rule of law, the nature of constitutional courts may be seen as twofold. On the one hand, they are, of course, a tool for strengthening and disseminating, incorporating the value of the rule of law, but they also can become, and actually they are becoming, an object of protection through the principle of the rule of law. So we have to bear in mind, I guess, that the role and function that are traditionally acknowledged to constitutional courts worldwide cannot be taken for granted. And as the constitutions, also constitutional courts are living bodies more than inanimate prototypes, which need care, trust, and nutriments. So I think this will be a very interesting session. I stop here and I immediately give the floor to our first speaker, Professor Tania Groppi. I welcome her here in Trento. Tania Groppi is a professor of public law at the University of Siena, where she also teaches comparative law and gender equality law. So thanks, and the floor is yours. I asked for, we try to stick to around 15 and 20 minutes. Okay, so we have time also for the 20 minutes for the discussant and the debate. Hopefully.
Okay, thank you very much, Simone. Thank you very much to the organizers, to Jens and the Trento team. It's always a big pleasure to be here, and I learned a lot from the previous session. Simone, please tell me when I'm about to complete, yes, my time. Then, constitutional courts in democratic erosion, in democratic backsliding. I'm going to focus on the European Union constitutional courts, and within the European Union we can find all the generations of constitutional court, as we can find the Austrian constitutional court, the first generation. And then I'm not going to quote all, to mention all of them in order not use all the time. However, second generation, third generation, and especially in the Central and Eastern Europe, there is really a plethora of constitutional courts in new democracies. I will only sketch some features of this topic, especially pointing out what, in my view, deserves further research. This topic, constitutional courts in democratic backsliding, has been investigated by many scholars worldwide, and also in Europe. There are many single country studies and a small number of country studies, and I will build actually on those studies, but I think that a comprehensive comparative research is still missing, and also a methodology trying to balance normative and empirical aspects. I'm going to divide my presentation into two parts. In the first part, I will address the issue of the attacks, let me use this very broad word, on constitutional court within the European Union by illiberal actors and the consequences of those attacks on courts. And I'm going also to raise a couple of questions. Is there anything new compared to the traditional tensions always existed between courts and politics? And there is any specificity of those attacks to the constitutional courts within the European Union? Then in order to try to point out, to underline if there are some specificities for constitutional court within the European Union in the democratic erosion, we need a more broad comparison, of course, because we need also to take into account what happens in other parts of the world to try to discover what is the specificity for what is going on in the European Union. Then the second part, if I hope I succeed in summarizing the first part, in order to have the possibility to discuss a little bit the toolkit to protect courts in the context of democratic erosion, and especially, but not only, the role of the European Union in this process of strengthening the constitutional courts. Then, as for the first part, constitutional courts under attack, is not surprising that in the context of democratic backsliding, when they reach power, one of the primary goals of illiberal actors is achieving control of constitutional courts. We could say the same for the judiciary, but this is for tomorrow's session. But from one hand, we can consider summarizing the judicialization of politics, the expansion of the role of constitutional courts over the last few decades, and courts have improving the role of courts has become like the standard response to dysfunctional democracies. And then, of course, as the power of constitutional courts grew in the past, they are a special target, a very interesting target for illiberal actors. And from the other hand, as courts are part of the rule of law, of the checks and balances, they are considered as natural enemies by liberal anti-pluralistic actors that would like to get rid of any constraint. Very often, it was mentioned by Jens, I think, at the beginning of this session, we refer to democratic erosion, democratic backsliding, but I think is erosion or backsliding of the rule of law most often. Then probably we should change also our language to define the crisis. Is not is a crisis of constitutional democracy, but constitutional democracy is based on two pillars. Then one pillar is democracy, but the other pillar is constitutional rule of law. And what is undermined is especially the constitutional rule of law. And then within this framework, we can easily understand why constitutional courts are a target. Very often, scholars refer us for the tools used by liberal actors to court packing or court carving. But I think that probably, and I would like just to stress the points that, in my view, deserve further research and by scholars, probably we need a bit more elaborated, sophisticated definitions and classifications, taking into account that there are both formal and informal tools that are used by liberal actors against constitutional courts. Then probably we should have a better classification. Here, I try to develop a classification based on 4 categories I'm presenting very shortly about how courts are attacked by illiberal actors. Then court packing is, of course, one possibility, but stricto sensu, it means intentional irregular change in the personal composition of the court that creates a new pro-government majority. Then is the independence of the court under attack, but especially considering these only this aspect about the composition of the court. And Poland here is unfortunately the perfect case for court packing, what happened in 2015. And according to the conclusion of the Advocate General Spielman, I think he also focused exactly on this aspect. But there is another category, I think, that is even worse as for the role of the courts. And here I use the expression court gutting in the meaning of strongly weakening the court, undermining its core functions and effectiveness. Is not only about composition, is not only about independence, but there are in this category, several interventions very often combined, intertwined, and as a result, by combining several dimensions of this court weakening, the court has not anymore the role that the constitutional courts usually, and according to the definition of constitutional justice, have. For example, excluding some standard from judicial review, exempting some acts for from the control of the court, weakening the effects of the decisions, for example, giving the legislator override powers, eliminating some way to trigger the court, some possibility to access to the court. If you consider all those dimensions all together, in my definition would be court gutting. And then there is the court curbing. Here, this, according to, I don't have the time to quote a scholarship, but it is considered as a mean to block or hinder court functions. It may consist in non-publication of court judgment, modification of the majority necessary for invalidating legislation, non-execution of judgments. And in the non-execution of judgments, it can be included as, for example, it happens quite often in Italy, also the lack of legislative implementation. Then fourth possibility is courts under stress. I use this category just to express the concept that in many countries, although probably we cannot precisely talk of court packing or curbing, even less gutting, but there have been attempts to capture the court without illegally packing it, just taking advantage of the political majority in the appointing institutions. And just to present an example from Western Europe, Spain probably you can discuss, can be considered within this category, or using strategies of delegitimization in the public discourse, often based on the populist rhetoric that unelected bodies cannot control the will of the ruling majorities, and then attempt to delegitimize courts. I wonder whether in this category of courts under stress, we can consider, for example, to switch from national constitutional courts to the European Court of Human Rights, the open letter by the 9 governments of the 22nd of May, asking the European Court of Human Rights to change its case law, or I'm summarizing, on immigration and refoulement, asylum seekers, and so on. Finally, it's just a letter complaining that this case law is not in line with the will of the majority of the European citizens. This is the last part of the letter. Then which consequences, once then categorizing a bit which kind of attack, then the consequences on courts. Here, summarizing, court packing or gutting, of course, avoid courts to quash unconstitutional acts. Then they don't have any more this power, or as they are not anymore independent, they don't have any interest to conflict with political majorities. What's more, courts, especially pact can act as a rubber stamp to give legitimacy to illegal acts of the government. And this is what is happened in Poland, and even worse, once populists lose elections and governmental power, pact and capture course can work as obstacles to the democratization, and this is what is happening in Poland. Is really impressive. Hanna is not here anymore, but it's really impressive reading the documents published on the web page, Polish web page dedicated to the I quote the title of the web page, dedicated to the documentation of violation of the rule of law by the public authorities of the Republic of Poland from 13 December 2023. Then task government and the judges and fake judges of the Constitutional Court contributed a lot, and also as members of Venice Commission, they are acting in this direction. Then capture courts. Court curbing reduces the possibility for courts to play their counter-majoritarian role, resulting in weakening the rigidity of the Constitution. And courts under stress by populist narrative are less likely to take bold decisions, quashing against political majorities. The two questions, yes, in order to have the possibility to develop a little bit the second part, I'm not developing the question, is there anything new? But I think this is not only about what is going on in the European Union, is what is going on in this conflict between illiberal majorities and constitutional courts everywhere in the world. Try to assess, is there something new, or also in the past we had, and I think here is the context and the intertwined attacks to the rule of law that makes the difference if you compare of what happened also in the past in some countries. And is there any specificity as for those attacks within the European Union? And here, I think that I only have a question, a point to be further developed, probably, because some authors pointed out that democratic backsliding becomes more likely within the European Union rather than outside, due to the emphasis on executive power from one hand, then this necessity to strengthen the government, strengthen executive power, and because the European Union in post-Maastricht policy structure limits states' domestic policy space, and this can have an impact making easier, finally, and facilitating backsliding. Then the question here is, which is this link? Is there any link between membership of the European Union and backsliding? Second part is about how to protect courts, then solutions. This toolkit is very difficult to disentangle the many variables influencing the resilience of some courts. Is difficult. However, we can at least to try to point out that institutional design matters. Comparing Italy and Spain, for example, the composition of the Constitutional Court, and we can also take into account Germany that finally succeeded in strengthening the process to appoint judges, and also probably the amending formula which I mean, formula does exist in a country can also have an influence. Anna Sukowska spoke about decentralization of constitutional justice, then this can also be a point when we deal with institutional design. Does a decentralized system is more resilient? In the European Union, we don't have so many examples, but probably the few we have deserves further investigation. And there are also many other procedural aspects within the court, dissenting opinion, the avenues to trigger the court, possibility for the court to oversight execution of the judgments, then several procedural aspects, in my view, that we should investigate. Behavioral models, second point to be investigated is about behavioral models of the courts. Here, some scholars suggest that business as usual is the best option for the course when they are under at least stress. Here I would like to just to mention, I don't have time, but the interesting case of the Czech Constitutional Court. I think we should investigate this court that displays a lot of resilience in an easy political context and with a very weak institutional design. But there are at least, according to scholars, scholarship and also in direct conversation with scholars from Czech Republic, they pointed out that this court acted, according to them, in a very wise way. I would summarize ELI as democracy and distrust, then protecting democratic rules, but avoiding any dividing from the moral or ethical or values point of view issue, than just focusing on protecting the democratic process. And political culture, of course, here the difference between new democracies in Central and Eastern Europe and what is happening also in difficult context in Western Europe. I think we should mention it. And external actors, okay, probably this was the, for you as organizers, it was the most interesting point to be developed, the role of the European Union institutions. Here, I don't have any clear answer. Of course, if you compare what is the toolkit to protect courts within the European Union and outside, then if you compare Israel, Mexico to Poland and Hungary, a classical comparison, there are many more resources here in Europe that doesn't exist outside Europe. But I'm a bit skeptical about the real impact of those tools on the resilience of the courts. I think at least it has still to be proven. And finally, I conclude with, I think what, in my view, is a key issue for strengthening the constitutional course in the context of democratic erosion of backsliding, that is public trust. And then for me, it is not from external actors. Of course, all those aspects, institutional design, behavioral models, external actors, political culture, they can contribute But I think a key issue is the public trust, because finally the prequel to many courts attack starts with this delegitimization of courts. And then I think that this is a key issue. And investments in strengthening public trust by courts is really important. Then this implies very clear judgments. It's not only a matter of communication or using social media, or it is also a matter of this, but also about judgments. But of course, this is not only the role of for the courts. Here that probably a real network of actors is necessary in order to avoid leaving courts alone in improving constitutional literacy and trying to build awareness in the citizens about the role of the courts, constitutional democracy, rule of law. And then here I think in this kind of events, we should try also to develop some operational tools in order to contribute as academics to this job. We cannot leave the courts alone in improving constitutional literacy and public trust. Thank you, and sorry if I spoke too much.
Thank you. Thank you. Thank you. Thanks, Professor Groppi, because you provide us with a model of strategies, but also remedies against the attacks to constitutional courts. And I think it's a key point that we start with some example. This model has been built inside the EU. We have to so within the more traditional judicial system, where the constitutional adjudication has been traditionally built within the constitution. So I think thank you, especially for the part of the remedies. I'm also convinced with the idea of public trust, and some national constitutional courts are moving towards that direction, also from some cultural initiatives, not only normative, not only by exercising their traditional function. So is there a continuity in the strategies and threatening and remedies also outside the European Union, and opening up the perspective? So I immediately give the floor to Professor Constant Greb from University of Strasbourg, where she is an emeritus professor, that she will focus on Western Balkans. And she also start from this apparent dichotomy between political pressure and resilience of constitutional courts. I want to highlight that Professor Greb was judge at the Constitutional Court of Bosnia and Herzegovina from 2004 and 2016. So thank you, welcome, and the floor is yours.
Thank you very much. And thank you very much for the invitation to come to Trento. I went here for several years to participate in a summer school with Professor Tognati. It was very interesting. And
Yeah.
oh yes.
Yeah.
Okay. And this was a pleasure. And so I saw Trento for the first time, and so this time is just a return. So about the constitutional courts in the Western Balkans. The Western Balkans had a transition which occurred with the aim of returning to Europe and to the rule of law, as in all parts of Eastern Europe. And this was, of course, notably reflected in the establishment of constitutional courts, which were supposed to ensure the success of transformation. However, more than 28 years later, the question emerges of how can the rule of law be made concrete or operational, and how can it be assessed. In fact, international surveys on democracy, transparency, and corruption in the Western Balkans show little to no progress in the different elements of the rule of law. This means that despite the continuous improvement and refinement of European benchmarks, the principle still is not operational. And the constitutional courts of these countries may be contributing to the rule of law crisis. So both sides are presumably responsible for this lack of progress. Since the organizers asked me to provide an overview, I suggest characterizing the entire area by contrasting the Western Balkans' common past with European requirements as expressed in European Commission reports and Venice Commission opinions. The progress toward European integration is thus at the forefront of this overview. Next, I will focus on the constitutional courts and their strategies. This section aims to empirically explore the two polarities of this conference: deferral to political interference and resilience. Finally, some concluding remarks attempt to bridge the two worlds, the one of the EU and the other, because it's really two worlds, and the other of the constitutional courts in the Western Balkans. But first, to the Western Balkans, between legacy of the past and the requirements of European integration. The legacy of the past remains a principal, dominant characteristic of the Western Balkans. With respect to judiciary, it is embodied in the concept of legal socialist culture. This idea and its incompatibility with European integration will be discussed before a brief summary of European conditionality as presented in the reports of the European and the Venice Commission. The socialist legal culture and the necessity of its transformation, this is the concept of The concept of legal culture refers to people's ideas, values, attitudes, and opinions concerning law and the legal system. It is, of course, quite a vague and highly contested notion, but it remains useful for a comprehensive analysis of the judicial system, in particular the interactions between the internal perspective, the way lawyers see and practice their profession, and the external perspective, which includes societal attitudes toward law and the legal system. Thus, the legal reasoning of a constitutional court is not only the expression of a certain technique, but also makes a statement about society's fundamental conception of law and judicial office. This affects the population's legal awareness and trust in the judiciary. It was your conclusion. According to Zdeněk Kuhn, the phenomenon of a socialist legal culture in Central European countries relied primarily on exegesis advocated during the 19th century. This strictly formalistic and positivist conception, which Kuhn terms mechanical thinking, implies that laws exhaustively regulate everything, leaving no room for discretion when interpreting them. Since this often proves impossible in practice, many laws are not applied, enforced in informal proceedings, or circumvented. As a result, mechanical thinking reduces the workload, but also creates blind spots regarding the growing complexity of law. It is reluctant to acknowledge or consider international or foreign law. It promotes literal interpretive methods regardless of the context or of constitutional goals and values, appearing thus as textualist. Consequently, only a limited approximation to European standards seems feasible. Either European standards are reduced through facade without consideration of their substance, or they are only applied to the extent domestic law allows. Clearly, such a concept is difficult to reconcile with European conditionality or even with the case law of the European Court of Human Rights. So, what are the accession conditionalities expressed by the European and the Venice Commission? Recently, the Copenhagen criteria for EU accession have been reviewed, giving rise to a new methodology of this concept. Its aim is to make the rule of law more concrete and operational. To this end, a comprehensive reform program has been proposed to the Western Balkans, resulting in strengthened supervision of rule of law and detailed benchmarks. The European Commission's enlargement and rule of law reports now prioritize the judicial system, fight against corruption and organized crime, and the protection of fundamental rights, especially freedom of expression in the media and peaceful assembly. All of the 2024 reports regarding Western Balkans criticize the lack of financial and staff resources in the judicial system. Furthermore, they blame the gap between legislation and its insufficient or absent implementation, which is typical for socialist legal culture. The reports also highlight that despite the existence of special bodies for prosecuting corruption and organized crime, both forms of criminality remain widespread in all 6 countries. The Venice Commission generally intervenes when asked by the national authorities. This happens mostly when an important reform, political crisis, or sensitive case before the Constitutional Court occurs. The topics addressed in these opinions primarily concern the judiciary. Of the 6 Western Balkan states, 4, Albania, Montenegro, North Macedonia, and Serbia, are currently included in accession negotiations. As serious candidates, each of them has a dedicated rule of law report. Despite their advanced position in the integration process, the 4 states must still accomplish deep transformations. So it appears that in Montenegro, the last reforms were adopted quite hastily, that Albania's vetting process is still not terminated, that in North Macedonia, the quality of the judiciary has declined in recent years, and that Serbia, while continuing its relations with Russia and China, has interrupted its EU-related reforms. By contrast, Kosovo and Bosnia-Herzegovina must make much more progress before negotiations can begin. Thus, Kosovo's lacking commitment to aligning the judicial system with European standards is noticed. And in Bosnia-Herzegovina, the influence of ethnicity remains of major concern. Now, after having seen very quickly these conditionalities, let's see the constitutional courts in this regard. It is sometimes difficult to determine the main strategy or judicial politics of the Western Balkan constitutional courts, as most of them have ceased to function for several years due to politicians' passivity, polarization, or vetting processes. Bearing in mind this discontinued jurisprudence, I will nevertheless attempt to find significant examples of different or resilient strategies before illustrating some more ambivalent positions. So first, two different strategies. Different behavior mainly prevails when legal culture has not evolved. This means that courts at the same time are reluctant to questioning the decisions of the political majority and remain committed to traditional legal techniques. The principal manifestations of this approach are avoidance, postponement, and circumvention strategies, which are frequently used by the courts in Serbia, Montenegro, and North Macedonia. For example, the Serbian court often postponed political sensitive cases until the political majority was no longer in power or about to lose its majority. The case of the Brussels Agreement between Serbia and Kosovo is particularly striking in this context. In its decision, the Constitutional Court denied the agreement's qualification as an international treaty. It's quite impressive. Through a vague formalist justification, the court declared itself incompetent, thus avoiding addressing this politically explosive problem altogether. Amusingly, in the same context, the Kosovo Constitutional Court also exercised restraint and declared itself incompetent. Thus, different decisions are not a monopoly of the before-mentioned courts. So we are coming now to resilient strategies. Resilience is primarily expressed through interpretive patterns that refer to constitutional principles and consider their use of our constitutional goals and adopting systematic or teleological interpretation methods. The proximity to European standards and the transformation of legal culture is obvious in these cases. Resilience often takes the form of opposition to the ruling power, but not all opposition is resilient in relation to the rule of law, and this could be quite difficult to distinguish. This attitude can be found foremost in Bosnia-Herzegovina, Albania, and Kosovo. So the Prizren decision of the Kosovo court is significant in this respect. The court found the coat of arms of the city of Prizren unconstitutional, since it did not sufficiently take into account the minorities referred to as communities in Kosovo. In this coat of arms, only Albanian symbols are visible. The court argued both collective minority rights and individual citizens' rights to equality. This way, it sought to establish a balance between ethnic and democratic principles and promote so the rule of law. In a similar way, the Albanian court balanced the rights of the parliamentary minority with those of the majority in the exercise of parliamentary investigations. It declared several legislative provisions unconstitutional for not sufficiently guaranteeing the minority's rights to effective parliamentary control. Conversely, the usually different courts sometimes issue resilient decisions. Thus, the Serbian Constitutional Court helped preserve democratic principles. In a bold interpretation that contradicted constitutional provisions, the court protected the deputy's representative mandate. The issue at stake was whether political parties could revoke the parliamentary mandates of their members if they switched parties. The so-called blank resignations served as an instrument of party control, which the court deemed unconstitutional in several rulings. These judgments are all the more welcome as they clearly reject a relic of socialist legal culture. It was very diffused. But it's not always very easy to appreciate all these situations. And so we have some very ambivalent positions. Ambivalence results foremost from the perspective of consistency of the different constitutional jurisprudences. While different positions persist often, resilience seems to be more difficult to hold steady, which is not very surprising. The North Macedonian Constitutional Court's case law on lustration legislation from 2010 to 2012 is noteworthy in this context. It led to the annulment of numerous provisions of this legislation, which largely stopped the lustration process. This is rather positive in terms of human rights protection, but rather negative in respect to transformation. However, the government succeeded in pushing through a new law with similar provisions to those overturned by the court. This time, the court abandoned its resilient position, declaring the law constitutional. This contradictory jurisprudence mainly discredits on the Constitutional Court and does not contribute to the development of the rule of law. Likewise, the court's willingness to considerably expand presidential powers to grant pardons shows little consideration for the rule of law. By contrast, the Kosovo court exemplifies the difficult safeguard of resilience. As a matter of fact, uncertainty is raised about the court's position on the rule of law by frequent changes of jurisprudence and interpretive methods, including some acrobatic implementations of the Constitution. So the case law on presidential elections or on the appointment of the Houthi government seems to be guided much more by internal political speculations than by the will to promote the rule of law. The Bosnian court is marked by this ambivalence to a lesser extent. While resilience predominates the case law on important topics, the item of ethnic quotas appears much more ambivalent and at the end of the day even different. Thus, the judgment on constituent peoples of 2000 was clearly resilient since it was opposed to the political majority and in favor of the balance of powers advocated by the rule of law. However, the subsequent case law shows an unlimited expansion of such quotas, turning out to be a case law that differs the general atmosphere and the consensus of dominant political parties. The most famous illustration of this tendency is provided by the Bosnian judgment in the Sedic and Finci case, in which the exclusion of the so-called others from standing in elections was accepted by the court. And when the European Court of Human Rights was called to decide this case, it found a violation of the 12th additional protocol. Clearly here, the Bosnian court missed the opportunity to contribute to democratization, likely considering consensus on domestic policy more important. Certainly, it is not always very easy to determine the contribution of a single decision to the rule of law. However, it seems to me that on average, the rule of law is better protected in Bosnia-Herzegovina, Kosovo, and Albania than in other Western Balkan countries. This conclusion might be surprising because the former are precisely the countries that the European Commission, as we heard it, has placed at the bottom of the European integration. So what could be the explanation? And I'm coming to my concluding remarks. Finally, upon observing constitutional case law, we have found that differences among courts depend far more on their reasoning and their general conception of law, in short, their legal culture, than on concrete texts. For instance, European benchmarks and the Venice Commission's recommendations advocate for the parliamentary election of constitutional judges with a qualified majority. In this regard, various modalities exist in Western Balkans. These modalities range from a qualified majority in Kosovo to an absolute majority of all deputies in Montenegro and North Macedonia, and split appointments in Albania, Serbia, and Bosnia-Herzegovina. Yet in all these configurations, the politicization of the courts remains significant and has not prevented long and frequent vacancies. Other examples relating to the powers and competences of courts follow the same pattern. For example, the Serbian court has numerous and significant powers, particularly with regard to the variety of acts that can be challenged and the possibility of self-referral. In comparison, the Bosnian court is quite limited, but in practice, the Serbian court, committed to traditional textual techniques of interpretation, shows much more restraint than the Bosnian court. In my opinion, these examples demonstrate not only the limits of law, but also some of the benchmark's defects. The first example can be observed in Albania. The Commission's insistence on constant improvements of the vetting process resulted in a lengthy procedure that left the country without a constitutional court for several years. Nevertheless, even after the reform was completed, the Commission denounced corruption in the judiciary. Therefore, I believe this type of perfectionism is more harmful than helpful to achieve the rule of law. A second defect is the lack of proper benchmarks to assess the quality of constitutional case law, or if you want, the evolution of legal culture in Western Balkan countries. This might be difficult, of course, but it explains a part of the discrepancy between the Commission's statements on the one hand and many analyses made by lawyers or political scientists on the Western Balkan constitutional case law on the other hand. Finally, constitutional courts can certainly improve the rule of law. However, they don't have a very high reputation and their decisions are not always enforced, far of that, so that their impact on society is relatively limited. Clearly, substantial rule of law transformation can only result from meaningful and active cooperation between civil society, this is very important, independent bodies, the judiciary, and political authorities. In other words, it's not for tomorrow.
Thank you. Thank you very much. Again, also here we you spoke about models, different approaches, and I want just to highlight that the idea of trust, the societal trust in such bodies becomes essential, key. You also finish by recalling this dimension. And then there's a further research topic, which is not only a research topic, also an institutional and normative one, which are the variables that makes a constitutional court, maybe the same constitutional court in different times, more different or resilient, and how to cope with ambivalent position by the same constitutional court, and if the concrete attitude of one specific court can be foreseeable in the future in terms of indicators and variable. At the end of the day, we are talking about the doctrine of constitutional adjudication that a specific constitutional court decided to endorse, more deferent or a more proactive vis-a-vis the political power. Then we hand and clear the picture with the trio, with the Ukraine, Moldova, and Georgia. So I immediately give the floor to Professor Alina Dovan, she's from the University of Trento, where she is a postdoc researcher here, developing a specific research project. Professor, and he also co-organizer of this conference. So Alina Dovan was associate professor at the Ivan Franko National University of Lviv, in Ukraine till 2023, and she worked as a senior researcher in Lviv Laboratory of Human Rights. So thanks, Alina, and the floor is yours.
Thank you, Simona, for presenting me. Dear colleagues, good afternoon. I'm very glad that there is a possibility to discuss issues concerning rule of law from a comparative perspective. Trento Law School is famous for its rich tradition of comparative studies, and the name of Rodolfo Sacco is well known far beyond Italy and Europe. That is why Trento is always a perfect place for discussing different legal issues in a comparative aspect. I would like to thank Professor Jens Welk for accepting the idea of including countries of Eastern Partnership into today's and tomorrow's discussion. I need to say, as a Ukrainian legal scholar, that our region is not always an area of interest in Western Europe, but Eastern direction nowadays is of special importance due to geopolitical situation and, of course, stability. One of the components of which is, of course, constitutional court and rule of law. In the activity of constitutional court is also a guarantee of stability, not only in Eastern Europe, but in the whole European Union in general. This year, there are a lot of challenges before the constitutional courts in all three mentioned countries, Ukraine, Moldova, and Georgia. In Moldova, in September, there will be parliamentary elections. In Georgia, as we all know, there is a continuing crisis because of suspension of negotiation between the EU, Georgia, due to the Russian influence, and in Ukraine, it's a endless war that needs to be stopped, we hope. But from this point of view, of course, constitutional courts, due to its crucial role in the politics, of course, they in all three countries, they will be involved into all these processes. And for us, Venice Commission, its opinions, recommendation is crucial. I remember one of our conversation with Simone, who was very surprised that we pay so much attention to Venice Commission, because of course for Italy it's not so let's say necessary, but for us there is such an organization, Doctors Without Frontiers. For us, Venice Commission is like Lawyers Without Frontiers, because without Venice Commission, I think in all three countries it will be the topic of conference, not rule of law, but rule of law and non-rule of law in Georgia, Moldova, and Ukraine, because due to Venice Commission, it's possible to improve the situation, and they are like pronto soccorso for example, for Ukraine, because without this control, it will be absolutely chaotic situation with the rule of law and improvement of the situation. The topic of my report is politicization of constitutional courts in Georgia, Moldova, and Ukraine. And what about resilience? Is it possible to talk at all about this aspect concerning our three countries? Using classical methods of any comparative research, synchronic, diachronic, it could be said that all three constitutional courts were developed in the same way. It's the same age, because after the dissolution of, after the collapse of Soviet Union, at the same age, at the same year, the new constitutions were adopted in all three countries. The constitutional courts were established, and then in 2022 started this fast-track program of our way to the European Union. So the preconditions, the factors are the same, and the obstacles are the same, because it's a corruption in all three countries, especially within judiciary. It's oligarchic clans who are fighting for the influence on the constitutional court. It's a fragile judiciary because of lack of independence, and its external influence from both sides, from Russia from one side and from the European Union from another, because it's not a secret we're using like a buffer zone, unfortunately, between two major geopolitical actors in this world, and that is why, besides the USA, and of course, all this creates the similar conditions for the functioning of the constitutional courts. As for the Moldova, I would like to start with this country. Before analyzing the situation there, I was sure that Ukraine, in Ukraine there is a worse situation with judicial corruption. No, we are not the worst. Also in Moldova is there a bad situation, really. As for the Moldovan Constitutional Court, to my mind, it could be said that who has an influence on Constitutional Court in Moldova has a power in a country. Contrary to it, in Ukraine, we could say an opposite, that there is a strong political influence on the Constitutional Court. However, in Moldova, it's Constitutional Court by itself that influence significantly the political landscape, and the reason for this is its competences. It's interesting to mention that if to compare the European Commission's opinion on the application of Georgia, Moldova, and Ukraine to the European Union, all of these three opinions were issued in 2022. In Moldovan case, it was written, for me it was unexpectedly, that the Constitutional Court is now independent. So according to opinion of European Commission, everything is perfect in Moldova and its rule of law because Constitutional Court is independent. But it should be stressed that it happened. I'm skeptical. I don't believe that it's so, but okay, we are lawyers. If it's written, we need to admit this fact. And before the 2019, it was a real collapse in Moldova in terms of rule of law. Why? It was created, it was provoked by the Constitutional Court of Moldova. And I found an opinion of former Secretary General of the Council of Europe, Torbjörn Jagland, who published an article in New York Times. Exactly, it was opinion published in 2019, and he, in his article, called Moldova a captured state which must be returned to its citizens. So the situation was really critical. But let's see which are the risks for the politicization. If I decided to use the title of the report, politicization of this court. So about Moldova, what are the risks of politicization? And even if nowadays European Commission wrote that it's independent, where it's possible to open again this Pandora box. It's interesting to notice that in Moldova 2 months ago, in April, a new law on Constitutional Court was adopted. Before there was very intensive work of Venice Commission that produced a lot of opinions concerning the necessity to amend the draft law on Constitutional Court. Unfortunately, in respect to the jurisdiction of the Constitutional Court of Moldova, it was not taken into account. So to my mind, there are strong opinion that the risk of situation could be, there is a strong risk that the situation with this crisis could be repeated. Let's see at the jurisdiction of the Constitutional Court of Moldova, because it's like this, in these details, there are answers why there was this crisis. So this jurisdiction of the Constitutional Court of Moldova is, I can say, even extremely very wide. As for the electoral process, for example, a Constitutional Court shall confirm the results of the referendums, shall confirm the results of the election of the parliament and president, shall determine the circumstances justifying the dissolution of parliament, the dismissal from the office of the president, and shall rule on questions concerning the constitutionality of a political party. All these powers were very effectively used by Moldovan Constitutional Court in order to provoke this crisis in 2019. I would like to give you these examples in order to see how it could be with rule of law outside the EU. For example, in 2016, the Constitutional Court of Moldova ruled that the constitutional amendments made in 2000, so 16 years after, Constitutional Court decided to why not to review. By the way, we also had this situation in Ukraine, so it's not something, maybe it's shocking for Italian lawyers. For us, it's like usual situation. But after 16 years, I mean, it's shocking. But okay, and the Constitutional Court in 2016 ruled that changes made in 2000 were unconstitutional. So they just changed their judgment and changed the way how to elect their president. Then in 2014, it was a famous case with the political party Patria, who was excluded from the participation in the parliamentary elections 3 days before the election. It's interesting because this decision was taken by the Constitutional Court of Moldova when other 5 political parties also demanded the annulment of the results of these elections because of the facts of discrimination and numerous violations. Opposite to it, Constitutional Court used this possibility and confirmed the result of the election. However, later in 2000, the European Court of Human Rights held that the exclusion of this political party, Patria, was a violation of European Convention of Human Rights. Earlier, the Constitutional Court made sometimes, let's say, even strange, odd decisions. For example, in December 1998, it ruled that the majority in parliament is not 51, but 52 deputies out of 101. In 5 years, Constitutional Court decided that no, it was used not good arithmetical rules, and let's check again. And in 2013, it ruled that a majority can also be less than 51 deputies when counted, but they decided to count from the number of those present in sitting. But may you imagine, so it was 1998, then 2013. During this period of time, they just used all these possibilities to decide how the country will live, let's say. In 2017-2018, the Constitutional Court of Moldova also used a very interesting technique. I never heard about it. At least our Constitutional Court is not so creative as Moldavian. And in 2017, the Constitutional Court of Moldova has repeatedly removed the legally elected president from his office for the purpose of signing some laws and decrees by third parties. Then these laws were signed and the powers were again transferred to the president. So for some period it was suspended, then they returned. It's a really very creative technique used by Constitutional Court, and we see that it's especially interesting because according to Constitution of Moldova, there is a principle of rule of law. But we see another colors of rule of law, how it used outside. Venice Commission, of course, has been demonstrating during all these years a golden patience because every year Venice Commission produces till now opinions asking to change the competences of the Moldavian Constitutional Court, but it's the same. So 2 months ago, the new law and the scope of powers are the same. They only changed one nuance, but it's not about these possibilities to influence the political picture in the country. So as we see, this year it will be a new challenge, and I think it would be interesting to see whether the European Commission has yes, was right. it's a process of my Italianization. Yes, was right. And whether it will be drawn into this process of parliamentary election games or not. So I think we will see in September. It will be end of September. It would be interesting to follow. Moving from Moldova to Ukraine. In Ukraine, in our opinion, I mean, in opinion of European Commission's on application for membership, it was not so optimistic European Commission, and of course, in our case, the urgent need of reform of the Constitutional Court of Ukraine in line with the recommendations of the Venice Commission was put at the first recommendation. So the first step should be done, done by Ukrainian authorities is to change something with the Constitutional Court. In 2016, a comprehensive reform of constitutional provisions on judiciary in general was started in Ukraine. The aim of it is, because it's still on, this reform, is to establish an independent judiciary. However, we Ukrainian lawyers, we are not so optimistic as our European colleagues. They are still optimistic, even we can say they are still naive, thinking that they can fight the judiciary corruption in Ukraine. We have already lost this hope, but let's see, maybe someone will take this courage to do something. So what is new in Ukraine and what is very interesting, it's really unique. We have absolutely another problem. It's not about powers. Our law is very good from the point of view of legislative technique. It's very easy to read. It's perfect in terms of that you have very good legal framework. Our problem is the selection procedure of judges. And why we have now a very unique mechanism of the selection of judges. It's unique because they're selected not by Ukrainians, they're selected they decided just if you cannot do it inside, we will help you from outside. And we have such a procedure that there are 18 judges in the Constitutional Court of Ukraine. They are elected for a 9-year term. 6 of them are elected by president, 6 by parliament, and 6 by Congress of Judges. What is new? Venice Commission recommended us to create an international component into this procedure. How it works? There is an advisory group of experts composed of 6 experts. One of them is appointed by president, another by parliament, one by Congress of Judges, and 3 external experts. One is appointed by the Venice Commission. Professor Sukhotska is a member, and 2 of them, 2 also international experts, they are appointed by the recommendation of international organizations which provide technical support for the reforms in Ukraine. And the first meeting of this advisory group of experts was in 2023. During 2024, they managed to select 2 new judges. One of them we are proud from my law faculty, and maybe for Italy it's not so traditional because it's rather young. I mean, for us it's like a middle age. He's 42, but I think for Italian reality, it's a rather young person. And but we are proud that there is finally a representative of academics inside this political institution.
I'm 42. I'm not middle-aged.
Yeah. Okay. We have another perception of age. Yes. And What about this procedure? It's very difficult from one point of view. Why? Because, for example, this January, there were only 11 judges of 18. Quorum is 12. So the work of the Constitutional Court of Ukraine is blocked. Before the start of the work of this advisory group of experts, there was a hot debate in the society, even in the whole country, what to do with our Constitutional Court. Even there were a lot of opinions of lawyers that we need to delete this body from our system. Why? Because unfortunately, they are not so effective as in all other neighboring countries. For example, during 2023, it was only one judgment from the Constitutional Court. Then it was a problem that it's very costly. I don't know how in other countries, but for example, there was an information because it's very transparent. If you may request, the immediately sent you an answer about the cost of the Constitutional Court, for example, for our budget last year, and it's a war in the country. Our Constitutional Court costed for our taxpayers $8 million in 1 year. And many experts consider it too expensive to have such a Constitutional Court, which doesn't work, in fact, but we just have it. But nevertheless, now there is still a procedure of selection of judges, and it's about Ukraine and Moldova, and only a few words about Georgia. As for Georgia, I looked through most of the opinions of Venice Commission concerning Georgia. Honestly, I didn't manage to find an opinion devoted solely to the Constitutional Court of Georgia. And in what is interesting in opinion of on application of Georgia for membership to the European Union, it was not mentioned. It was not mentioned at all. About Moldova, it was written it's independent. About Ukraine, it's needed to be changed, or yes. And about Georgia, absolutely nothing. As we know, it's a not stable situation in Georgia, and of course, Georgian Constitutional Court also will be involved into all these political games in Georgia because of influence of Russia, unfortunately. But in general, it's the main thesis concerning the situation in these 3 countries. Thank you for your attention.
Thank you. Thank you, Alina. You definitely unpacked even more the idea and the content of and the perspective from which to understand the idea of rule of law and also the role and function of constitutional courts. And it reminds me the idea of Constitutional Court as counter-majoritarian body, but now it must also be effective. No? So thank you again. No, so it's 7:10. We have still some minutes for the discussant. So I immediately give the floor to Pietro Faraguna. He is Associate Professor of Constitutional Law at the University of Trieste, and he is currently serve as a law clerk at the Italian Constitutional Court. So he has a privileged point of view for analyzing all we discussed this afternoon. Thanks again, and the floor is yours.
Thank you very much for the invitation. Thank you, Alina. Jens and Simone. I will try to help the organizer. Since we are running late, I will be very short, but it is always a pleasure to be here in Trento. And I have to say that, I mean, the organization is always perfect. And I was very impressed by the fact that, I mean, you knew before everybody of the general strike and you avoided me like finding it out tomorrow at the train station. So thank you very much for that. So I have the simple role of the discussant, and it is a very easy role because there is so much to discuss here. So I will perform my role as a traditional discussant, let's say. Just in a few points, I mean, these are like a bit fragmented. So first of all, I think that with this very broad general overview, comparative overview, we find out once again that the Italian constitutional and political and institutional experience is really an amazing laboratory for the degeneration of democracy and constitutionalism. I think that, I mean, the close and far past shows us that, I mean, many sources of degeneration has proved very successful in Italian history. I'm referring to fascism, but somehow in the years of Trumpism, I mean, I think that we have experienced under the years of the Berlusconi's government something connected with this kind of transformation of institutional balances. One first point is the fact that, I mean, Tanya mentioned the fact that democratic erosion is many times an erosion of the rule of law. And I mean, the point is that probably it depends on what we conceive with democracy. And you mentioned that, I mean, if we consider democracy constitutional democracy, then of course the erosion is connected with the constitutional part of the constitutional democracy. And today, probably this is something that we should focus more on. Also because political actors, I think that it is their role to try to be unbound. So they push in the way of getting power, because I mean, this is the role of any kind of power. And of course, this is the role of political powers. And I mean, they need to find a safeguard, a protection, I mean, a counter force, a counterbalance. And this is the idea of constitutional democracies and checks and balances. So probably the point is that in many countries, checks and balances are not working properly. So it is not the responsibility of political actors. Political actors are doing what they are doing in a whole history. They are trying to get power. And so probably the point is that checks and balances are not working as they should. And probably this is counterintuitive for lawyers and for lawyers connected to courts. I mean, we have trust on courts and we think that courts work much better than political actors. So probably this is also true, but if we look at this interaction in this way, I mean, we should probably identify the problems in the checks and balances and not in political actors, which are like performing what it is completely normal that they perform. It is, I think, very interesting and somehow dangerous the way of designing our discourse by emphasizing the role of legal culture, as Constance did. I mean, it is amazing. Of course, it is a huge impact. But then I think this impact of the legal culture is open to be translated into legal terms. And I think that this kind of translation within the European discourse passed through this idea of national identities. So now, is national identity a constitutional commitment, or is this a pre-constitutional, pre-legal commitment? I mean, in the defense of many Central and Eastern European countries in the rule of law crisis, national identity played a big role. And I mean, this role is connected also with the legal culture, and it is not easy to measure that. And I think that it is very risky to have a double standard. It is interesting to contrast the competences and jurisdictions of constitutional courts, as Halina described in Moldova, Georgia, and Ukraine in the Trittico, with the jurisdiction of the Italian Constitutional Court on the political process. I'm not sure that the design of the Italian Constitutional Court would be assessed in a positive way. If we look at it, I mean, just on paper, and I mean, I think this is an important point of like looking at the rule of law in the books and looking at the rule of law in action, as Constance did in her presentation. I mean, there is a very weak and poor competence as for the control of the integrity of the political process in the Italian constitutional system. So there used to be like a shadow zone of constitutional compatibility as for the whole electoral process. And I mean, this has changed in the latest 10 years, but still nowadays it is one of the few countries where, I mean, the validity of the election of the single MP is assessed by the parliament itself with no judicial control. And I mean, the same is true also with regard to the integrity of the legislative process. I mean, and this is, I think, an interesting point. Of course, public trust is important, and probably public trust is important also in the sense that constitutional courts need some kind of ambivalence because they need to protect their same existence. And I mean, probably this requires also taking incoherent decisions according to the specific historic moment. And there is a huge risk of backlash nowadays, and this risk may turn into constitutional amendments, changing the role of courts, and of course this is not what we are looking for. So there is a big risk of building a perfect institutional designs on paper that then it is an institutional design that doesn't work in practice. It was very interesting, the description you did of the composition of the Constitutional Court, which is like, I think we all, I mean, Italian scholars have recognized like huge similarities with the Italian system, but with this kind of like European committee. I mean, it looks like as the committee for the appointment in European jurisdiction. And I think that this could be a matter for workability of the system. And it is something that, I mean, we also experienced in the parliamentary appointment of constitutional courts judges. The point, just to conclude, concerning age in courts, just because, I mean, I'm happy to self-identify myself as a middle-aged man. Moreover, I feel myself, I mean, I feel I'm ready to retire. So I think I've given a lot in this country, and it is enough, and I can, this could be the moment. But I mean, it is not just a matter of self-perception. I think it's also an institutional perception, because I mean, and I was always very impressed by if you look at the picture of any kind of constitutional court in Central, Eastern, Far East Europe, I mean, it is very impressive from our perspective of Italian scholars. But I think this is also connected with the fact that, I mean, in a country changing, I mean, approaching a transformation, you cannot pick constitutional judges from a generation which is educated under a completely different legal scenario. And so probably this is not true anymore in countries where, I mean, the conservative role of constitutional courts could be also played by people who are of a different age. But I mean, I think it's an interesting point. Thank you very much.
Thank you. Thank you. Thanks, Pietro. So I look Jens because we have 11 minutes to to get out before the lock-in now. But I think we have time for a quick response for each of the speakers. Yeah.
Okay.
We will have more time. But
Thank you. Just a quick, very quick reaction, especially as it was so interesting what Constance said about this role of legal culture and how difficult it is to capture by using only legal indicators the reality of those courts. And for example, I checked now the Venice Commission checklist that the checklist doesn't mention interpretation or I still have to check better the use of precedent because, for example, this lack of continuity and the overruling, the frequent overruling undermine the rule of law. For this reason, I think, although Piero said that it can be risky to include in a checklist or in some indicators also extra legal aspects. But I think, if I'm right, but we will see in the next months, as in October, Venice Commission will present the updated checklist that will be approved in December according to the schedule. But as far as I remember, Anna is not here and probably or tomorrow, but I think that one of the aspects they would like to amend is also to find a way to capture some factual aspects. And this was also one of the points of Kim Lane Scheppel discussion about the role of indicators, how we can measure backsliding. Then I think this is an interesting point to be developed. Thank you.
Just some words very briefly. I have emphasized this point on legal culture because of my experience. I experience very textual interpretations and I know what it means. And is completely changing the spirit of a constitution if you interpret it like that. So it's not law on paper, but it's really law in action to distinguish depending on the legal culture. And I saw what the different courts made with, for instance, the case law of the European Court of Human Rights. And if you analyze the Serbian case law on this convention, it's troubling because you don't recognize the European Convention on Human Rights. It's another text. So I'm sorry, but I think it is quite relevant to make this point.
I like very much that proposal of Professor Groppi about the necessity to elaborate operational toolkit in order to understand how it's possible to proceed. But at the same time, I was thinking whether it's possible to work out the same rules for every country. Taking also into consideration legal culture, for example, because what would be good, effective, for example, for Italian Corte Costituzionale, I have a very strong doubts that it would be possible to use in Hungary, in Moldova, in, for example, Azerbaijan. So, of course, it depends on the situation, but of course, it's needed. It's necessary, but how to do it this is a challenge. And also my remark about legal culture. Thank you, Pietro, for, as always, very profound analysis. Thank you very much of our presentations. As for the legal culture, I need to say that I support the position of Professor Gravet, because if, for example, to use if to imagine that we would be given a task, for example, to see how the same case would be solved by, for example, constitutional courts of Italy, for example, Spain, for example, Serbia, Georgia, for example, Azerbaijan, I'm sure that it will be different, even if using the same, for example, if the same international standards, but the response will be absolutely different. Because also of legal culture, because most of our judges, for example, in our constitutional court, they were trained, of course, in Soviet periods of time. They have this legal consciousness. For example, in Ukraine, until 1996, the principle of rule of law was absolutely unknown. It was not. It was not used. It didn't exist at all. I mean, it's difficult to tell about legal culture because, of course, it was legal culture before 1996 because we existed. Yeah, and I need to say very even good. Why not? Yes, but I mean, it's a question, and I need to support the position that legal culture is a crucial element because it defines the answers of the constitutional courts to what they need to do. Thank you. But it's for the next meeting, for the next conference. An idea.
For tomorrow.
Also,
Yeah, because thank you. But probably after tomorrow, after the third session, we will have time also to discuss and develop what we learn today. So thank you, all of you. So we will convene again tomorrow morning at 9. Okay.
Buongiorno a tutte e a tutti. We will switch to English, and we welcome also who is connected online as we are in streaming. This is also to remind you that this is a recorded meeting. So if there's any problem with privacy issues and so on, you need to say it now. And the plan this morning is to focus on the institutional independence of the judiciary, which is, as we know, in many countries, in particular in the countries which two panels are about, the Western Balkans and the so-called trio area, usually meaning judicial councils, very often in the plural form. There's one notable exception, which we will hear about also today, which is in particular Bosnia and Herzegovina, which has a joint council of prosecutors and judges. What we want to do is today to look at the self-governance side of the rule of law, of the judiciary within the rule of law principle. So the idea that an independent judiciary also requires an independent administration and self-governance as a separate branch of government, as we have said also yesterday. And the question is how this is done within the EU, what are the common principles, and then to look again, like we did yesterday with the constitutional courts and also in general into the two geographical areas. This will take us some time, but we have very interesting speakers here for addressing these topics. And after this, in the second half of the morning, we will dedicate, as we said yesterday, time for discussion. Now I'm looking for something. Time to discussion. I already ask you to think of, but probably you have done already, to think of the issues you want to raise afterwards, because we have left deliberately some time for discussion in order also to have a confrontation among us. So I am happy to introduce the speakers. First, Professor Frans van Dijk, who is Emeritus of Empirical Analysis and of Legal Systems at Utrecht University, and has a research interest specifically in the characteristics and performance of legal systems from the perspective of the value of the rule of law, but also from the perspective of promoting a peaceful and affluent society. He participates in the work of the ENCJ, the European Network of Councils of the Judiciary, on judicial reform and on independence and accountability, and is co-author of many reports. We have met in Bosnia-Herzegovina in one of his missions to the council there. He's also actually still involved in a trilateral cooperation between the AJPC in Bosnia-Herzegovina, the Norwegian court administration, and also the Dutch Council for the Judiciary. And actually, he's also an expert very much he's an academic, but also an expert from the inside, because he actually has been director of the Netherlands Council for the Judiciary. And his difficult task is now to give us an overview over the issue of judicial self-governance and the related principles. And please take the floor, Frans van Dijk. Thank you.
Okay, after these friendly words, I hardly dare to speak anymore. The organizers actually put a question on the table, how to make the rule of law principle concrete, operational, and how to assess it. So that seems to be very exact what you expect from me. And so I'm focusing here on the governance side of matters. But to assess something, you need standards. And the question, of course, is, do these standards exist on governance? And finally, how does the governance of the judiciary affect judicial independence? Now, these are probably quite difficult questions, but let me start. So the governance model of the judiciary, in Europe, there is a wide variety of governance models. The historic starting point, I think, for all countries, more or less, is that judges were facilitated to do their job, a sort of hotel system, and everything was taken care of by the executive, Ministry of Justice. UK is an interesting example where judges even have at least some judges have their own courtroom with their name on it. So that's a real hotel system. Now, still it lives on, so the management of the courts is in some countries still in the hands of the Ministry of Justice. Italy is probably one of the most interesting examples in this regard. And the Netherlands before 2001, before a council was instituted. Now have taken place different developments all over Europe, such as councils for the judiciary. There's a very divergence of tasks. There are boards for specific tasks, for instance, the selection and appointment of judges. There are autonomous court administrations. So that's more what you could call an agency model. Scandinavia is doing that, with Scandinavia shifting towards councils for the judiciary. And what you also see is very different levels of decentralization. So there are countries where many tasks are done by a council, but there are also countries where actually the courts have all these responsibilities. So this is difficult to capture all these differences. So there is no common model. However, I think there is an enlargement model, a model that applies to the countries that became part or are in the process of becoming part of the Union. So if you look at these differences, and I'm going back, of course, to the enlargement model. But first, you have to look at the tasks that need to be fulfilled. So who decides what about the judiciary? And then the standards that apply to the bodies that are mandated to undertake these tasks. And finally, is there accountability about the performance of these tasks? So having tasks is nice, having standards is nice, but does it work in practice? Again, more questions. Now this is an overview of the tasks that need to be fulfilled. And it's actually from this European network of councils for judiciary. By the way, also countries like Germany and Austria participate in this work, despite the fact that they don't have a council. So to the left, you see these tasks. Well, probably the most important one is the appointment and promotion decisions about magistrates. I'm going to focus on judges. So the human resource aspect. This includes also training of magistrates, discipline, judicial ethics, dealing with complaints against the judiciary. And these tasks are, for instance, largely in the preview of the Italian Council for the Judiciary. There are two councils, by the way, in Italy, as you all know, but I'm focusing now. It doesn't matter that much a difference. But then there are other aspects, tasks that have to be fulfilled. And one is the performance management of the judiciary. That's a bit business speak, but it probably has to do with duration of cases, the quality of how cases are handled, probably one of the most crucial elements. Then there is the administration of courts, finance of the courts, and proposing legislation concerning the courts and the judiciary. So in many countries, when there are new laws prepared that affect the judiciary has can advise the government and even go further, ask for certain changes of the relevant laws. Now, I put here some of the examples of Denmark and Italy. So you see that there are different ways of solving problems. So all these tasks have to be fulfilled. Now, you can do it with a council for judiciary, but you can also have other bodies with decisive influence of judges. So then you're still independent, the governance, but you can also have sort of bodies where judges are in a minority or there are no judges involved. So other is often just the Ministry of Justice who can decide matters concerning the judiciary. And what you see here, the difference between Denmark is in Denmark, they do the appointment of promotion of magistrates, but there are also tasks like discipline, which are put in a different body and not the council. Italy, on the other hand, has essentially these tasks at the council, except for the training of magistrates, which I think is very strange to have that in a different way. But anyway, that's irrelevant what I think about it. And you see that Italy then drops out when it comes to the administration of the courts, finance, all these more matters of managing the judiciary. And Denmark obviously does these tasks through the council. So there are these, what they might call a sort of southern model and a northern model, but that's probably simplifying too much. Now, if you have these tasks, then there are standards for councils for judiciary. So if you have a council, then certain standards should apply. And well, the first one is not really standards, but its position of the council should be guaranteed in the constitution, which is, for instance, the case in Italy, but not in Denmark. And probably the most important one is that at least 50% of the members of the council are judges who are chosen by their peers. So that's the standard that's also taken up by other international bodies. So these judicial members represent the whole judiciary, so they shouldn't be taken only from, for instance, the Supreme Court, but they should reflect the different tiers. Former members of government shouldn't be a member of the council, former or present members of government, but also former members of parliament are not a member of the council. And then there are also governance issues like the council should control its own finances. So if you want to spend something, but you have to go back to the Ministry of Justice, there is no big success. But it's still the case in some countries. And of course, the council should be able to hire its own staff. Because the way of influencing, which we currently see proposed in new law in Bosnia, is that they tried to get the Ministry of Justice to get influence on the Secretariat by trying to appoint the director of the council. On finance, and it should also be able to determine its own activities. Now, what you basically see is Denmark scores quite well, Italy in a sense also, but except for the members of government and members of parliament. And now, how would the enlargement model of your judicial governance looks like? And this model applies not only for new applicants, but also for the old ones, like Romania, Lithuania, we all have them. So the first element is that there is a council for the judiciary. So we saw that all these differences, like in Germany doesn't have a council, but has also a workable model where the independence of the judiciary is, I think, also guaranteed, but that's a different method. But in the enlargement model, I would say there is a council for judiciary to separate the powers of the state. It's also difficult to see what kind of other solution would be available. This council has a broad mandate covering nearly all the tasks that need to be fulfilled. And that's a more recent development. There is an increasing focus on information technology. And that's in particular driven by AI applications. So because of AI applications are being thought about, it becomes very close to the judges themselves. So it's not just administration, it's how you do your cases. The funding of the judiciary is in this model still under discussion often. So that's one of the most painful things, is apparently for politicians to let go of financial aspects. So how the courts are funded and how the finances are managed is difficult to let go for politicians. And we see that there is this general rule of members elected by their peers in this model. And I should say that this model is also close to current ideas about the governance of public agencies. For instance, if I may call a national central bank a public agency, it also has independent status, and let's say the same aspects as I discussed here are there also, and often stronger, strangely enough, than for the judiciary. Now, just an example, Romania, all the tasks, actually everything is in the brief of the council, except the funding of the judiciary, and there, of course, discussion about that. And the standards are completely adhered to. So they're playing the game fully to the with regard to this enlargement model. You find it the same in Bulgaria. For instance, in Lithuania, they're also at this in this method. And Bosnia and Herzegovina, as you already mentioned, is also an interesting case, which I happen to know a bit better. That's one of the most broad and powerful councils for the judiciary in Europe. And I think Croatia is on the a bit in the same model. Now, there is this difference between de jure independence and de facto, and the question is, does it work? Now, my empirical background comes up, so I'm going to show you some graphs, figures about the data, what we know about it, and there's a distinction. There is a survey, I'll show you, the perceived independence by citizens. That's a survey done by the so-called Eurobarometer of the European Commission. And it asks essentially the question, how do you rate the justice system in terms of the independence of the courts and the judges? Would you say it's very good, fairly good, very bad, or fairly bad or very bad? And green gives you the percentages of good. And we see a huge difference in Europe. It's on the left hand Denmark, on the right side Croatia. And I must say that independence and trust are very closely related. So perception of independence is, in the eyes of many citizens, more or less the same as their trust in the judiciary. Well, we can see here, of course, we don't know what's the truth here, if there is any truth, but we must be aware how citizens perceive independence. Well, that's also in the case law of the international European courts, the relevance that a court shouldn't only be independent, but it should also be perceived to be independent. It's a crucial aspect. And we see here these big differences. What's also striking here is that the difference between, let's say, old and new members, the West, South, and on the other hand, East, is becoming smaller. So countries like the Baltic states are moving up the list and are getting intermingled with other countries. I'd like to point out, for instance, that Spain and Italy also have very low scores on perceived independence. So that's one. And the other is a big survey of the ENCJ, so this European network, among the judges of Europe. And actually nearly all countries participated, all judiciaries, even the UK in 3 of its forms. So England and Wales, Northern Ireland, Scotland. Might not be that good an idea, actually. But anyway, and Ukraine and Moldova participated for the first time. They were allowed because they are now in this enlargement process. Bosnia is also taking part, etc. Now, what we see here is how do judges see their own independence, and it's a score between 0, a very low independence, to 10, and it's this question is not about my own independence, but how I see the independence of all the judges in my country. Now, finally, what you see here is that actually the results are quite, generally speaking, quite good. So the judges in the field score their independence and of their colleagues quite high. With the addition of Ukraine, we added a country at the bottom. So Ukraine is well below the independence levels of other countries. Relatively low scores for Bosnia-Herzegovina, Bulgaria, but also Montenegro showed a decline. Hungary, of course, is declining. But what is striking, of course, is the big difference between how the citizens see it perceive independence and how judges themselves see it. And that's also quite an important lesson for the judges, that their own views might not be shared by the citizens. But if, so the next step here is that how do they see the independence of counsels for the judiciary? And that was actually the question that's on the table. And of course, judges are more critical about that. With very low scores. So out of the score between 0 and 10, you could say, well, the 5 is in the neighborhood of sufficient. We find that the independence of the council in Spain is always very low. And that, of course, has a lot to do with the local situation where the selection of the members of the council was taken over. Was first, they were elected by the judges, but that was taken over by Parliament. And now it's under a change in the law is underway, but I'm not entirely sure how this works out given the political issues in Spain. But also Bulgaria has a very low score. And in this respect, Ukraine, yeah, well, I think what you see could be better. Let's put it that way. Throwing light on this matter is also a question in the survey. This is a different type. So the question is, so during the last 3 years, my independence as a judge has been respected by the Council for the Judiciary. And this question is actually asked in this survey, which, by the way, you can find on the website of the ENCJ if you're interested. Red is the percentage of the respondents, the judges, that feel that their independence is not respected by the council. And what you generally see here is that the independence of the council, of the respect they show the judges for their independence is generally quite well. So the red percent, the reds here are relatively small, with, of course, in Hungary, there is a decline of nearly everything. Also this, in this regard. So that's positive, and you should compare it with with the question, so my independence as a judge has been respected by the government. Well, many judges in Europe feel that that is not the case, that their independence is not respected. Not surprisingly, Hungary jumps out with nearly, yeah, hardly, what is it, 20% in green. Most judges in Hungary, not surprisingly, are very unsatisfied with the government. But you see these bad scores in a lot of countries. Spain, Slovakia. No, Slovakia actually quite well. Slovenia, I would say. So what can you conclude from this? So what you see, perceived judicial independence varies widely. And if you look at the citizens, and seems not to be simply related to the governance model. So I showed that at the high end, Denmark, it has a council. At the low end, there is Croatia, has also a council. So having a council is not sufficient. Well, that may not come as a surprise, but so a council as such doesn't guarantee judicial independence. And the most direct comparison, I feel, is between Romania and Bulgaria, where Romania is in all respects scoring quite well, and Bulgaria is scoring quite low. The counterfactual, of course, can you organize it in a better way? In the sense, if you would leave it at the Ministry of Justice, you're going nowhere, because the last point we saw that judges feel that their independence is much more respected by the council than by government. So this counterfactual is probably not a solution unless you do it in a situation where the relations are stable, like in Germany. Although judges in Germany feel that there should be a council as well. So these are the findings so far. Now, I like these graphs. I'm going to bother you still a bit more. So I would like to look at the fulfillment of specific tasks. And typical responsibilities of councils are the selection and promotion of judges. And are they doing this in a good way, according to the judges? Mechanisms against judicial misconduct, corruption, are they in place? And this difficult joint responsibility of council and executive on finance, how does that work, caseload and resources? Now, let me show you. I take one of them. Could also show you how people think about the independence of the selection of Supreme Court judges. But this shows you that judges in my country have been promoted or appointed other than on the basis of ability and experience during the last 3 years. Of course, the typical judicial formulation of a question with the double negation, but so that is bad, not only on merit. And here we see that judges are often quite critical. And the worst situation, of course, is happening in Hungary. But in many countries, and also, for instance, in Germany, the scores are well, the conclusion is that judges are quite critical about how this occurs. And let me see, we're in Italy. Italy is also not positive. Let's face it. It's close to 50% of the judges feel that it's not entirely based on merit, but there may be historical events taking place that color this, if I recollect correctly. So the lesson here, especially for this network, is that councils should shape up, should do a better job on these matters, and be more transparent and be more, try to convince the judges of their performance. Well, this is judicial misconduct is appropriately addressed by the judicial authorities. Well, it's less bad than these appointments, but still it's quite critical. And here countries pop up like France with relatively low scores. And well, I'm not going to 5 minutes, more than enough. Judicial corruption is effectively addressed by the judicial authorities. And what we see here is that Bosnia, Bulgaria, Croatia stand out in a negative way. Well, and then finally, caseload. So what do judges feel about a caseload? Now, you can expect that they're not happy in general, but caseload is probably one of the worst, and it's getting worse. So if you compare it with previous surveys on this matter, so this is the 5th time that it took place, the issue of caseload funding is become more and more of an issue. And for instance, what happened in Montenegro, so they went really down in many respects, but this is probably one of their worst scores. But you see again, well, this is very widespread. And only Denmark and the Netherlands, perhaps Ireland, with their objective funding systems, survive the judgment of the judges. I should say that I didn't include it, but there are currently also a lot of issues concerning the pay of judges. So this is becoming, it's handled in a very political way in Hungary, where judges' salaries have been lagging behind inflation. And they play it out, well, we can give you more salary, but then you have to agree with certain amendments to the law, which regulates the council. So that's also, so you see to some extent that the classic discussion on independence is a bit shifting towards these resource matters and pay and these sort of matters. Right. Well, if you want to, am I still?
Yeah, no. You were just
joking here.
No.
These statistics are interesting, but probably you have to dig deeper. And this, for instance, happened recently in Bosnia on our suggestion. They did an external review of the functioning of the HEPC. And I think this going deep into the functioning of a council can be very useful, but it can also be painful. And I think it was quite painful. So what you, for instance, saw in Bosnia, that they're focusing entirely on appointment and discipline. And so the management and the improvement of the judiciary and reducing duration of cases is really not really taking up very strongly. And an aspect of this election of peers, by their peers, is that the members tend to promote the interest of the courts that elected them. And especially if they would go for a second term, then of course they can be heavily influenced to promote the interest of their own courts. So taking responsibility not for your court, but for the whole of the judiciary is an issue. And probably in this world of legal people, there is a need for strategy. So what are your goals? What do you want to achieve for the whole judiciary? Now, conclusions. So the governance of the judiciary is evolving in a variety of ways. There's from a historic model that doesn't allow for the separation of state powers and is outdated anyway. Second, there is a model of judicial governments that has been applied in new members of the EU. So based on this Council for Judiciary, this broad mandate, and I think the EU on the ground, these delegations are really have been pushing quite hard in this direction. This is the model they actually ask countries to introduce, and actually I think they are doing it. But I showed you that within this model, perceived independence varies. There are ways to, as I showed you in the surveys, that you can assess de facto independence. Of course, it's a second best solution. It's not easy to measure de facto independence if you know the literature, but you probably should dig deeper and do more qualitative analysis, such as an external review. Now, I think this enlargement model, while imperfect, seems to be the best solution. I don't see other solutions, but you shouldn't take as given that once you have a council, everybody lives happy forever. Well, that's it, actually. Thank you for your attention.
Thank you very much for your in-depth presentation of and also the distinction you just made, also repeated just at the end with the enlargement model, which is very topical, of course, for the two geographical areas we want to focus on. I think also the slide before the conclusions, this distinction between the classic safeguarding functions, focusing on appointment and discipline, and the more strategic functions is very important in an environment where you have to think of the transformation of the judiciary, but also of society more in general, and what we are talking about in the capacity, the strategic capacities, which you mentioned. I think this might be also something we can discuss again. And also what I want to say, which for us lawyers, and of course you're included, is sometimes a bit strange to work with these surveys, but as far as I know, these surveys have also become a kind of benchmark, even in the enlargement process, in order to have a kind of counterweight to more technical indicators and parameters. And so the idea of looking into how justice is perceived, but also what is corruption, what is the own perception of judges. So to put these together, I think this was to have an empirical basis also. I think this is very, very important, and thank you for illustrating us. I now have the pleasure to introduce Gianluigi Pratola, and we were not joking, we were just making reference to a common mission we had in another area, in Lebanon concretely. Gianluigi is a magistrate, currently prosecutor at the Italian Court of Cassation. He also wrote how many years he's already a magistrate, so many more than you would think. He has experiences in both fields, in civil and criminal matters, in different levels of Italian courts and also Italian regions. He's the former general secretary of the Italian School of the Judiciary and also former member of the Study and Research Office and Secretariat of the Italian High Judicial Council. He also worked at which is very interesting also for many countries, at the Massimario office, so the office which summarizes basically the judgments, also for official communications. And also, and this is also why I asked him, I have got to know him on various missions. He has more than 20 years of experience in international and EU-funded projects in the Balkans. In particular, practically there are all of them, excluding Bosnia, exactly. And then Egypt, Lebanon, Tunisia, Armenia. So there is a rich experience also in the field, and we have asked him, or I have asked him, to talk about the Western Balkans area. Please take the floor.
Thank you, Jens, and thank you for the invitation in this Congress. It's very interesting and very important to focus on some subjects that are also very actual in discussion also in our because we are in Italy, also in Italy in this moment, because with the government there is this fight with the judge, with the magistrates just for the organization of judiciary in the view of guaranteeing independence of the judiciary. And the problem is always not only the internal independence, but also the external independence of the judiciary. The fight is always, but if you contest our organization, means that you want to interfere in our organization on one side, and on the other side, sometimes the self-protection means that you don't want you to interfere with my, way of managing the situation, even where this managing is not perfectly in compliance with the standards or with the we can say the correctness of the activity. So it's sometimes the border is very difficult. What Professor said before is that it's very important. Every country has his tradition, as his way of organization, as his mentality. This is the thing that I understood in all these years of activities. And you cannot analyze properly the situation of the country if you don't enter a bit in the mentality and the tradition, historical situation of the country, the steps only with this kind of analyzing you can you understand how it works specifically and how is possible to suggest some correction. And also, for example, also with the Italian system, because I want to compare because we talk about it, and we can say that the system is, as it is now, is very, very interesting, and in my opinion, is a perfect balance among the powers to guarantee the separation of powers. On the other side, and now we enter in the Italian mentality and the Italian management of the situation. There are situations where, notwithstanding this, we can say with construction of the constitution, of the law, that is, in my opinion, really, really interesting. I can say that probably is the model more advanced in Europe. On the other side, there are situations where the interference, for example, of the we hear around the correnti of the magistratura, the correnti della magistratura that interfere sometimes in the activity of promotion of magistrate, and so they act. The High Council of Justice sometimes act not perfectly, we can say, according the merit criteria and a good, we can say, practice of acting. So this is the way that you can have on the paper the best system in the world, but we have to verify how the system is managed. This is the basis also to speak of Albania, because of Balkan countries of Albania. But just to clarify, what are what is the approach? First of all, the Judicial Council, coming a bit more in the method, in the task that I have, that it was assigned to me. The Judicial Councils obviously are a guarantee of the self-governing, and are the self-governing body of the magistrate, and they should guarantee the independence of the judiciary from the other state powers. There are a lot of principles of independence that focus just on the activity of the Council of Judges, and I don't want to. I recall, but I write something in after this. This meeting, and probably I will be more precise, but the only thing that I want to say that among these principles, for example, the European Charter of the Statute of Judges, for example, is one of the, we can say, European act or of the decision or of at a European level, point out just the independence and impartiality of the judges through several topics. There are selection, recruitment, initial training, appointment, removability, career development. These are the key points that must belong to the Council of Judiciary to guarantee the independence of judges. But we have also to consider another aspect. We are talking about Council of Judges or judicial councils. We know that there are countries where there is a judicial council, like in Italy, for example, that manage judges and prosecutors. There are other countries where there are two different councils that manage judges, one council, and prosecutor, other councils. There are countries where there are no council of judiciary, and for example, in Germany, where the independence is guaranteed in another way. Now in Italy, as you know, there is a discussion if we must pass to a system with a judicial and prosecutorial council, or we have to keep the council together. the problem of prosecutor, I say, is a problem that regards also, I want to say, the independence of justice. So we are not talking about necessarily of the independence of judges, but we have to pass to independence of judges, of justice. The independence of judges must be guaranteed also with the independence of the prosecutorial system, because a system where the prosecutors are not independent obviously affects also the independence of justice system in general, because there are also here some principle statute also at European, at the international European level, where they design the activity of prosecutor as that must be independent. What are the main principles of the independent activity of prosecutor? The main principle is, first of all, to be correct in the investigation. So the prosecutor mustn't take evidences against the procedural law. Must not go away with an investigation when they realize that the material that they have are not enough to proceed. Must respect the rights of the convicted person, but also of the witnesses, but also the victims of the right. And so they must conduct an independent investigation. An independent investigation with the only scope to arrive to the truth, to a, we can say, processual truth, because as we know in the judiciary, we cannot reach the real truth, but we have to, we arrive to a processual truth that should be as much as possible the same of the real truth. But as we know, we are humans, and the investigation are a human activity. So unfortunately, not always, it doesn't happen in always that we arrive to the truth, but we arrive to a process that affirm the decision according the investigation taken. In the Balkan countries, coming to our, in the Balkan countries, this is, I wanted to say, because in the Balkan countries, this is, and this was, especially in the past, a big problem. Because the Balkan countries come from a communist period where, on one side, the judges were, we can say, corrupted, they were influenced by the political power, but in particular, the prosecutorial service was in the hands of the political power. In the Balkan countries, in particular, there was a very strong police. The police, depending from the government, that was very free in the investigation, and they didn't accept to be influenced by the prosecutor. So they had an autonomy, complete autonomy in performing the investigation. And the prosecutor was very weak in the communist period, because there was a prevalence of the strength of the authority of the police in starting and in conducting the investigation. Passing from the communist period to a democratic period, there was the figure of prosecutor was a bit disoriented, because on one side it was set up in almost all the countries a stronger figure of prosecutor. Especially a stronger figure of general prosecutor, that is the head of the prosecutor of the countries. There are small countries where, so the general prosecutor, very strong general prosecutor, at the end controls all the investigation of the country. It's very different from our countries where they are bigger and it's not possible. But when we passed to this system, the general prosecutor was too strong. First of all, the general prosecutor was nominated by the parliament and so it was very close to the political power. On the other side, there was this general prosecutor that controlled all the activities of prosecutors and had also the power to advocate the investigation of the prosecutor. So you can see that the investigation was at the end, could be at the end manipulated by the head of the prosecutor that was very connected with the political power. So the situation didn't change too much. And at the end, was the next step was to, first of all, to keep out from the parliament the power of nomination of the prosecutor, because just to stop this liaison with the political power. On the other side, was to guarantee that not only this external independence of the prosecutor, but also the internal independence of the prosecutor. So the possibility of the prosecutor to perform the investigation in an independent way without being influenced by the head of the office. This also in European countries, there is this difference in some countries where the prosecutorial service is hierarchical, or the prosecutorial service is less hierarchical, there is more independent of prosecutors. But the step that it was felt as necessary was to guarantee also this internal independence by prosecutor. And the institution of the Council of Prosecutor was basically the solution to guarantee that all the decisions regarding the career of prosecution, starting from the general prosecution, pass to an independent self-government institution like the Council of Prosecutors. This happened in several Balkan countries, and especially in Albania, where now there is a Council of Prosecutor that nominated the general prosecutor and the head of prosecution offices, and this is on the paper the guarantee of the independence of the prosecution activities. In Albania in particular, there was a big reform in 2016. The main reform started finally in 2016, and the reform was made a complete reform of the judicial order, and there was also a vetting process at the same time during the reform. The vetting process was a process of analyzing the judges and prosecutor activity to verify on one side their capacity, on the other side their assets, to verify if they were if they are or if they were corrupted. It was a shock in Albania because almost 40% of the judges and prosecutors were dismissed. The vetting process is finishing in this period, so it took a lot of time. And there was an internal commission controlled by an European Commission. Frankly speaking, I don't know if the activity of the internal, no, in Albania, the activity of the internal commission was always correct, because I saw situation where I'm not sure of it. But it was very important in every case, because the message that left to the community was, we are renewing the panel of corrupted judges and prosecutors to replace with new ones that guarantee the independence of activity of judges and of prosecutors. In a situation like this, you can imagine that there are victims, because in such a big process of evaluation, sometimes too much strong, in my opinion, but But the message arrived because the perceive of the independence of judges or prosecutor in Albania completely changed in the last year. The vetting process is, I told you, is finishing, and at the same time, there was also a sort of revolution of the institution, we can say, because a problem that was in Albania is the head of the, for example, of Court of Cassation, the head of the constitutional body were all nominated by the parliament. And if you, and also the members of the Court of Cassation, not only, for example, the head of the Court of Cassation, what does it mean? If the level that controls at the end all the jurisdiction of the country is nominated by the parliament, you know, you finish the independence because you can do whatever you want in first and second degree. You can condemn, absolve, you can decide civil procedures, very important. But if you arrive to the last moment of control and there is somebody that look at it with a political point of view, you can imagine that the justice at the end is conditioned by the political power. So with the reform, the nomination of the president of the Court of Cassation, of the judges of the Court of Cassation, of all the judges are passed to the High Council of Justice. It happened with the judges, with the High Council of Justice, and with the prosecutor, with the prosecutorial council. So on the paper, the situation is completely in line with the standards of European Union. At the same time, the revolution was also because you can imagine in a country where in a few period 40% of the judges or prosecutors were dismissed. So the School of Magistrates that is in charge of taking on board the new judges and prosecutors had the role to fasten their activity, not fasten because the period is defined by the law, but to take on board as much new candidate for position of judges and prosecutors, but with a good level, because if you take person like the person that is missed, the exam, they have to work on the exam and they have to strengthen their activities just to increase the capacity of training and of forming of new candidate judge or prosecutor. For example, now I'm working, because I told you that I work in Albania, I think almost 20 years, but now we are, I'm following a project, a twinning project, just for assistant of the School of the Judiciary, because we are working for the School of the Judiciary on the didactic level, so just to see how to form these judges and prosecutors, but also on the organizative level, because, for example, a structure that has to increase so much its activities has been supported also in this way. Also on IT level, for example, just 1 month ago, I went in Albania with the IT of the Italian School of the Judiciary, and we are rewriting all the IT system of the school to be more efficient and to be more helpful for the activity of training of judges and prosecutors. So that's the reason why it was a earthquake in Albania, because all the system was changed. All the system was changed. And I have the impression that, and I have to, in a certain way, to congratulate with the capacity of Albanian people to adapt. Because I always say that if something like this was happened in a country like Italy or our countries, European countries, it was completely, I can say, every reform in Italy, if you reform also a rule, it takes years to be well interpreted in the Constitutional Court. You go to the Court of Cassation that gives principles. So even a small change of a law, you can imagine when it changed everything in the same moment. And so I have to say that the Albanian institution and the Albanian react, in my opinion, in a very positive way. It remains the problem of corruption. The problem of corruption, the image and the perceived of corruption, for sure, is better than in the past. But I don't see that the problem of corruption can be solved in 3 years, 4 years. And the mentality of a country cannot be changed in 3 or 4 years. It takes time. But I think that the steps are very good, and I wish that in the next future they can enter in the European Union. Also because it is another stimulation just to go in the right direction as they are doing in the last years. Thank you for the moment. I think that is enough.
Thank you, Gianluigi Pratola. I think the last remarks were very important. We see this in many countries, a kind of reform overkill, that there is an excess of new legislation introduced at the same time. I remember also in Bosnia-Herzegovina, they changed all the procedural codes and introduced a different model, the adversarial model. This is, of course, also linked to the observations which we made yesterday regarding the gap between the reform for ticking the box in the benchmarks and then the effective implementation and the sustainable implementation. And of course, the more you change, it is not that automatically the more will also be changed at the ground level in the field. The second important perspective you introduced, I think, which was which was not so much present yesterday, is the question of the prosecutors. No, because I think also this is a very important issue. You mentioned in particular the power, the political influence and the powers of the general prosecutor, and very often the general prosecutor still appointed by parliament. We have seen this also in Armenia, but also what was very important in Armenia as a very extreme example for me was to see that there is a third body between the judges and the prosecutors and the police. So actually it's a fourth body then. So a body in between, which is called investigators, and they are also independently, or maybe not independent, exactly, this is the problem. They are not independently organized, but they are autonomously organized, and they even wear uniforms. So they look like police to us. We do not have familiarity, no? And also coming back to what Van Dijk said before regarding the perception of independence, of course, if you have police in uniform and then you have these investigators in uniform, and then you come to a prosecutor which is serving under a general prosecutor appointed by parliament, then the perception of independence is probably a different one from the
nominated this investigation body by the president of the Council of Ministers, in brackets. So you can imagine which independence was.
It's a kind of, for us, it appeared like a kind of second level police, which was said that this was the Soviet system, which was like that. No, and not just to, I think for this reason, with this anecdote, I wanted to underline for this reason, I think it's also very important to, and of course also for the fight against corruptions, to have the prosecutors also on the screen. Having said this, unfortunately, we do not have the coverage of the Ukrainian area. We tried Ukraine, Moldova, and Georgia. Sorry, we tried to have someone here, and it didn't work out. But we will probably manage for the publication. And so I have the pleasure to immediately, we have therefore 2 discussants, and I can introduce Professor David Pimentel, who is Professor of Law at the University of Idaho. So we could also talk about the United States, but we can do this afterwards, because the rule of law, of course, is also a topic. And he has also now, since, may I say so? Yes, since yesterday, and congratulations, a PhD from the University of Graz. because he was, before his academic career, he did, of course, things at the judicial councils in various circuits in the US and is a Supreme Court fellow in Washington, but he has an astonishing record of international experiences in very different fields, among which, in particular, court reform in Bosnia and Herzegovina, and in particular in the first wave of international judicial reforms there, and also afterwards then in Romania. He was even overseeing the court management at the ICTY in The Hague, and afterwards headed the rule of law mission in South Sudan for the United Nations. And of course, his research was very strongly influenced by this experience in the field, focusing on rule of law, judicial independence, and accountability. And his PhD is actually about the judicial reform in Bosnia and Herzegovina. And having said this, please take the floor. I'm wondering if I can get the...
Jens has complained that I speak very quickly, and so I put together a PowerPoint so that you can follow what I'm saying if I get going too fast. But it's a topic that I'm so passionate about that there.
Open it.
I think it's already open.
But you need to show.
Yes, absolutely.
This one, yeah, that's it. No, because otherwise it's not the.
Yeah, it's not going to help. Good, good. But I'm always trying to say too much in the time that I have, and I'm sure what I've prepared is too much. So we'll go through it a little quickly and hopefully skip over some sections to focus on what's most relevant and important to us in this inquiry. I was very impressed that Gianluigi talked about how we need to understand the culture. How do we enter into the culture of the society in which we are working? How do you suggest change in a place like that? And this is a classic problem that court reformers have done over the years. They come in with an idea about what works in my country. Americans are some of the worst in this, right? You know, we've seen this. They come in and say, "Oh, you need to do it the way we do it," and expect it to work in the same way. But every society is completely different. The history and culture is different. If we look at the Anglo-American system, for example, courts historically protected people from the abuses of the kings. This dates back to Magna Carta in 1215. People wanted, and society accepted the idea that judges have immense power, and it was absolutely critical that they be independent, because that's who stands between you and the abuse of the executive. And courts in the Anglo-American system are empowered actually to interpret law and then to change the law as necessary to achieve justice and equity. So this is rooted in history. This idea that judges should be very, very powerful, and the independence is absolutely critical for them to perform their function. We can go to other cultures. And I teach comparative law, and we study Islamic law, and we study Asian legal traditions and Confucianism-inspired law and African customary law. But you don't have to go very far away to find a very different approach to this issue. If we go to France, pre-revolutionary France, the courts were oppressors of the people, and the revolutionaries were very concerned about limiting the power of the judges. Initially they did not even want judges to have power to interpret the law. They were to be mere fonctionnaires, just applying mechanically the law. It was deemed anti-democratic to have judges interpret the law and decide what the law is. To the French, independent meant unaccountable. And this, of course, is moderated over the years. But historically, this perception, driven again by their history and by the way they experience judges. Now, I I did some work about 12 or 15 years ago in Nepal, trying to help them to craft a new constitution. And the Maoists had taken control of not a full majority, but a plurality in the parliament, and were talking about how to set up the judiciary, and I was there to advise them. And I had these really confusing conversations with Nepali Maoists because they said, yes, we want an independent judiciary, but what they had proposed was a judiciary that was controlled by a committee of the parliament. And I said, how is this independent? This isn't independence. And they said, no, this is like really important. And it was only as I came to understand a bit the Marxist perspective, that this is the ideology from which the Maoists came, of the role of courts and the horrible history of corruption within the judiciary of Nepal. They were reacting to that. They wanted a judiciary accountable to the people, and of course, the only way they could be accountable to the people was through the parliament. But historically, the people don't need courts to protect them from the government, to protect them from the executive. They need the government to protect them from the exploitation by the capitalists. And the government is there on your side, on the side of the people. And of course, the judiciary is an arm of the government and we should not be surprised that telephone justice was a concept in socialist states, because of course you wouldn't trust an individual judge to know what's best for the people. You take the judge gets a phone call from the party headquarters, and on any case of great significance. So, but of course there's also the perception about what does justice mean. In my Western culture, justice is about individual justice. Can this individual get justice? This unpopular individual, perhaps, can they get justice? And they need an independent judge to ensure that their rights are protected, because unpopular minorities might otherwise become victims of the tyranny of the majority. And so we see just these different ideas here. There's our Nepali flag. So the idea is that judicial structure maybe really needs to be tailored and really needs to be different in different cultures, depending on what ideological roots of the society are, what the religious influence in the society is. The religion has been an enormous influence on legal traditions in various places, and very different things here. I was impressed, that we have to get over the idea that there's some best practice. We used to always talk about best practices, and it is like, this is the model. You need to do it this way. This is the way it is done. This is the way it should be done. And working in post-colonial Africa, I came to realize that this is deeply problematic, to go into a country and say, oh, you need to do it this way. We're here to enlighten you. We're here to civilize you savages. I mean, these are harsh words, but it's when you show up and say to an African country, you need to do things following the European model, they say, this sounds familiar. Haven't we been dealing with this? You are just the neo-colonialists, right? This is imperialism all over again. And so we have to be really sensitive about that. Of course, Franz has made an excellent point here that there is no consensus even within Europe about judicial councils, and it appears that we have very functional systems with them and very functional systems without them, and part of this may be the history, part of this may be the way people think about it. What are the issues culturally in a Far Eastern tradition? There's tremendous respect for authority, so they don't have to worry about enforcement mechanisms the way we do in the Western Balkans, for example, where defiance of judicial authority is something very, very normal. Gianluigi notes that the reform in Albania was designed to deal with the particular issues there, right? We have to respond to the problems of Albania, which are a part of its communist history and a part of its current cultural situation. So, maybe there's a culture within the courts, and there has been a tradition in the United States. We'll see if it stands up, of tremendous independence by judges, who will defy the very president who appointed them. We see this again and again. These are heroes. People, every judge kind of wants to be Sir Thomas More, the one who stands up to King Henry VIII and says, no, I'm going to do the right thing, quite regardless of what the powerful people think should. Now, bringing this to Bosnia and Herzegovina, of course, the judicial reforms here came in direct response to the Dayton Peace Accords in 1995. The High Representative was appointed and given a sweeping power. And so we were able to do judicial reforms. I was a part of this reform because the High Representative had power to alter the Constitution at the stroke of a pen, to implement legislation. If the Parliament wouldn't do it, well, fine, the High Representative would just impose it. And so we had really a free hand to do absolutely anything and everything that we wanted to. We didn't have to worry about the politics to a large degree of getting these things implemented. I learned hard lessons later that you can't do that everywhere. So the High Judicial and Prosecutorial Council was created, and a really central theme here was independence. So we had to make that council completely independent of the other branches of government. And Jens and I have had multiple discussions about the fact that there aren't even checks and balances in this situation. The executive and the legislative branch really have no power, structurally at least, to do anything if the High Judicial and Prosecutorial Council were to exceed its authority or to act in some sort of corrupt way. And this will form the core of some of my research here into judicial independence. The courts were restructured and consolidated. That was my project. The head of court restructuring there in 2002. The judges were all dismissed. There was a heavily vetted selection of new judges, as I understand it's happened in Albania as well. Judicial salaries were dramatically increased. Court presidents were empowered to manage their courts. Electronic case management systems were implemented. New procedure laws were adopted, as just referenced now. So it was a sweeping reform. I went back to Bosnia nine years later and conducted. I was at the Pravni Faculty and conducted a survey of all the judges and prosecutors in Bosnia in 2011. Yeah, here I am with my family. We had a lovely time in Sarajevo. It was fun to go back. But we posed these questions, which of these reforms made a difference? And of course, the HJPC was the High Judicial and Prosecutorial Council was a part of this query. What did the judges think worked? What didn't work? And I collected all of this data in 2011, and I was able to, create these bar charts about what judges liked and what they didn't. What they thought, what they really hated was my project, the judicial. It was a humbling thing that the restructuring of the courts they thought was perhaps the least effective. So after that, in 2019, the High Judicial and Prosecutorial Council was rocked by scandal. The HJPC president, who had already been perceived to lean into a Serb nationalist agenda, he was recorded in a meeting where there was money. It was agreed that money would be paid to him to intervene in a case. He was also implicated in a plan to get a close relative of the HJPC appointed to a coveted judgeship. These things were documented. These things were reported in the press. And there was no accountability. This is the problem here. Okay, the HJPC, this was their moment in history. This was the test of history. Would they step up and do the right thing? And they did not. The HJPC, quite shamefully, I think, and ultimately dismissed the ethics inquiry on the technical point that the code of conduct that prohibited corruption applied only to judges and judicial acts. It didn't apply to the HJPC. So they have no code of conduct at all, so they can't possibly violate it. But we just proceed with our corrupt system. To make things even worse, the HJPC issued a press release asserting that those who were accusing them of corruption were in fact violating principles of judicial independence. And Gianluigi talked about this, when the idea that anybody who contests you must be trying to interfere with you, right? And so they were using judicial independence to avoid accountability. and they went on and actually called for an investigation of the media entities that had reported it, to punish the messenger here. I came and I conducted a new survey in 2024, asking very much the same questions as I had in 2011. I was able to contrast the answers we got. Court efficiency, not so much the issue here, court integrity, the different provisions that we've done. HJPC management got higher ratings in 2011 than it did in 2024. Actually, everything was worse in 2024 than it was in 2011. So maybe the bloom was off the rose a little bit. There had been some backsliding in this issue. I have a bunch of data. The most negative response I got from all of these judges, I got over 600 responses, which is really a terrific response. I'm in awe of France's surveys. Ian CJ does just amazing work. I trying to do my own little surveys. I'm impressed with what they've done. But we can see here they had to answer: one is if things were worse, two if they were the same, three if things were better, and four if they were much better. And we can see that the averages on public confidence in the HJPC in 2024 had averages of overall of 1.72, meaning so overwhelmingly they thought things were worse. But that was the exception. Court presidents always a little more favorable about the HJPC because it's the HJPC who made them court presidents, right? That's not a great surprise. I managed to disaggregate the data by coming up with a survey in all three languages that they use in Bosnia, and so the survey taker could opt for whichever language they wanted. Which gave me kind of a proxy for how different ethnicities were viewing things. And I had thought that the Serb respondents might be most negative, and that was not true. The Serbs and the Bosniaks were very, very similar. The Croats, for reasons I have no idea, did not, were a little more positive. So, okay, yes, I need to wrap up. So in any case, judicial independence in Bosnia, 2/3 of the judges felt it was adequate, which I thought was interesting. Another quarter thought it was complicated. 10% said they didn't think they had adequate independence. But here's the damning thing. Do you believe the HJPC are adequately held accountable for the conduct if they violate principles of ethics and integrity? This is a direct question about the impact of those scandals, and that number was quite low. Does the HJPC have too much independence? Is judicial independence become a part of the problem? In my research, I concluded that checks and balances would not help in Bosnia, and the reason is that the executive branch and the legislature are so corrupt that if they had power over the judiciary, they would not use that power to keep the judiciary honest, but they would use it, in fact, to corrupt the judiciary. So checks and balances maybe isn't what we want. Some of these ideas were suggested to me by Sven Marius Urke, and those of you who've worked in Bosnia may be familiar with him, played a major role there. Is it really fair to expect the HJPC to fix everything? I mean, I think maybe not. We're always calling for judicial reform to fix rule of law problems, but the crisis in the rule of law in the United States is not because the judiciary has failed. It's because the executive branch is out of control in the United States right now. The attacks on the rule of law are not the fault of the judiciary at this point. We hope the judiciary will have the courage to stand up and protect our institutions. In the United States, we're very concerned about that because that's not at all clear. The legislature has failed to stand up at this point to prevent a rise of fascism in the United States. In Bosnia, this problem is political corruption, divisive ethnic politics. I've got a picture of Milorad Dodik here. Those of you familiar with his brand of Serb nationalism is trying very hard to destroy the unified Bosnian judiciary. So I ultimately conclude that it is not a problem of too much judicial independence. And I think that in Bosnia, independence is absolutely critical, but the real challenge here is going to be, I'm sorry, I'm out of time. So is going to be figuring out how to do judicial integrity and internal to the judiciary. There are a lot of judges and prosecutors throughout the Bosnian system who responded to my survey who felt that were very unhappy with the way things were operating at the HJPC. We need to empower those judges to help shape their institution. And to police the misconduct and police the corruption in the judiciary from within the judiciary, so the judicial branch can maintain its integrity and its independence at the same time. That's what I have. Thank you.
Thank you very much. Thank you very much, David. And you confirmed that you can speak very fast, actually. Just, I think what's very important and also maybe a new aspect we haven't touched upon so far was the question of accountability, also of these councils as a counterweight to independence. And also, I think what you illustrated with your examples is also referred to what was discussed yesterday regarding legal culture, apart from the socialist question, the question of socialist legal culture, we might come back to in the discussion afterwards. Also the question touched also by Gianluigi before, of the amount of change we are talking about in these systems and the amount of also cultural adaptation, assimilation, and sustainability this, of course, brings in. No? And I think the distinction with this example, whether the code of ethics for judges applies also to the members of the council or not, is a brilliant example of positivism, which I also had the chance to see from quite close. Bene. Radha Sita is our last speaker, and she holds a law degree from the University of Ljubljana and is currently here in Trento. She's doing a PhD in Maribor at the University of Maribor and also here at the School of International Studies. But also she has more than a decade of professional experience within the judiciary as in the court administration at all levels of the Slovenian court system, including Constitutional Court and Supreme Court. So she knows the things she does research about also from within. And if you want to comment, if you want to add something, probably on accountability issues, then.
Thank you, organizers, Ian, Simone, Halina, for having me here and to be able to speak about my research, of which I'm passionate about, and especially to have guests which can answer to the numerous questions I have. And I will use the opportunity to ask you questions later on. But first, I would like to also present my own research where I think there are some problems and solutions and fit very well with the panel and the last words of Professor Yates. So about the topic, judicial councils in Europe and their accountability. That is what I'm interested in. But first, I would really like to explain how did I come to this topic, because it's very important as it has developed. I find it also the way the judicial councils have developed. We were talking with Professor, if you remember, so try something with the rule of law and conditionality, the topic today. And I've read about literature about rule of law and conditionality, and what is actually, what do I say, the main topic, the most frequently used word is about judicial reforms. So that is the path from the conditionality, rule of law, we go to judicial reforms. What is the next topic? We go to judicial councils. You never have a judicial reform without the judicial council. They're extremely important. Okay, so I will do on that, Professor. Okay. Reading about forward, I went with this research and I saw soft law promoting this model of governance. This is solution. This is the best way. Okay, I have so much to say about it. And then again, the literature that was so skeptical about this model, and really it scared me in a sense, what are we doing? And this is so huge gap. So a lot of researchers said there is no connection, absolutely no connection or negative connection between councils and judicial quality. There's a negative connection with the efficiency, negative connection having a judicial council with public trust in the judiciary. Then I saw the ENCJ 2022 survey. So judges rate their own independence much higher than independence of the councils. But these are bodies supposed to protect your independence. How can you be protected by a body that is less independent than you are? And thank God we have this kind of survey because it's unique. Nobody has asked before, neither judges nor citizens, but as citizens, I don't even believe they know what a judicial council is. So luckily now we can compare how it has changed during the years, and I want to further research on that. So I went back to the professor and said, this is not working. This is not okay. Maybe you remember, Professor, that day. It was the same day the Professor Pimentel came to the University of Trento, and I was, this is not okay. I want to write about it, that this model is not working. And you said very powerfully, directly, simply, what are the alternatives? Going back to the Ministry of Justice model? No, try something. You said, try something, one characteristic, focus on it, and let's find where is the problem, the smallest problem. And the same week, again, reading stuff accidentally or not, I found the Kees Sterk report for Organization for Security and Cooperation in Europe. And there was a article on accountability of judicial councils, making some comparison between countries, making some also important emphasis on the ethical side of the judicial council's members. And for me, it was a click. Of course, how can we, it's obvious we have missed it, as it was in the judiciary context, talking too much time about their independence and not accountability. The same is happening with the councils, of course. A lot of independence, but not accountability. So, okay, that is it. I digged in, I tried to do the research based on very important also opinion of the Consultative Council on European Judges for the 2021, which already had some kind of structure. What is it all about? It's about the 3 dimensions, which I'm focused and dealing with more in detail, because it's not about the ethics, just about the ethics. It's about, they say, about judicial accountability. So their decisions have to be tested before courts. That's what they say, independent courts, independent from the council. That's the judicial review. It's the so-called judicial accountability. The second one is the punitive, or Professor prefers to say individual, not to scare them too much. Individual accountability, meaning there should be disciplinary framework, there should be code of conduct. And the third one, the explanatory accountability, as the word said, explain, be transparent, be proactive in this way. So once I got this framework, I have some written, okay, let's do some comparative analysis. I got either no information or scattered information. It was difficult to know what our country is doing on these topics. And I decided, should we do a questionnaire, but not typical one in the sense of evaluate what do you think about these topics, but the countries directly should be asked, and their councils, what are you doing on these topics? What is your regulation at the end of the day? And I did develop a questionnaire with 15 questions. I got connected with the ESCJ, with Professor Van Dijk, which I'm grateful for the help invested. And this took a lot of months, actually, not just to develop, but to get responses. This February, it was distributed. I got a really good response rate, 22 countries. Some of them I struggled a lot. For example, Italy, it took months of begging, pleading, and saying, yeah, next week, now, tomorrow. basically the same with Bosnia. They want to be critical because Bosnia, obviously, they have a lot of work to do and they have so many projects. And this is only, let's say, another research project, but accountability is precisely that. Responding to questions, to the public, to the academics. So this was kind of my small first test. Would they reply? How fast would they reply? And what the quality of replies, the answers would be. Fortunately, France, Greece did not reply, and Denmark, those are basically the only countries in this part. And then for the Western Balkans, Montenegro immediately, Bosnia after pleading, and then nothing. No reply. Okay, so this is also maybe even question what I want to ask you again. Why are they not there when they, I think, need to be? They need to be. So to focus then what I got on the results, which is, for me, some of them very surprising. About the judicial review, almost all of the country have, apart from, for example, Hungary, but they don't do judicial career. Lithuania, Georgia, they say, this is constitutional body, no review. But I warn that this will definitely fall before the Court of Justice of the European Union, and especially also the human rights. The punitive accountability, not only that, code of conduct for council members exists only in 6 countries, Belgium, Italy, but for not the CSM, but for the administrative one, Luxembourg, Montenegro, Norway, and Portugal. So this is really a very much important place when things could get improved, code of conduct, especially for this kind of excuses. And model exists. The ENCJ prepared a model. You just have to copy and paste. So it's not the work. The work has been already done by others. Surprisingly, also for the disciplinary framework, they don't mention even in their laws about the disciplinary accountability of their members. Croatia, Slovenia, Finland, Norway, Moldova, Slovakia, Latvia. This topic does not exist in the national legislation. For the explanatory accountability, you have to say every council publishes annual report. This is in the soft law requirements, okay? But apart from that, they're very much different. I've asked them, do you, and these are questions now, hot questions, do you have public sessions? Do you record sessions? Do you public reasoned decisions? Do you have communication strategy? They vary a lot. Especially, I think they're very much not in fond of public sessions, although some countries, especially Italy, Romania, they're very open about it. Those countries, they do not want to have one. They're a bit more, yeah, but what if things will be worse? Then everything will happen behind curtains. We have had this conversation. Can more transparency be bad? I don't believe that. Many professors have tried to convince me that, including, we still have to talk about it, but I think that transparency can never be bad. Why? Because it's not the fault of being open if something is not working. It's the structural problems that have to be addressed. It's a sign that the illness is somewhere is elsewhere. No, so don't heal it like symptomatically. No, so this I up until this moment I think like this. So about the difference, Ukraine answered yes to everything. Luxembourg said no to everything. So I think there is much more to learn from these experiences. Now, my standing is not that 100% transparency, or there should not be data protection considerations also valid. Of course, one should always have in mind all these interests very much. But the point is going from the transparency and then having reasons to disclose to close some information and not vice versa, what is happening now. So this is briefly my preliminary findings, let's say. I think next time we meet or we write each other's articles, and even the next time I will also have some nice graphs and further conclusions. Thank you.
Thank you. Thank you very much, Rada. I'm still skeptical about transparency. What you last said, I can probably agree with, that transparency should be the principle, and then you need to motivate exceptions from the principle. But I'm quite convinced that some exceptions are reasonable, but I don't want to talk too much and abuse of my. We have also run out of time. But just to, I think one sentence. I think the issue of accountability is really very important, in particular when we build up new independent councils, as we have seen also with the example of this scandal, emblematic scandal in Bosnia-Herzegovina and also in other countries. If we build up a new power center, in a way, this is the point. The council is a center of power. And of course, this is an attractive thing for politicians to do, but it's also something which can be, as any power center, be abused from within. And so we also need to focus on accountability. And the purpose of your research is actually to look a bit deeper into this issue. And thank you for sharing your insights. So I would just briefly, before we have a short coffee break, leave the floor to the two speakers in order to maybe reply to some suggestions, to some comments. There were no real questions, I'm afraid, but if you want to, yeah, but now you are out of time.
You definitely. Yeah, well, it's great to see that you just use the opportunity to present your own research, which is much more interesting for me than hearing comments on my own work. I'd like to make a couple of remarks. I would entirely agree that accountability is a major issue. It has always been. So also in this ENGJ framework, it's independence and accountability. So if there is no accountability in the long run, there will not be independence, because then the political forces will move against you and the people will move against you. But there is, of course, this tendency to focus very much on independence. But I find in accountability that there are also very many different traditions there. So for instance, what you're saying, opening up meetings to the public, which happened in Romania, in Bosnia. Yeah, that would be seen as crazy in the Netherlands. So a board reflects on its, takes a position and publishes its position. Then that's so. You should take into account different cultures of accountability. What I would like to say also on what happened in Bosnia, we have recently advised in my different role as a professor only and not from the ENCJ, that a council like the HEPC should take responsibility for its own future. So what happened in Bosnia, that all sorts of international forces, countries intervened there, came up with nice suggestions. For instance, the Americans pushed their own system of criminal prosecution in a context which was totally different, and they are still struggling with this sort of systems that don't fit in. And that's one of the major things that is lacking there. They just believe that any great advice from the US or from the Netherlands or whatever should be taken on board. And these councils should really get up to it and say, well, this fits in our system, and this is what leads to a good, for instance, criminal procedure. And that's, I think the international world has done a lot of damage I think in Bosnia and perhaps also in other countries, by giving too much advice and being drawn into it. I must say corruption. If you say, sorry, the person in Bosnia that was the Geltje, he was, of course, elected by the peers. So the problem is that it doesn't stop with So you have a good way of electing members to a council. So it can't be in, but it's that's also so the idea came up again. Should we do another vetting in Bosnia? So you can do it every 20 years. That's ridiculous. So the idea that you can divide the world into two, you have good people and bad people, we vet them and we're only left with the good people and then everything is fine. That's not how it works. You have to change the incentives. So for instance, their work is being done on asset declaration, which is probably one of the most important things of transparency in these environments. What do I want to say with this? I want to say that from an international perspective, we should be very careful that we don't mess up in these countries and make it worse instead of better.
I think this is a very useful reminder. Thank you. Gianluigi, do you want also to?
That's because I don't want to take too much time for the break because you have time also later, but only a couple of things. First of all, with transparency that, first, if you need some information about the Italian council, call me, please, because probably you passed this. I'll give you because I've been working there for 6 years, so I can be more helpful that. And the second thing, the principle of transparency is true. The principle of transparency is a very important principle that must be implemented in all the public administration. But with the judiciary, we have to take in consideration also another value, the image of prestige of the judicial activity. So the question is always convenient to be too much transparent, to show aspect that can affect the image of impartiality and transparent and correctness of the activity of judges and prosecutors. This problem comes, for example, especially with the disciplinary activity of the councils, because in Italy, for example, very open, because all the disciplinary sessions go to Radio Radicale, so can be heard by radio, except the cases where the judge or the prosecutor asks for not transmitting it because they don't want. But also in this situation, for example, in an office where there are some suspect because the disciplinary decision of violation of rule of impartiality about judges or prosecutor, how can they perform their activity until it's not clear what happened? So we have to be very careful in using transparency in certain habits, because the most important thing is that the perception of the judiciary is a good perception by people. And I say in a moment where in Italy we have some problems on it, because a society that doesn't believe in the judiciary is a society where the chaos expands itself. You know what I mean? So the transparency is very important, but in certain situations, there are some interests that must be balanced, on it. The second thing that I wanted to say is I want to again to emphasize the importance of the School of the Judiciary in all the systems. The training and the good, we can say, formation, saying probably is not the right term, of judges and prosecutors is the best way, not for the education for them. The school doesn't have to educate or inform, or inform only on the news. The the School of the Judiciary has to put together judges and prosecutors, let them discuss and let them help in finding the right solution, and especially the possibly the uniform solution of the question in the country. Because a country where in the north something happens and in the south happens differently is a country where it's not possible even to think that if you commit a crime in the north is different from committing a crime in the south. So the school has this role to help also together with the Court of Cassation to nomophylakia, we say, so the right, correct, and uniform interpretation of the correct interpretation of the rules in all the countries. And it's very important, as the European rules say, that the School of the Judiciary is an independent institution, must be independent from the Council of Justice, must be independent from the Ministry of Justice, because here the school has to take the suggestions of these two institutions in performing their activity, but the activity of the school must be independent from all the other institutions in the justice system. Stop.
Thank you very much. This is indeed a very important additional issue, the training, which is, of course, you find it in all reports, and it is not very much liked by donors because it's a soft issue and they spend much more voluntarily in other issues. Thank you, all of you. I was just close with a very, very brief one-sentence anecdote. When I was working in the High Judicial and Prosecutorial Council of Bosnia-Herzegovina on a Friday afternoon, because I had forgotten something in my office, I went back to the office, and Friday afternoon, there's obviously nobody working in this institution, like in many other institutions. And when I asked the situation, it is on top of the court of Bosnia-Herzegovina. And when I asked at the reception to open me the door, then they say, well, where are you working? And I said, at the HJPC, at the High Judicial and Prosecutor. And they said, the untouchables. So this was, for me, really an eye-opener. And I think it's very much related to what we are talking about here. And it should not be like that. And of course, I said, touch me. Okay, thank you very much. We have a coffee break now, a quarter of an hour, I would say, that we have, as promised, time for discussion. So unfortunately, we'll go down to these machines and we will try to extract some coffee from there. Thank you very much for your active participation. And thank you for the... Yeah. Okay. Ladies and gentlemen, we are now in the final part of our conference, and what we want to do, as announced and promised, because we didn't have the chance so far, is to discuss and to, after having let sink in what we have heard from our presenters and from the discussant, now we have some, let's say, at least half an hour, maybe even a bit more, 40 minutes of time for discussion on the various presentations we have heard, on the various dimensions of the rule of law in the different regions. And I have already one person who wants to speak, Professor Suchocka, and afterwards I take of course, here's a list, Tanya, perfect, and Constance, perfect. And afterwards, we will have the pleasure to listen to Roberto Tognati with the final remarks. Please, you have to use the microphone because we are online.
Yes, hello?
Yeah.
Yes. So thank you, Professor. I decided to take a floor because as I was the first speaker yesterday, and I had my speech in certain sense on behalf of the Venice Commission. So I also would like to share with you some of my experience of working as a representative of the Venice Commission in the group of international experts for Ukraine. And as you know, it was a very long discussion concerning the role of international experts in internal situation, internal law. But We had also a very positive experience with the participation of international experts. Here we have some judges, some advisors. They were active in Balkans in different institutions. And then it was also very strong discussion concerning the role of experts in the system of Ukrainian judiciary, how the international experts, foreign experts could be involved to help to make a reform of judiciary in Ukraine. It was exactly, it is a very strong role played by the Venice Commission. I can say that I visited Kiev, I don't know how many times, so I was a permanent resident of Kiev since many, many years, sometimes I could say. And once I had also an opinion, one member of parliament said to another member of parliament, you don't know the constitution. If you would like to know what is in the Ukrainian constitution, you have to ask Karlo Tuori or Hanna Suchocka. So we were such an expert to the Ukrainian constitution. But exactly, it was very important for me because I was involved, as I said, also in making the Polish constitution. So the role to advise to the Ukrainians was very, very important. And then when the Venice Commission, after the very, as I said, long discussion concerning the creation of a special group of advisors to the Constitutional Court, and it was the motion of the Venice Commission adopted, accepted, the group of experts has been established, but it is established by the law, because in the law to the Constitutional Court, there is a special pressure provisions on the AGE. It is this good AG group of experts, advisory group of experts. This is such a formal title of our activity. There are 6 persons in the group, 3 Ukrainians and 3 foreigners. The experts, international experts, represent United States, European Union, and Venice Commission. I'm from the Venice Commission. It was also a judge from the United States, but after the victory of Trump, United States, as you know, cut all the funds for making reform. And now it was a woman judge, she is a very difficult situation, but still is vice president of the group. And you know, what is our role? Our role is to make an interviews with candidates. They run for the position as a judge to the Constitutional Court. We receive the list of candidates, and then we make interviews. We prepare the list of questions, and first of all, we have to check the moral integrity. It is the first problem, and the second is professionalism. But moral integrity is of great importance, and I would like to say why. We heard today the discussion and also presentation on the role of culture in the different countries. And here is one of the most difficult problems for us, how we can understand local culture. Because, for example, local culture sometimes means nepotism. It is a local culture. Should it be included to the standard or not? And it is one of the most difficult problems we have, because we ask the candidate, you were a judge in such a case when your, I don't know, nephew or somebody from your family was, how to say, accused. But I am a judge, independent, etc. Yes? So they don't understand, many of them, they don't understand what does mean conflict of interest. And we have also to redefine conflict of interest. Then the third problem, which is also of great importance, and it was discussed also here, is how, I don't know how to call it, not to be very negative, but it is a corruption, which is also a kind, as an element of a culture. And we have to present and discuss with the candidate that certain, how to say, financial help could be called corruption. Yes, it's not only financial help. We have to divide, and we have to define what does mean. So for that reason, I think I am always in favor to keep the element of local culture. But first of all, we have to clearly define what does mean local culture, and we have to cut the negative elements of local culture as nepotism, lack of conflict, of, not understanding conflict of interest and corruption, to create standards, which are common standards taken from European standards, but also based on the so-called local culture, yes? So I only would like to say in a very general way, yes, because I'm still acting in this process, but I can also say that we propose a candidate to president and to the Verkhovna Rada. Still now we are waiting for the new candidates, which will be appointed by the Council of Judiciary. But we proposed the candidate in February. Now we are in June, and no one has been appointed because probably we propose not just candidates, yes? Because we proposed candidates, they were not involved in the specific alliance with authorities. So it is a really very big problem, and we sometimes are under very strong critics, but we would like to make our role. Very often we vote, in majority cases we vote unanimously, all three Ukrainians and we three foreigners, but there are also cases where we are divided. And there are very, very important cases. Sometimes there are the persons which played very important role in judiciary in previous system, and now they would like to run for the constitutional court. Yes? So I only would like to present that the looking for standards for concrete countries is a very exactly difficult problem, complicated issues. But first of all, we have to take into account the guidelines of the Venice Commission, because the guidelines of the Venice Commission are exactly created on the, as I said yesterday, on the compilation of some local culture and the European culture, but without the negative elements of the local culture, yes, as I mentioned before. Thank you so much for your attention.
Thank you very much for reminding us of the importance of local culture and for elaborating on this, and in particular also I think which is very useful starting point which you mentioned is the concept of the conflict of interest. I'm only wondering, not for contradicting you, on the contrary, but that we have to take into account, as you perfectly know, and as the Venice Commission perfectly knows, that there are many systems where we have state capture. And I have heard it in Georgia myself, the winner takes it all. So we have a system where democratic change is possible still. This is a difference. It's not a dictatorship in that, although this is probably now just changing. But I was really told by an interlocutor, the winner takes it all. And of course, and exactly, and this is of course a limit to the idea of the conflict of interest in our sense, and the question also of how far can the margin of appreciation in defining the local culture go, no? And there I think your suggestion of looking at this compilation, which is a collection of experiences, of different experiences, and attempt to find a common denominator is an excellent one. Thank you very much for.
Yeah, thank you, Jens. I have a couple of comments and questions, I don't know exactly, from this morning session. First of all, it was mentioned, Franz mentioned, the one point that is the participation of the judiciary, or the initiative of the judiciary, or the participation in legal reforms affecting the judiciary. And then I would like to ask whether you can develop a little bit more this aspect, because there is, I think, an ongoing discussion on the participation of the judiciary, or the councils of the judiciary, or of the constitutional courts in the legal reforms affecting their competences. And yes, for example, the judicial overall, I would use this word, judicial overall in Mexico, open up a debate on the not only opportunity, but necessity, constitutional duty to at least listen the point of view of the judiciary in this legal, in the procedure. Then this is a point that I think at academic level, at least probably I'm missing information or readings, I don't know, but is not so developed, this participation of the judiciary, judicial councils and constitutional courts in the legislative procedure on reforms affecting their competencies. Second point, comment or question, we discussed a lot the gap between law in the books and law in facts when it comes to the rule of law and especially judicial independence and judicial accountability. And I had the impression that while when we deal with the judiciary, there are indicators, there are quite a lot of indicators that have been developed, and some of them, the surveys that have been mentioned by Franz this morning, are quite developed. When it comes to the constitutional courts, as far as I know, we don't have indicators to assess the reality. I'm also looking at Anna because, for example, Venice Commission is not working, I think, on indicators. It's much more qualitative or yes, and finally in the checklist, there are not quantitative indicators. And then I think at least at academic level, as a network of scholars thinking about also future research projects, we should try to develop this aspect that is so well developed as for judicial councils, for example. And we cannot say that, okay, constitutional courts are outside because they are outsiders, they are constitutional institutions. Also judicial councils and the judiciary is a power of the state. Then we cannot say that our constitutional courts are untouchables in this way. And then probably indicators and also some concepts such as accountability, the three dimensions. I think that even the judicial accountability, at least in Europe, can be also developed as per constitutional courts, because finally there are so many decisions of the European Court of Human Rights that are condemning the states because of the attitude, the judgments or omissions of the constitutional courts. Then I think there is some room for further research.
Thank you. There certainly is. I have just received a message from Professor Josef Marko from Graz, who's also listening, and he suggested, why don't you talk about the role of law schools and law faculties also as an even wider concept of training, which has been mentioned before now, and also of building up. Of course, this takes time, a legal culture, which fits also with you have said. So your suggestion with research project, there is probably also a wide field open. The problem is, of course, finding financial resources for that and establishing context, but exactly this would already be part of the purpose. Constance, please.
The question I wanted to ask is not at all about the rule of law in education, in universities and so on, but it's much more restrained. It's another time the example of Albania, what is worrying me very much, because I have been in a mission to Albania in 1990, I think, or 1991, something like that. And it was already about vetting. And there was a vetting commission which made awful things. And the whole Council of Europe mission said, no, that's not possible. You cannot do that. And we were at a very nice dinner, and there were the leading personalities of Albanian government and jurisdiction, and they closed the doors very brutally and let us dinner only alone. And so it was very clear that the official personalities didn't accept at all the propositions of the Council of Europe mission. That was in the 90s of the 20th century. And today is still the vetting problem. When there was the judicial reform in Albania, it was in 2016, they counted 9 years of transition. 9 years. Now, normally it's finished and the problems are the same. How can you clean judiciary? That's the question which I would like to ask, because in countries where you have any vetting system, of course, judiciary is not clean, but is it much dirtier than in Albania? That's a question. What is the price and what do you expect? And so, as Tanya asked, where are can have some indicators to know what we can expect, what we can have, and what it costs? I think the costs here are too high.
This is an important thought we need to reflect upon. Certainly the costs are certainly high, and I remember, which I can only recommend to anyone who doesn't know, also beyond the Western Balkans, but the report is actually on EU financial support for the Western Balkans. It's a report by the European Court of Auditors from January 2022, and it's a disaster. It's really the cost is too high. On the other hand, what you have spent is considerable, and what you get in terms of progress is very, very much criticized by the same Court of Auditors. So this is really a very sobering reading. But of course, you had a different topic here. Do you want to add something?
Yes.
Okay. And then it's Gianluigi. And
excuse me.
Mm-hmm.
I just wanted to add after the both interventions that concerning local culture, sometimes we forgot that even in Western Europe, the differences of local culture are very important, that most Nordic countries don't have constitutional courts, and so on. And there are a lot of things that perhaps are not acceptable for other Western European countries, so that perhaps the reflection on Western Balkans or other candidate countries could be a little bit different if we are more tolerant about the differences of local cultures. But of course, we always have to distinguish between some local particularities, which are exotic, amusing, and so on, but can be tolerated, and those which cannot be tolerated because against the European common values. And we always have to make the work to try to distinguish between these both components. Thank you.
And here I would add or reply that also the transformation process as a difference comes in, of course, and the starting point, which is different, in particular regarding the Nordic countries and let's say any country of the Western Balkans or the trio. And this is absolutely, but there's also a link, I think, with regard to the issue of which I mentioned before, state capture, and what is happening now in many Western European countries in a different, of course, in a different setting, but with the question of which we have touched upon, the question of the narratives of populists regard aggressively against the judiciary. So here probably we can also draw from some experience in terms of resilience, which is one of the parts of elements of our title. Gianluigi, if you get the mic, please. Thank you very much, Julia.
Only a couple of considerations to answer to the questions. First of all, I appreciate so much what was said about the culture, because I think that it's very important to define what does it mean taking in consideration the culture of a country, because there must be borders and limits in defining, and I think that the European institution should focus on it, should, first of all, should emphasize the importance of taking in consideration the particularity of the culture. But on the other side, they should put some limits and some border in written to be a guideline for people that goes. I saw a lot of times experts going to give suggestions that are completely impositive. You know what I mean? They arrive and they say, oh no, this is completely wrong, without taking in consideration the particularities of the system and the culture of the system. On the other side, I saw some experts that there are too involved in the culture and in the system, so saying that in some situation it was not possible because no. There must be some guidelines for the activity of the expert, and it's very, very important to focus on it. Thank you for emphasizing this, is also in my opinion. And I think that also for talking about the culture and the modification, the change of mentality, I think that the big role can have the law faculties and the law school in this, because I think that one of the starting point in changing mentalities is just to play with the education by the beginning of the students, and I think it's also starting from the schools, not only for the law faculties, but I think that the law faculties should have a big role in not only in teaching the law rules, but also in teaching in how to approach the rule of law and the law rules that you teach. So it is very, very important to work also with law school and law faculties. About the Albanian vetting, it is, I agree with you, because the Albanians refused vetting at the beginning, because obviously it was something that infringed too much also the interests of the countries. But in 2016, when they had the light of entering in Europe more concrete, then they understood and they accepted that the only way to have a good chance to go to Europe, to enter in Europe, were to show the cleaning of the system. That's the reason why was accepted this the vetting process only in 2016 and were refused before, because there were a concrete perspective that after this probably they could show that the system had changed and they could have a good chance to go to Europe. Obviously, as you said, vetting process is not makes not miracles, because if the mentality doesn't change, obviously you can do all the vetting that you want. And in Albanian, it happened also another thing, that when in the process of vetting, the judges or the prosecutor, they were sure that would have been dismissed because they knew perfectly that they would discover all what they did, they increased their affairs because they had to take all that much as possible before being dismissed. So also the vetting process has the dark side, not only the good side. But what is important of the vetting process? First of all, that some of the part of the judiciary that is more corrupted is dismissed. The second thing is to show to the community and to the judges and prosecutors that only being in line with the principle of ethicity, principle of studying good capacity, you can substantially continuing in your work. So this is important. What is very important is the message that you pass to the community, also to increase the trust of the judiciary in people, in the community. This is very important. Obviously, it is difficult. It is a bad process. It's a process that has that is not perfect also in performing. In Albania, I think that there was a lot of people that was dismissed also where it was not necessarily dismissed, no need of dismissed. On the other side, there were people that should be dismissed and they did not, because obviously it's something that you have to prove and they have to prove, so it's a culture. And the fact that it was managed by a local commission was a problem, because I saw, for example, my personal experience, the president of the court of Tirana, Lady Airo, I can make also the name. I know her since 20 years and I could put my hands on the fire that it was not corrupted. But as far as she was the chief of cabinet of one minister of justice in the past that was of the opposite of the opposition, gave space to, to make a sort of revenge against her for some acts. So also the process of vetting has some dark, sides. But as a principle, is important with all the victims, also innocent victims that it has. It was a very good sign in Albania, I say, for Albanian situation and for Albanian society to hope that the justice could be ameliorated, could be increased. So it was, at the end, I had to give a positive, positive judgment on it.
In Bosnia, we have talked about this before in the previous panel. In Bosnia, the first vetting actually, which occurred very, very early, was a vetting for war crimes and serious human rights violations, full stop. So this was really for in the work of the kind of first war crime trials. Also, not the idea we cannot have judges who themselves have committed such violations. So this was very clear cut, very black and white, and of course very much influenced also then in detail. The second phase of vetting, which was now threatened in Bosnia after the scandal we have talked about, was let's do what they have done in Albania. So let's focus also on the corruption issue, and let's focus on illegal assets of judges or assets which are not declared or judges, conflict of interest. So very, very wide. And the judges were absolutely, totally worried because of the Albanian experience. And the Commission used this as a kind of threat in 2020. And here's my link to what we have heard yesterday from Cristina Fasone regarding the emphasis on financial means in the rule of law sanctions. We have not talked too much about the tools which we have in order also to do something actively. And now we have talked about vetting, but in general, is this the right way? Is this the only way? Maybe you can also elaborate a bit on this, and this brings me also to Tanya's remark yesterday, whether there is a link between democratic backsliding and the membership in the EU. So maybe we can also elaborate a bit on this in order to go back also to the question that we are talking here about rule of law. We have now delved very deeply into the judiciary reforms, but let's get mentally one or two steps back and see the rule of law also as a principle as a constitutional principle, as a common constitutional principle, and as we said yesterday, a general principle of EU primary law. And with this, Katharina, please take the floor. The mic is here. Thank you.
I would like to pose a question to Professor Suchoska, because you spoke about the vetting process, and this was a long question, because I read about a lot how the law in Ukraine was adopted, and I think there was a big bargain between the Venice Commission and the Verkhovna Rada of Ukraine, and a lot of difficulties in order to approve that law. In comparison to other opinion that the Venice Commission enacted not only with respect to reform in Ukraine, but also in other countries. Therefore, I'm asking you how much the geopolitical conditions insisted to the decision adopted by the Venice Commission with respect to the introduction of the vetting commission with international members, because at the beginning the commission proposed 4, then Ukraine proposed 3, then there was a decision about the majority rules or the unanimity and so on. And I reading all those opinions and the laws which were adopted meanwhile by the Verkhovna Rada, I have the perception that this was one of the most hard aspects to decide while the reform was ongoing, and also really difficult for the Venice Commission to take a stance. Therefore, I'm asking you, because this also is related to the so-called transfer of the rule of law. Thank you.
If you want to reply immediately, this would be. Thank you.
Thank you. Thank you. You know, it is exactly, I listened to the discussion of the vetting procedure also in Albania, because you know, so it's difficult for me to say that, but I was exactly involved in making reports on Albania, on the vetting procedure on behalf of the Venice Commission, but also in many opinions on Ukraine. Because, as you said, it was not only one draft, not only one proposal on vetting in Ukraine, because there were changes, powers, changes, authorities, and always the Venice Commission start to make an opinion of the vetting procedure, how to make it, who should be included. So it was exactly a very strong discussion between Venice Commission, because we had many drafts. In Ukraine, it was such a situation that sometimes we received 3 drafts. In the meantime, one was just adopted by the Verkhovna Rada. And in the meantime, before we ending our opinion, it was changed, yes, but new amendment added. So for that reason, it was such a chaos. I don't use the word chaos in the legislative procedure, that it involved exactly the role of Venice Commission very, very strong to be engaged in making, finding the solution. Finally, I think that we agreed to some solutions common for Ukraine, and which was also accepted by the Venice Commission. But then it is only, as we know, Venice Commission are only opinion, not the binding opinion, and then the implementation should be done by Ukrainians. And it probably is not realized in the best way, but not only in Ukraine, but also in other countries. And here, you know, it is also another problem, because in the beginning, when we discuss, because we use the different terms, as you know, decommunization, illustrations, vettings, etc., etc. In the beginning, when we discuss on the vetting and illustrations, we would like only to make a cut with the communist past. But then it has changed. And now what we call vetting and we call illustration, it is much more connected with corruption. Because exactly now we have in all the countries corruption. You know, I also can give you one anecdote, but I don't mention the country. It was not Ukraine, it was not Albania, but it was another country. When we, as members of the Venice Commission, tried to create such an independent body to make a vetting procedure. And we propose to create such a body where 3 judges will be and some other persons. And somebody from locals said to me, do you think that you find 3 uncorrupted judges in our country. So it's the answer just 10, 11 years ago. Yes, not now. Maybe now it's better. I don't know, or maybe worse. So, but for that reason, I also do answer exactly. We had a lot of discussion, but I can say that probably with any of the, with all the drafts coming from Ukraine, we had many discussions, but finally we are able to find a solution. And then the new proposals have been done, and new request for opinion has been sent from Ukrainian authorities. And I said once that with the Venice Commission will have the work to the end of his life with Ukrainian. Yes, exactly, because we still have the new drafts, which are just in sequence for the draft law just adopted. Yes, so this is exactly a problem. Yes, it is exactly. But now the draft is still on the vetting procedure and should be realized, but it's not in a good way realized. But we also take it into account when we analyze the candidature to the Constitutional Court. Yes, we also try to verify if the candidate was verified and went the positive way the vetting procedure. Yeah, so.
Thank you for sharing this. There was a beautiful conference 1 month ago at the Bocconi University in Milan on the Venice Commission and on the anniversary, and a lot of very interesting information also was given there, and in particular also the increase in the opinions, in the increase in the activity. It's a dialogical activity as on the checklist. Exactly, yeah. And there are even urgent opinions of the Venice Commission, which exactly reply to the or react to the phenomenon which you mentioned, that there is the new draft law and then the revised new draft law. And of course, if I were a government, I would continue to throw out new drafts that keep the Venice Commission busy and to confuse things. But no, but this is a very, very important development also, and also regarding what we said before, to how to say, to respect the diversity of solutions, while on the same time insisting on some common principles. You need a dialogue and you need to understand also the other. And in this sense, the Venice Commission certainly is central, and is also, this is a personal opinion, sometimes a bit used by the European Commission in order to have a greater leverage also, no? Which is part of that game. And maybe this brings us to the question with EU membership and backsliding. Tanya, if you want to say something, and Christina, if you want to add something on what you said yesterday also.
Just a very quick remark, because I mentioned the membership or the future possibility to be a member of the European Union twice. The first time it was about the dangers, I would say, then is the European Union influencing in a negative way the democratic erosion or backsliding, is contributing. And this paper I mentioned emphasizes the growing role of the government, of the executive power, and the disempowerment of the parliaments and of the people, I would say, as an element weakening the constitutional democracy. Then this was the first mention. Second mention was on the opposite side. It was about the fact that there is this network of institutions in the European region, I would say within the European Union, of course, but in the within the Council of Europe as Venice Commission. Then from one hand, we can discuss whether there is a negative influence of the membership of the European Union. And on the other hand, there is some evidence, at least, that this network is working, strengthening constitutional democracy in the European region. much more than in other parts of the world. Recently, Marta Cartabia published in Verfassung blog, if I'm right, a short post emphasizing this difference between what is going on in Mexico and Israel, and examining whether within the European context it would work in a different way.
So in a way, a kind of antidote to the sovereignists, as they call themselves, to keep in. But we also have this spillover through these networks and the dialogue through these networks.
Yeah, then there are the two sides to be explored.
Thank you. Christina?
Thanks, Jens. Yes, definitely I should probably in my future contribution provide an overview of the various instruments before zooming, if this is the case, on spending conditions. I decided to focus on spending conditions for the sake of the presentation because I thought that could be the easier standard of comparison with the other case studies to assess, I mean, how the EU is dealing with that and how the EU and the other Western Balkans, Georgia, Moldova, are using or benefiting of these spending conditions. You mentioned the report of the European Court of Auditors, so maybe this is not very effective. I can also go in other direction. Maybe it will be useful for the sake of the special issue also to understand a little bit where the consistency or the coherence of the various contribution can be strengthened, and I'm very open on going in different direction. I can also, as in terms of title of the session in the panel in which I was involved, there is a reference to rule of law methodology. I can also elaborate more on what we mean by rule of law in the EU, because I think there are many elements that, especially since 2018, have been clarified. So it's true we do have a lot of resistance, but there are also common elements that the Court of Justice is constantly repeating. So I can further elaborate on that, on what do we mean by judicial independence and so on and so forth. Thanks.
Thank you very much. Also, in particular, for reminding everybody in the room that there will be, at least there is a plan for a publication, and you will be very soon invited. You will be invited soon, but the publication is due not very soon, which should tranquilize you. But also because we need to let that sink in. But many of us are here because they are already working on these issues, so it should not even be too much of a problem. And the idea is, as I said yesterday, this review of Central and Eastern European law, which is then also probably an important publication venue for having interested readers in these issues. And thank you also for your readiness to maybe shift a bit the focus, but maybe also not, because I think this financial issue in particular for the EU is in a way also indicative of also linked to what we have said before with regarding corruption issues. And so I think there can be things created. I look around if there's anybody who wants to add something. I would have a short question. This is not very nice, but to Pietro Faraguna, because you were the only one, as far as I remember, mentioning the involvement in the electoral issues yesterday. So just also to maybe to clarify also for our purpose of comprehensively illustrating the rule of law issue, connecting with what Christina just said, also for the publication, how important is this issue for, if you could clarify a bit your emphasis on this issue, because I think this was the only time it was deliberately mentioned, if I'm not mistaken.
Yes, I will take it maybe from the Romanian case, which was not like widely mentioned here. But I think at the first sight, that was a case that was somehow discomforting, even like Western European lawyers, let's say, in the sense that, or probably from the perspective of Italian public lawyers, that was quite a lot as a as an intervention. But then, I mean, by scrolling the text of the Romanian constitution, it appears quite clear that there is a straightforward competence in double-checking the integrity of the electoral process. And so if this is the case, I mean, the whole event assume a completely different dimension. And I think that, I mean, while we are looking at these developments, I mean, it is quite impressive the fact that in the Italian constitutional tradition, there is a very soft, there are very soft powers of the Constitutional Court and of ordinary courts in checking the electoral process, while, of course, when we assess the rule of law, this is a crucial topic. And so probably, I mean, in assessing that, I mean, the first comparative test we should do is, first of all, to double check what is the jurisdiction, what are the jurisdictions of ordinary and constitutional courts in the given legal system. Otherwise, it doesn't make any sense.
Thank you so much. So I would close the discussion if I don't see any urgent, no, not urgent, okay. Then I would leave the floor to Roberto Tognatti, who I don't think I need to introduce, because probably most of us are here because we know Roberto and we know about Roberto's work. And to those who do not, but I really don't believe that there is anyone, Roberto is a professor emeritus in constitutional law and comparative constitutional law here at the law faculty, and an incredible great scholar who usually is able to summarize things which many of us would not be able to summarize. And please, Roberto, come. And so I have tasked him, I have invited him, and he accepted to summarize and to give his own reading of what we have discussed these 2.5 days. And I asked him how much time he would need to do this. And it was a very Solomonic answer, but I would say 30 minutes is an adequate time span for our long and very diverse discussions touching very different fields. And so I'm very happy that Roberto has accepted this Herculean task, and we'll start now to introduce, and afterwards there is the speakers' lunch, and there will hopefully enough time, because it's really next to our law faculty building, that also those who have the train at 1:45 will at least have some possibility to eat something. Thank you. Roberto.
Well, thank you very much, Jens, for your kind words of presentation. And of course, thanks to you, as well as to the other colleagues, for the invitation to attend the conference. I have to say that this has been a very rich conference. I think that all of us learned a lot and have gained, I would say, insight into areas that perhaps we didn't consider earlier. One of such items, for instance, might be the topic of a next conference, very difficult, but I think worthwhile, a conference on comparative code of judicial conduct. It came out that this is an issue which recurred quite frequently, and I would say that at least constitutional lawyers, not only in Italy, are not considering this topic very much. And at the end of the day, we found out that it is quite decisive. So this is perhaps one of the first contributions that I can give as a final conclusion. But don't be happy, it's not over, in the sense that I still have something to say. Although the only reason for not being grateful to Jens for his presentation is that you raised expectations too much, And of course, this means that I will disappoint you very much, but this is what happens in life. A word of praise and appreciation for the concept that inspired the thematic organization of the meeting and of the three panels. The first on rule of law methodology, which I think is a very fine expression. And then two focuses on constitutional courts and on judicial councils. I have to say that the third panel today inspired me very much because it was able to go through or beyond the judicial councils themselves and deal with the judiciary and the judicial function at large, which otherwise might have been a sort of missing link between the second and the third panel. And it is important, I would say, because I would consider the judiciary as the routine backbone of implementation of the rule of law. This is what happens daily. This is what happens everywhere at all levels of jurisdiction. Of course, constitutional courts are important, but they are up there. Judicial councils are important, but they are up there. But what really matters is what courts do, what judges, individual judges do. So it is important always to bear this in mind. Let me also have a look with you to the title of the conference, which has been recalled by Jens just a few minutes ago, Rule of Law, Resilience and Conditionality Inside and Outside the EU. Now, this is absolutely crucial. In spite of the distinction, I would say there are two common assumptions on rule of law, resilience and conditionality outside and inside the EU. Now, with regard to the outside of the EU, the assumption is that rule of law, resilience and conditionality refer to the perspective of membership in the EU. And this is important, and I shall explain why, whereas the perspective inside the EU reveals the assumption that the process of supranational integration is aimed at achieving an ever closer union. And what is the link between the two perspectives? I would say is Article 49. Now, sometimes we take for granted, we know Article 49, but we should read it again and again. And for instance, I had forgotten an important part of Article 49. The text says, any European state which respects the values referred to in Article 2 and is committed to promoting them may apply for membership. The commitment to promoting the values of Article 2 of the treaty is as important as having already accomplished or achieved this target. So I would say that between the outside and inside the EU, there is a structural and permanent obligation of member states to pursue those values and implement their duties accordingly. Okay, so this is just to praise again the title, which means much more than perhaps one might read at first sight. Then I would like to deal for a while on conditionality and the framework of conditionality. And I would like to say that manifestations of different forms of pressure and political conditioning on constitution making from outside are not unusual. The constitutional power is normally described by constitutional theory as the authentic sovereign power without any limits. But this is not the case. And I would certainly, for instance, refer to the zeitgeist as a quite compelling element of pressure on constitutional lawmaking. Would be difficult out of time and space. Of course, space is also a very important variable. to write a constitution which does not get any inspiration from other constitutions in the area. So pressure from outside is there, not only as a consequence of military defeat. Now, of course, we have the cases of Italy, Germany, and Japan. But let me deal now with Italy for a while. I say this because there is a sort of national pride which always likes to distinguish the Italian case from the German case. Now, the peace treaty in Italy contained Article 15, which made it necessary for Italy to establish a system which would respect fundamental rights and the principle of equality and no discrimination. Now, does it have to do anything with the racist legislation of 1938? Well, I would say yes. And in fact, we find Article 3 in the Italian Constitution, which reflects Article 15 of the peace treaty. And also, with regard on the reconstitution of the fascist party, there is a specific provision in the peace treaty which says that the fascist party shall not be organized again. And this is reflected in the 12th, if I remember correctly, provision of final provision of the Constitution. A third element, protection of minorities, of national minorities. Although the Constitution speaks of language minorities, we know that the European terminology now speaks of national minorities. But we have an annex to the peace treaty, which is the Gasperi-Gruber Agreement, which regulates the role, the status of the German-speaking minority in Italy. So this is again an example of international pressure on the constituent power of the Italian Republic. And personally, I'm proud of this. I'm not ashamed. I don't see it as a deprivation of national sovereignty. I see it as a sign of attention of the international community on what was going on in Italy and the capacity of Italy to respond to such expectations. Of course, different elaborations might apply to Germany and Japan. But as I said, this pressure from outside is not only a consequence of military defeat, but in many cases is also based on a voluntary perspective subordination to those very forms of pressure and political conditioning. Voluntary. For instance, the Constitution of Portugal of 1976, the Constitution of Spain 1978, they both have a provision whereby the interpretation of fundamental rights in their own constitution must be in conformity with rules of international law, in particular the Universal Declaration of Human Rights. And then also the European clause in many constitutions of Central and Eastern Europe, of Southeastern Europe, and some countries, including Italy, have introduced the European clause only in the year 2001, although Italy has been one of the founding members of the European communities. Now, the European clause, in my opinion, is not only related to EU membership, but is an explicit choice of what Italians call forma di Stato, or the, we shall say, political and institutional regime, namely a regime of constitutional democracy. And this has been well said by Tania Groppi yesterday. Now, let me give you the example of a republic which is normally regarded as, and not only regarded, is very, very proud and with a very nationalistic approach, the Republic of Serbia. Now, in Article 1, it says the Republic of Serbia, blah, 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 based on the rule of law and social justice and commitment to European principles and values. Now, this is not strictly related to membership, because Serbians knew that their membership was not a matter of days. So I would say the European clause is a link between sovereign constitution making, and the expression of a constitutional will to establish a state based on constitutional democracy and eventually achieve EU membership. But EU membership comes at a later stage. Constitutional democracy comes first, in my opinion. So I read this in the European clause. And of course, this is consistent with the frame of conditionality that I'm dealing with. Now, with regard to this, let me also quote an author, Matthias Kuhn. Grazie. Who developed the idea of cosmopolitan constitutionalism, which may be considered as representative of the current, what I call best evolution of the world constitutional phenomenon. Matthias Kuhn describes it as the new and growing general concept of cosmopolitan constitutionalism that results from a revised understanding of constitutionalism that is both cosmopolitan and post-positivist, whereby sovereign states and positive law retain an important role, but have to fulfill their role as part of a cosmopolitan and post-positivist conception of constitutionalism. One more quotation from Kuhn. According to the interpretation of current constitutionalism offered by the vision of cosmopolitan constitutionalism, constituent power is vested not only in we the people, but also in the international community. The constitutional legitimacy of national law depends in part on being adequately integrated into an appropriately structured international legal system. And the legitimacy of the international legal system depends in part on states having an adequate constitutional structure. So we the people, but also the consistency with the zeitgeist as expressed by the international community. So conditionality, this is the point where I want to get. Conditionality and the European clause are, in my opinion, to be regarded as instrumental to establishing a European cosmopolitan constitutionalism, not a worldwide cosmopolitan constitutionalism. And the conditionality is consistent with the qualification of member states of the Council of Europe that are described in the preamble as like-minded states. Now, I have always been impressed by this expression of like-minded states. Like-mindedness of member states is a precondition for establishing a political union. I switch here from the Council of Europe to the European Union, but this is the context. Like-mindedness of member states is a challenge, an authentic test for developments to come. And I'd like to make it clear that the conception of the European Union as an ever closer political union, on the one hand, is quite well far away from the other conception of the European Union as a confederation of nations, or even as not more than a common or a single market, as ideologies of sovereignty are trying to establish. Now, the Prime Minister of the Italian government expressly speaks of the development of the European Union as a desirable development, as a confederation of sovereign nations. Now, on the contrary, I would like to stress the fact that like-mindedness is not same-mindedness. In other words, the purpose of supranational integration of an ever closer union is not to achieve uniformity, but mutual compatibility, or at least non-incompatibility. And this is very important, I would say, because Here we have to look for drawing the line between tolerance, as Constance has reminded we should do, but also as having common standards, as Hannah suggested that we should have. Of course, at some stage you have to decide. Now, perhaps we have to take into account the fact that the European Union perhaps has been very shy in establishing common standards, non-incompatible. We have had a lot of opting out, even from the Charter of Fundamental Rights, although the opting out, for instance, of Poland and the United Kingdom has been regarded as legally without effect. Perhaps the European Union has been even too flexible. Now, let us compare for the moment how three different aggregate entities have regulated the issue of uniformity of fundamental rights. Now, in the United States, that have the advantage of being clear-cut, but the disadvantage of being tough. Article 6, the supremacy clause. Federal law is above all other laws of the states. The Canadian Charter, Article 33, the notwithstanding clause. The same fundamental right, except when the provincial governments suspend those provisions, those federal provisions, for 5 years, and that may be renewed for other 5 years, which is, of course, less tough than Article 6 of the United States Constitution. And then let's see the third aggregation, the European Union, which is even softer because, as we know from Article 51 of the Charter of Fundamental Rights, the provisions of the Charter are addressed to the member states only when they are implementing union law, which is even softer. So we have three different models of how to regulate uniformity or diversity in the enjoyment of fundamental rights. Now, I have to say that I do appreciate very much the European way, which is a soft way. But still, considering what is going on in our days, I wonder if it has been too tolerant, too flexible, too open to diversities. In particular, if we consider that ideological consistency marks a difference between an international organization and the political community. There are international organizations with common aims and purposes, like the Association of Southeast Asian Nations, which include countries which have a very, very different and even opposite political regime, from the monarchy of Thailand to the communism of Vietnam. But certainly, I would say that the European Union aims at something more. This scenario, I repeat, of non-incompatibility, which is the minimum, or compatibility, but certainly not uniformity, this scenario also contributes, in my understanding, to explaining and supporting the use of the comparative method by courts. Now we have an expert like Tanya in this field. She published a very important book recently, but the topic is there, and it is an issue. The use of comparative method, not to decide the case through foreign law, but to find plausibly a similar rule in one's own legal system. There is a very important decision, which I always teach to my students now in Innsbruck, which is the Spanish Constitutional Tribunal decision on same-sex marriage. This, I would say, is an incredible, clear example of judicial decision-making within the scenario which I have indicated here. And from this point of view, in particular, the use of the comparative method by court, I would recommend Perhaps Hannah could do something in this regard. She's a powerful person. There is a need to ensure translation of main judicial decisions. And we read from Costa's paper that Albania does not translate any of it. Now, I would say that the Council of Europe or the Venice Commission should assist technically and possibly also financially courts of the area to have their decisions translated in order to make possible and feasible the role of scholarship in monitoring the developments of judicial decision making. I'm not talking of any political control, but I'm talking of scholars' critical monitoring. And this is important because circulation of models is a cultural phenomenon which is out of political control, which happens because of its own strength. But it does need to have some tools, and translations of decision is one of such tools. So for ending this part of my presentation, and I think I still have almost 10 minutes, don't I? Almost. Okay. I would like to say something about the consequences of the current ideological polarization on the framework of conditionality, which I have described so far. Now, conditionality and its framework are affected by the dynamics of the complex phenomenon that is normally referred to as democratic backsliding, democratic regression, development of illiberal democracies, and the like. A dramatic and effective way of describing the present political context is by the expression culture war, which I make my own. I think there is a culture war. And I think that it is correct to identify in the aggression to constitutional democracy one way of expression of the culture war, and in particular, the attacks against the judiciary, against the judicial function, on the selection of judges, and against constitutional justice per se. I think that if we take some examples like Hungary, Poland, and Israel, we find clear examples of what I have said. And I'm afraid that the reform of the Italian judiciary in Italy is following this kind of example. And I should take, for instance, out of all this country, a context of intimidation against the free exercise of the judicial function. I have forgotten in my bag, but that's not a problem because I don't have time. But I would like to point out to your attention the letter of intimidation that a number of executives, all members of the European Union, have addressed to whom? To the Council of Europe, to the European Court of Human Rights, to the public opinion, insisting that they are, and I'm talking of Denmark and Italy that have promoted the initiative, but much to my regret, I should mention also the federal government of Austria, the Baltic republics, and others, I think 9 governments altogether. They claim to be truly respectful of the rule of law, but they claim that the case law of the European Court of Human Rights make it impossible for them to perform policies against illegal migration that the majority of citizens want. They don't quote any case. There's no reference to case law. There's no reference to examples. It's just that the case law makes it impossible to perform democratic policies against illegal migration. Now, this is intimidation. And this is a clear example of a threat to the rule of law. And I think Tanya, who mentioned this letter already yesterday. So in my opinion, what is needed is to set up forms of institutional resistance. I call it institutional resistance because it should take place through the exercise of the physiological functions, and in particular, non-differential attitudes and interpretations. I hate to mention myself, but this is the title of an article which I wrote on commenting some judicial decision-making during the first Trump administration. Non-differential attitudes and interpretation. I think that we should encourage that very much. Now, this may sound a sort of militant attitude, incompatible with the scientific dealing with the issues, but I think that this kind, many of you have said, I'm going to make a passionate intervention. Well, also my intervention is passionate, but I think that it is consistent with a scientific method. I have 3 more points, but I insist on one in particular, on the rule of law. Because we have been talking of the rule of law, of course, because we have been talking in English. But have we taken another language, like French, German, or Italian, we would have talked of l'état de droit, Rechtsstaat, and even the report of the Venice Commission, of the Venice Commission, have both references. In the English version, it is rule of law. In the French one, it is l'état de droit. And this, mind you, is something that the comparative method must try to impose on scientific narratives. Because in the common law and its evolution, I would suggest, and this is a suggestion and not a statement, but I would suggest that the rule of law has become and is now synonymous of constitutional democracy. But in continental Europe, if we talk of Stato di diritto, état de droit, and the like, we need more definitions. We need to enrich the expression with more meanings. We need to include a number of features that altogether sum up in the notion of constitutional democracy. Now, I think it was Christina that yesterday mentioned Article 2 of the regulation on the general regime of conditionality. Allow me to read it to make clear my point. For the purpose of this regulation, while I will say much further, the following definitions apply. The rule of law refers to the union value enshrined in Article 2. Now, the rule of law refers to values. This is already quite original. It includes the principle of legality, implying a transparent, accountable, democratic, and pluralistic lawmaking process. Legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection, including access to justice by independent and impartial courts, also as regards fundamental rights, separation of powers, and non-discrimination and equality before the law. Now, a lot of things. Whereas when we talk of English, we just say the rule of law and everybody understands everything. So this is important. Why? Because of the consequence of the observation by Constance Greway again yesterday, that the rule of law is mainly the outcome of legal culture. And legal culture is intimately related to the legal family of the legal system, so that we have a common law, a civil law, and a socialist law legal system, and consequently different understanding of the rule of law. Legal culture also provides the opportunity for developing different methods of interpretation. Let's take originalism in the United States, which only exists in the United States, although of course also in Britain, interpretation is quite textual. The lawmaker in Britain knows that judges would be too free unless they were very accurate and detailed in legislation. Let me say, we're all adults here. If you read anti-sodomy legislation in some American states, you read a treatise on sex, because the accuracy of description of what penetration means is such that would be unheard of in any civil law country. We have literal interpretation, we have purposive interpretation. Now, let us always remember the European Court of Human Rights when it says the convention is a living instrument that must be interpreted in the light of present-day conditions. So this is the task of the judiciary. And schools of training for magistrates and updating and refreshing and whatever it is must be up to this, which I think is an expectations by citizens as well as delivery by political as well judicial institutions. In other words, the culture of the rule of law must be present at all levels of society as well as at all institutional levels. Now, let me just quote a very short personal experience. I was once invited by the Economics University in Moscow to take part to a conference on the judiciary. And the colleague who invited me insisted, Roberto, you must be very aggressive because our judges don't interpret the law. They follow, as Constance said, the socialist legal theory. And so I gave a paper which I thought was very aggressive. If anybody cares, I'll be glad to share this paper, which has been translated into Russian. I don't know how it was translated because I don't know Russian. What I know is that at the end of my delivery of the paper, any question, any comments, any reaction, complete silence. Nobody was shaken by my aggressive presentation. So this is why we need to invest very much in this direction. Of course, there is a factor of time when we talk of the Western Balkans. I wonder if we didn't expect too much in too little period of time. Considering also that constitutional transitions are an almost typical feature also in Western Europe, or at least in Southern Western Europe, plus Germany. And perhaps there's maybe another hint, the need for some diachronic research between West and East, according to some benchmarks, on how long we had to wait in order to achieve some results. Let me give you an example. In Italy, we have data, which I don't recall personally right now, concerning the fact that when the Constitutional Court was established, it was younger judges at the lowest level, Praetori at the time, that raised petitions to the Constitutional Court to challenge the constitutionality of legislation. And the Court of Cassation, I'm sorry for our colleague here, the Court of Cassation came much later than the Praetori. Why? I suppose because the members of the Court of Cassation had their training during fascism and certainly before the Republican Constitution, and they did not have the sensitivity to achieve that particular result of contesting, of doubting about the validity of legislation. So perhaps some research in this direction might also be valuable, considering also some episodes. For instance, the president of the Italian tribunal for the purity of the race, of the Italian race, became the first president of the Italian Constitutional Court. I wonder if this, who said something is dirty? Huh? Constance said, what is dirtier, what is less, more, less dirty? I would say this is dirty. But anyway, so as I said, the topic is very rich. The suggestions that I received have been very many. I'll just say one thing about the appointment of judges, in particular, those judges that are appointed by the political power, which is, of course, different from the recruitment of judges. I'm talking of members of constitutional court, of the international court, of the supranational court. I think that we should prefer the appointment of mainstream jurists, not of jurists that belong to the extremes of the current polarization. Because if polarization penetrates the courts, then I'm afraid that we should forget whatever I said about European cosmopolitan constitutionalism. And perhaps we don't need too much transparency in this process, if I may. Thank you very much for your attention.
Thank you very much, Roberto. Definitely no disappointment. Maybe a disappointment only in comparing the first part with the second part. In particular, your very, very efficient call for resisting against intimidation. I think this was very striking, and in the way also the integration, the synthesis of constitutional democracy as a concept, which is now more and more a synonym for the rule of law, in particular because of the excesses in emphasizing the democratic principle, where we need a balance between the two. Thank you so much for this task which you accomplished very, very well, and giving us additional thought. And we will leave you over summer, and after summer, this is the threat, we will come back with a call for preparing this publication. Thank you, all of you, for coming here, which is not the norm anymore, because we are more and more used to connect, and we may need to get used also to smaller numbers, and maybe also think of organizing this next time as a big round table where we can maybe interact even more directly. But thank you for coming here, despite also these extreme weather conditions. Thanks all who have supported and participated the administrative stuff. Again, Anna Giacomoni, with whom you have been in contact, Julia, who was circulating here with the microphone, and also thank you to my two colleagues, Halina Dovan and Simone Penaza. We have thought of all this together and have prepared this together. Now, I would like to ask you to hurry up and go to the just 80 meters here from the law faculty. Simone will take the lead and bring us here that everybody gets some bites. Thank you very much, and have a good day and a good afternoon.